Representative McGrath, do you have a pink card? You can grab one here.
Oh, I didn't even know there were. I love your like a shower caddy. Well, they never did shower
Thank you.
No, 1670.
Yes.
I'm so nervous. And today is
It's a little shower caddy.
Yeah, there's no need to be. We don't bite here.
Caitlin, I was just told that I am no longer allowed to have the roll call judiciary. Only the clerk can.
Yeah.
If she were talking about.
Yeah, that's the official sheet. That's why.
Yeah, Paul Smith called me yesterday and said, like, that's the official roll call.
Yeah, thank you.
I need my own thing if you want to use it.
What?
Yeah, this sheet, he said it's the official roll call sheet, and he said, we're, like, we don't sign the sheet, so he said, I don't want other pages of it laying around and then it getting confused with the official record.
Margie.
Yeah, I'll make my own.
Okay.
But I gave her like a template, so she made a sheet for herself and has a bunch of bills. Do you want copies of that one?
I just give you one, you can see, you can do your
That would
own
be
if you like
great.
it better, but.
That'd be great, thank you.
I know this is all for our own edification.
This is what I did based on Caitlin's.
Yeah, that's
mock-up,
great.
So like the original number in here.
Yeah,
right
yeah,
down here.
okay. Thank you very
I
much.
can send you the link, the document if you want me to, like, so you can print it
Okay.
home too or whatever.
Okay, thank you.
Yeah.
Just waiting for the chairman. He'll be here shortly. When then we'll open.
So it's now a little after 9:35, so I'm going to open the proceedings of the Judiciary Committee, but I'm also going to immediately, after we do the Pledge of Allegiance, I'm going to immediately recess so that our colleagues can conclude their caucus. So with that, Chair recognizes Representative Perez to lead us in the Pledge of Allegiance. With that, we'll recess for about 5 minutes. Thank you. I'm going to call the Judiciary Committee back to order, and I apologize for the delay, but you know, there on both sides of the aisle here, there are things that just need to be worked out. So we're ready to begin. I'm going to open the hearing on House Bill 1671 FN, and I would recognize Representative Linda McGrath. Representative McGrath.
Thank you, Mr. Chair, and thank you, members of the committee. I'm Representative Linda McGrath, representing Rockingham District 40, Hampton, Seabrook. And I'm here to introduce HB 1671, an act relative to prohibiting state Medicaid payments to facilities that discriminate against employees, students, or trainees for exercising their lawful medical or religious vaccine exemptions. I'm the pharmacist that was fired by Walmart for using my professional judgment, refusing to inject children with an experimental vaccine that I knew caused myocarditis, which it turns out is most prevalent in teenage boys. And the reason I tell you that is because this is exactly why I ran for state rep, to try to protect everybody's medical freedom and civil rights. And this bill does just that. So at its core, this bill is about three things: civil rights, workforce stability, and responsible use of taxpayer dollars. Civil rights. First, HB 1671 does not create new rights. The rights protected here already exist under federal law. The right under the Americans with Disabilities Act requires reasonable accommodation for legitimate medical conditions, including medical contraindications to vaccination. Another right under Title VII of the Civil Rights Act requires reasonable accommodation for sincerely held religious beliefs. What this bill does is align state Medicaid funding policy with those existing protections. It ensures that facilities receiving Medicaid dollars do not discriminate against employees, students, or trainees who are lawfully exercising those rights. A second thing this bill does is responds to very real healthcare workforce problems. New Hampshire, like the rest of the country, is facing critical shortages of nurses, technicians, and other healthcare professionals. During the COVID era, the Centers for Medicare and Medicaid Services mandated the COVID shot for participation in federal health program. We saw many qualified workers and students excluded from employment or clinical training, not because they were unsafe or unqualified, but because they were denied their legal, medical, and religious exemptions. I'm sure you remember the slogan of those who worked with the sick and infected during the pandemic, but were then fired for refusing a vaccination. We went from heroes to zeros. Senator Tim Lang, in an article in the New Hampshire Bulletin in 2021, while pushing HB 220, stated he knows 18 nursing students who had withdrawn from their programs, unable to complete required rotations, some just months before graduation. In these cases, their schools honored their exemptions, but the rotation sites refused. These were individuals who were already invested, that we were already invested and educated, and whom our healthcare system desperately needs. In recent testimony, last week, I believe, in Health and Human Services, public hearing on HB 1179, which was to establish minimum nurse staffing standards for nursing homes, a director of one of our county nursing homes testified that there are no registered nurses. There are no registered nurses to hire. So when a facility refuses lawful exemptions, the cost is not abstract. It means fewer providers, fewer clinical placements, longer wait times, and reduced access to care for patients. The third piece of this bill is about responsible stewardship of Medicaid funds. Medicaid is a public program funded by taxpayers. This bill simply says that state Medicaid dollars should not be used to support facilities that engage in discriminatory practices prohibited under federal civil rights law. Regarding the fiscal note, I spoke with the legislative budget officer who confirmed that this bill does not authorize any new funding or positions. The fiscal note is based on assumptions, he said, made by the Department of HHS. Those assumptions appear to presume that a significant number of facilities would violate this law. My position is that enforcement costs would be minimal. If Medicaid participating facilities are clearly informed of their obligations under the law, compliance should follow. There should be no need for an additional compliance officer. Facilities understand what is at stake. No provider is going to risk losing eligibility to Medicaid reimbursement by knowingly engaging in unlawful discrimination. They did this exact same thing when the tables were turned the other way, firing much needed staff due to mandates rather than risk the financial loss. I contacted a couple of dozen teaching facilities, nursing, EMT, pharmacy. Great Bay Community College of Nursing indicated that there are some vaccines that have no exemptions. Colby Sawyer Nursing School replied, all of our students are aware of required vaccines for clinical. So how many young people don't even apply for these educational opportunities, knowing that they won't be able to have their vaccine exemptions honored? This bill is not intended to be punitive. The goal is simple: to ensure that lawful medical and religious vaccine exemptions are always respected, that overreaching government mandates do not happen again, and that state Medicaid dollars are not used to support discriminatory practices. This bill sends an important message. New Hampshire supports patient access, respects civil rights, and values the healthcare professionals who serve our communities. HB 1671 protects workers, students, and taxpayers while helping ensure our healthcare system remains staffed, ethical, and accessible. And I respectfully ask for the committee's consideration and support. I passed out 2 papers. One lists just some of the education jobs that need rotations and maybe wouldn't be able to get them unless this passes. And the other one, you people are probably way more familiar about federal versus state laws, but apparently the state has authority over vaccine exemptions in Medicaid. And so this outlines those. And if I can, I'll answer any questions.
Questions for this witness? So I guess I have a question. I want to make sure that I'm understanding. Am I understanding correctly that when the bill says no healthcare provider shall discharge, threaten, or otherwise discriminate against an employee, student, or trainee regarding the terms, conditions, or privilege of employment, because the employee, student, or trainee has executed a valid medical or religious vaccine exemption, am I understanding correctly that that is an exemption, meaning that the employee does not want to get some vaccine.
Yes, so one of the impetuses for this legislation is that students especially are getting through their education, but are not being able to get their clinical rotations because those facilities are the ones that are not honoring their exemptions.
Right, so what I want to make sure I'm understanding is this bill, to use your situation as an example, this bill would not allow you to say you can't, um, you employer, cannot, are facing, some, negative consequences from Medicaid.
Mhm.
Um, not because I don't want to take I as an employee don't want to take the vaccine, but I don't want to give the vaccine to somebody who comes into the pharmacy. If
So
Walmart,
I
let
gave,
me
I'm
just
sorry, go
make
ahead.
sure just to make my
Yeah.
question clear. Let's assume that Walmart, in your example, said, we want to give the COVID vaccine or whatever vaccine to anybody that, comes in with a doctor's order saying, give the vaccine. This bill would not allow, this bill might, if it were passed, might allow you to say, Walmart can't discriminate against me because I don't want to take the vaccine. But if Walmart's position is any patient that comes in should get the vaccine, you would still have to give the vaccine to that patient.
That is actually an excellent question. I never put those two together. I gave my testimony as the reason why I brought the bill because I want to make sure that the government overreach never happens. But I was more focused on the employees and the students rather than the employee. I think that as far as employee and employer relationships, I don't think it would apply there because that's like a private contract. But I would have to check with a lawyer as far as the reading of this, whether that would apply to that situation. I'm not sure.
Okay, I mean, I think that's kind of because I guess I see a very significant difference. One thing to say, Walmart shouldn't be able, Walmart at the expense of perhaps losing Medicaid, shouldn't be able to tell you as a pharmacist, you have to get the vaccine. That's one level, that's one thing.
Mhm.
If this bill were meant to say, you as an employee of Walmart could say, I don't think that the vaccines are a good idea, and therefore I shouldn't have to give the vaccine to anybody that comes in. That's a far broader proposition, I think.
Totally understand your question. It's an excellent question. I don't really know whether to tell you offhand because I hadn't considered that scenario.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Representative Lucy Weber. Yep, it's fine.
Question of the chair. So the first the representative, she handed out some written testimony, was not labeled as to who did it or why. And whereas this one, she has her name on it, so we know exactly like who it is who's submitting it. So I don't know what we should do. What's her? I don't know. Are people required to label the written testimony to submit so they know like who submitted it, or is it any?
I don't think. I mean, I don't think we've. If that is a requirement, I don't think that I'm aware of it. And I mean, we all know. I don't think there's any confusion that the first handout was by Representative McGrath, and this one is by Representative Weber.
We haven't gotten
We haven't got.
gotten the address.
Yeah, just send it around. We can label it ourselves.
Yeah. All right, Representative Weber. Thank you.
With apologies, Mr. Chair, I think the problem is that people haven't received
Okay.
Representative McGrath's testimony.
Please proceed.
Thank you so much, Mr. Chairman and members of the committee. My name is Lucy Weber. I represent Cheshire 2, which is Walpole and Surrey over on the Connecticut River. And it's good to be back in Judiciary, where I started out in the late Stone Age. So here's the thing. I fully understand about the issue of religious concerns, religious exemptions, and the constitutional protection, therefore. What I am very concerned about is the effect of those religious exemptions on a population that is medically frail and very much at risk for infection and other things. So facilities have a duty towards the people they are treating to either keep them safe or at least not inflict more harm on them.
So, you know, I don't mean, but can I just ask, because I think this is, I want to make sure that you're interpreting the bill, if I'm understanding correctly, and kind of in the way that I was, that it doesn't just mean that the employee doesn't have to take the vaccine, but it means that the employee, if they have a religious objection, doesn't have to give it to anybody else.
No, sir, I'm not saying that at all. What I'm saying is that if you have an unvaccinated employee in your county nursing home, where the patients are by definition frail and medically needy because they wouldn't be in the county nursing home otherwise, even having an employee who is not vaccinated serving that population, and I'm starting a little before this bill occurs, so that'll become clearer as I go through. I am concerned initially that simply asserting one's right not to be vaccinated and then choosing to be employed in a county nursing home puts all of those people resident in the county nursing home at greater risk than they would have been otherwise. And so that ship is not one we're probably addressing today because it's a matter of law already. But I don't think that it is fair or wise to come up with a scheme that imposes greater risk on other people so that an individual may assert their religious preferences. So that's my beginning, but that's probably already there. So to go on, here's the next thing. First of all, the facilities are in a terrible bind because on the one hand, particularly when we're talking about nursing homes, but any medical facility, they are under a duty to their patients to keep their patients safe and not to do more harm to the patient than the patient came in with originally. And as one who contracted COVID when I visited a friend at Mary Hitchcock Memorial Hospital, you know, there's a lot of disease going around. So the problem is that if you put this kind of a penalty on the facility, not only are you putting the residents at greater risk, but if the facility says, you know, because of your religious exemption, we can't have you working with the most vulnerable patients or whatever they say, if they are found to have discriminated and their Medicaid funding is withheld for services they have already rendered, and the Medicaid funding is not there going forward for that facility, which is what this bill says, you are going to lose an entire facility. Think about what that means for your county nursing home, where many of the patients are on Medicaid, and a Medicaid reimbursement loss will actually push any teetering facility into financial insolvency. So my question is, what is going to happen to the patients resident at that nursing home? Many of whom are on Medicaid, many of whom are not. If the nursing home isn't available, the patients still need care. How are we going to care for them? And there are really only two options. I mean, either the nursing home, if it's the county nursing home, or even if it's people on Medicaid who are not in the county nursing home, either the facility shuts down and we have to find new places for all of those people. Or guess who has to pick up the other half of the Medicaid payments? You know, the county taxpayers? Well, apparently not, because they're not going to get Medicaid at all. So there's going to be one whole population where until they find another residence, they're not going to get care at all. So I think that the consequences down the road of withholding the Medicaid funds are out of all proportion to the issue that this bill is trying to address. And the people who are going to bear the brunt of it in either way is anybody who is medically fragile and dependent on Medicaid, and some people who are medically fragile and not dependent on Medicaid. And I am authorized to say, because we're all trying to be in several places at the same time, that Representatives LaMontagne, Woods, Palmer, Tellez, Hartnett, and Lucas join me in my opposition to this bill. And I thank you very much, and I would take any questions from the committee.
Thank you. Questions for this witness? Yes, Representative Scully.
Thank you, Mr. Chair, and good to see you. Thank you for coming before us. I understand that you're voicing a concern here. Are you aware of any studies that have demonstrated that unvaccinated healthcare workers posed a major risk to any population, including the people they were working with?
That's not research I have done, but it's not research I have done. I will just leave it at that.
Thank you.
Thank you. Other questions for this witness? Seeing none, thank you very much.
No, you've got.
I'm sorry, Representative Tripp. I'm sorry.
Thank you, Mr. Chair. Thank you for taking my question. You assume that there are only positive benefits to being vaccinated. The sponsor for this bill clearly stated that there were negative positive consequences for taking the vaccination. Do you have any thoughts on that?
My thoughts, as the child of a polio survivor, are that vaccination has been the best public health advance in all times. And I want you to remind you that we are not just speaking about COVID here. And I understand that people are concerned about the way the COVID vaccine was rolled out and had concerns about that. I don't think that the ongoing research is bearing out the concerns that they had. And there are, well, I won't go there, but the other thing that this would ban is the polio vaccine. My father walked with a limp for his entire life, but he didn't have to live the rest of his life in an iron lung. Measles. 500 or so kids died every year of measles prior to 1963 when the measles vaccine came in. Those are the deaths, not the ones who were permanently deaf or the ones who had ongoing issues of many sorts because of the measles infection itself. Chicken pox, whooping cough, all the childhood vaccines that have been given since the 1950s and 60s, which have turned out to be exceedingly safe. And people don't remember, my generation is just on the cusp of remembering what it was like not to have vaccinations and the terror that came with it. I got vaccinated when I was about 5 or 6. I remember it well. I didn't step my foot in a public pool until I went to college when I was 18 because my parents were so frightened of polio. The terror that came with that, the people who with measles spent months in dark rooms, lost their hearing, had all kinds of complications going forward, immunocompromised from the disease, not from the vaccine. And I think that it is very unwise to depart from something that has been unbelievably well documented as a good for society. I will also just say that I heard downstairs when there was a bill about repealing childhood vaccines entirely, that even without a mandate in vaccine, 98% of the population is vaccinated. So I don't know why there is that much support in Japan and so little support here, but that isn't something I can deal with. I am concerned about the effects of this on a fragile population, and that in punishing a facility, you are also punishing all the people who attend that facility and all the people who need to be on Medicaid for their health care. I don't see why they should be punished.
Other questions? Representative Tur.
Yeah, thanks, and thanks for taking the question. This bill is under the public health law, makes a change, but the effect of the bill largely dictates Medicaid payments. I'm wondering if it's appropriate to basically dictate Medicaid payment policy through a public health section of the law when Medicaid hasn't implemented, as far as I know, this type of a restriction on their payment.
Thank you for the question. I think it's an excellent question. And I have done no research on how that would play, given that their policies control in this area, despite the fact that we pay a certain percentage of it with state dollars.
Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
All right. Next, I'm going to call on Melissa Blazer. And you know what? I note by the time that we're significantly behind. Part of that is our own fault, but nonetheless, I'm going to ask people if you please limit your remarks to 3 minutes.
Thank you. Yes, thank you, Mr. Chair, members of the committee. I'm Melissa Blaznik. I'm here representing Rebuild NH. I just want to, your question earlier, I do not believe that the bill applies to whether somebody could, as an employee, give a patient a vaccine. This is their own personal exemption for what happens to their body, but I certainly would be open to clarifying language on that. Also, just ironically, based on the previous testimony, in my experience having dealt with a lot of people, a lot of students looking to get clinical rotations, the county nursing homes were actually one of the few places that they could do clinical rotations with religious and medical exemptions. So I'm here just to kind of highlight that there is an issue with students. I have a couple of testimonies here that I would like to share from students. They were very nervous to come and expose themselves publicly. They didn't want their full names out publicly, but Priscilla had a couple of comments. So she said, I had a dream of being a registered nurse, proud of the difference I would make. It was a dream that I was making a reality. I started my nursing career path in 2018 and was on track to receive my nursing degree in spring of 2022. Unfortunately, my plans did not unfold that way. So essentially, she had completed all the vaccination requirements necessary to work with patients in clinical rotation except for the COVID vaccine. The hospital I was originally going to do clinical rotations at would not accept my religious exemption for students regarding the COVID-19 vaccine. I was told exemptions would only apply to staff, but students were considered a liability. My own remark is that that is a recurring theme, is that the employees in most of these facilities can have religious exemptions, but not the students. So ultimately, she did have to quit the program, and she said, I have nursing school debt without the profession. And then another student, this is the daughter of Scott. In April of 2025, the student was accepted at NHTI. She paid her deposit, filled out her paperwork in August. From the beginning, she was transparent about having medical vaccine exemptions. And at the program's in-person open house on August 18th, the student met with her instructor specifically to confirm that her exemptions were known and that she would be placed at a clinical site that recognized them. The instructor admitted that she had not reviewed the student's submissions, but said she would, quote, do her best. The next day, the student received an email stating that there were no exemptions and that there was no, quote, workaround. Within 24 hours, the instructor followed up, instructing this student to withdraw from the program. The student refused to voluntarily withdraw. And on the first day of class, the instructor demanded one-on-one meetings during the student's lunch break. The student called her mother in to help explain the basis for the exemptions. The instructor was forceful and unequivocal. No exemptions would be honored, and the student had to leave the program. Despite repeated requests, the instructor refused to explore clinical sites that recognize the exemptions.
Your 3-minute time is.
Sure. So ultimately what ended up happening with the student was that they went around the school and did find a site for her to do the clinical rotations. And that does happen, but occasionally, but I can count dozens more people I know who simply could never find a site. So that is my testimony.
Thank you. Questions for this witness? Seeing none, thank you very
Thank
much. Next, I'm going to Robert Barry, please.
Good afternoon, Mr. Chair, members of the committee. My name is Rob Barry. I'm General Counsel to the Division of Medicaid. I asked for 5. I'll try to keep it at 3, but I do have some very important things to inform of the committee. We are just here to provide information, but we do have some strong concerns about this bill. Prior to my role as General Counsel to the Division of Medicaid, I did serve as General Counsel to HR at the Department of Health and Human Services, so I do have some extensive experience in investigating employment matters as well. And that helped inform my penning, I guess, of the fiscal note worksheet and my experiences with how investigations of this nature would go down. So to start off, we think it's questionable whether CMS would actually authorize suspensions of Medicaid payments under these circumstances. Typically, suspensions are based on matters of provider fraud or when a provider has lost their license to provide services that are, the covered services. So we're not quite sure would be able to actually be put into effect. But we haven't been able to run that down with CMS, but that's at the moment where we stand with that. But as a practical matter, the bill is very light on process in terms of the legal process involved in this investigating these complaints. So typically, when you investigate a complaint, there's a legal standard to apply. This bill does not have a legal standard. Does the department apply a preponderance of the evidence? Does it apply probable cause, clear and convincing? We don't know. There's also no rulemaking authority. There's no other standard into it. So the department has no guidance as to how it would decide whether discrimination has occurred in these circumstances. So that would need to be fleshed out for it to actually determine what occurred. Also, there's no indication as to how a provider would even earn their Medicaid payments back. It just says it would be suspended indefinitely. Well, there would need to be some sort of ability for a provider to earn their reinstatement into the Medicaid payment process if there was such a thing as a suspension for this. They would have appeal rights as well. We could not just suspend without some sort of legal process. It would either have to go through the AAU, which is our Administrative Appeals Unit, or we'd have to go through a court process, depending on how it would work. And I also want to point out the practicality of investigating these complaints. When we...
Can I ask you to just finish up as quickly as possible?
I will, that this is very, very important. So when we investigate fraud complaints, we have paper trails or a lack thereof, right? We investigate claims, and if we have the right, if we have claim paper trails, they indicate that someone's billing properly, or if we don't have the paperwork, we know they're not billing properly. When you're investigating employment matters, it's testimony, it's interviewing people. You are assessing the credibility of people. So it becomes a he said, she said investigation, and it's going to leave the department with trying to wade through very difficult relationships that may go back 10, 20, 30 years, involving difficult personalities and issues like that. And I do also read this bill too, that if somebody requests a vaccine exemption, they're granted it without issue, and then suddenly they are disciplined for some issue, then they may, if they're upset about it, claim it that they were discriminated against. And now it's the time for the department to walk in and decide whether that discipline was warranted or not. So we're going to be getting involved in some very, thorny issues involving employer-employee relationships. So this bill is mixing civil rights law with Medicaid law. Thank you.
All right, thank you. Questions for this witness? Seeing none, thank you very much, sir. Next, Mary Holland? Mary? I think it's Mary. Mary Holland? Or is it from, boy, somewhere from New York? Cardmont, maybe? Ridge, New York? Nope, all right, don't see that person here. 36 Joyce Drive. Nope, all right, thank you. We'll go on to the next one. Terrence Hanlon, please.
My name is Terrence Hanlon. I'm an internist, internal medicine board certified. I've been practicing in New Hampshire since 2001. I just want to make the point to the committee that prior to COVID-19, this was not an issue. And people got medical exemptions or religious exemptions without any pushback from the hospitals or from New Hampshire Medical Society. But during COVID-19, I saw how people who got legitimate exemptions were treated, and they were persecuted. And it was a very difficult time. And when you're a physician, you have to make an individual decision for patients. You need to make the best choice for them. You should not be coerced into making a decision based on what your company thinks. So I just wanted to say that there was something different that happened during COVID, and it needs to be addressed. It was not an issue before COVID, but something has changed. And I just wanted to make that statement here, that we do something about not discriminating against people who have legitimate religious exemptions, because it does affect how you make decisions as far as your patient care goes. So I just want to say that. I'll keep it short.
No, thank you.
Take any questions if you have questions.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
I don't have any other pink cards. Is there anyone else who wishes to be heard on? What?
Thank you, Mr. Chairman. I don't have prepared testimony. I just wanted to respond to a couple points. Sorry.
Okay. Okay. Yeah. Just keep it within the 3 minutes.
Sure. My name's Ben Bradley. I represent the New Hampshire Hospital Association, which includes all 26 of the acute care hospitals in the state and all specialty hospitals. Just going over my notes, I wanted to address a couple of things. The points about students. We have been in touch with the community college system, the university system, and other educational facilities to ensure they understand what the expectations are of our facilities when it comes to vaccination. Back during COVID, there was an expectation that students and staff of a hospital would need to be vaccinated, and that was mandated by the CDC, the federal agency. Now, hospitals do not mandate the COVID-19 vaccine and do make accommodations for folks who have religious and medical exemptions. They may have to wear a mask in patient-facing areas or other measures to help prevent the transmission or try to prevent the transmission. And so we want to make sure that the community college system and the university system and the other educational institutions understand what those expectations are, because I think that there may be a miscommunication to some of their students at times about what that looks like. And so, as was pointed out, I think there was an ability for a student to work in a facility that was able to provide accommodations and work directly with that facility so they understood what the expectations were. But I just wanted to clarify that for folks so you understand what we do now. We are concerned about this bill and are opposed for the reasons stated by others who are opposed to this bill. Happy to take
Thank
questions.
you, sir. Question, Representative Perez.
Thank you. Thanks for taking my question. So if you don't require the COVID vaccine, the hospital doesn't, but yet if a student doesn't get it, you're making them wear a mask or work in or do their training in a area that would have been different. Isn't that a form of discrimination against that student for not getting the vaccine?
So I think the application of masking is universal across students and hospital staff. I think that the communication that may be coming from the educational institution may be different than what the employer has instituted. And so our commitment is to go back and make sure that there's very clear communication between those educational facilities and what the expectations are of those placements, where they're going, the facilities for those placements. And so as far as discrimination, that's another question, is what's outlined in the bill, what constitutes discrimination? Does it mean that you can't require somebody to wear a mask if they're not vaccinated? Does it mean that you can't require a person who's not vaccinated to take precautions when they're around patients to ensure we're providing the safest place for care and getting those patients better?
Other questions? Seeing none, thank you very much, sir.
Thanks, Mr. Chairman.
I'm sorry, did I see somebody else? Yes. Did you put in a? Okay.
Oh, we called you and you
Oh, okay. I'm sorry.
weren't here.
Yeah, we called you and you weren't here. Okay. All right. Yes, please come on up. Yeah, just ask you confine your remarks to 3 minutes. Thank you. I'm sorry, tell us who you
Sorry.
are.
Yes, Mary Holland, president of Children's Health Defense, an organization devoted to ending the chronic disease epidemic among children. And we were very active during COVID related to all of the mandates affecting employers and employees and students around the country. And I can tell you that, as I think others have acknowledged, that the medical and the religious exemption process was corrupted. It didn't work. It was largely a sham in hospitals, in the military, and particularly and universities. It didn't work. There was not a way that the universities or the employers, including cities and states, achieved reasonable accommodations for people seeking religious and medical exemptions. And I do think that what is being proposed here aligns New Hampshire with federal law, including the Restoration of Religious Freedom Act. I do think that what we've done does especially affect the trainees. It affects the nursing students who, in the middle of their education, were told they would have to get COVID shots or flu shots, for that matter, in order to continue their training. And so what's literally happened is we've been excluding qualified candidates from the military and from healthcare professions, medical school and from nursing school, because of people who have legitimate medical reasons or legitimate religious reasons. And so I do believe that it's very important to This doesn't really create new law at all, and it does address the shortage of healthcare professionals, also the shortage of qualified people going into the military. It's a related issue. I don't think that this is really breaking new ground. It's just bringing state law into alignment so what happened during COVID doesn't happen again.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
All right. Anyone else who wishes to testify regarding HB 1671? Seeing none, I'm going to close the hearing on HB 1671, and I'm going to open the hearing on CACR 23 relative to legislative oversight of the judicial branch and establishing legislative oversight. And I would, oh yes, I recognize Representative DeRoy.
Good morning, everyone. My name is Susan DeRoy, and I represent New Durham and Middleton, New Hampshire. Today, I want to talk about CACR. I was here just a few days ago talking about another immunity bill, but I think this one's just as important as the last one. New Hampshire has always stood for something simple and powerful: live free or die. Live free or die. That means no branch of government gets a free pass. No unchecked power, no exemptions. Our founders built a system of checks and balances so that people, through their elected representatives, keep every part of the government accountable. We're not accountable. Yet today, one branch, the judiciary, lacks the routine oversight that others have. We already have impeachment in our Constitution. The House can charge judges for misconduct like bribery, corruption, and maladministration, and the Senate can remove them. But impeachment is a nuclear option, rare, extreme, and has only been used twice in our history for the Supreme Court justices, Langdon in 1790 and Brock in 2000. Why are we seeing such an outcry from our citizens, especially when it comes to family court? Parents testify year after year. Fathers alienated from their children by false allegations, mothers dismissed when raising abuse concerns, children coached to reject a loving parent. In recent hearings on bills like HB 1323, we heard heartbreaking stories. One father in court since 2009. Evidence was ignored. Others losing contact due to weaponized claims, alienation, or abuse. The House Family, Children and Family Court Committee hears these cries, debates reform like mediation, first approaches in HB 652, or criminal penalties for custody violations in HB 194. But progress stalls. Nothing happens. The bills get recommitted for more study, partisan split, bold change, and the judiciary's self-policing leaves complaints unaddressed. The result, a system that prolongs conflict, drains families financially and emotionally, and harms the very children it's supposed to protect, making injustice more prolific, not less. It isn't just inefficiency. It's failure of checks and balances. So what's missing? The legislature, our branch closest to the people, debates and holds hearings, but lacks the tools to investigate judges when patterns of maladministration or bias emerge in family cases. Currently, most complaints go to the Judicial Conduct Committee, run by the Supreme Court itself. Too often, serious concerns get dismissed quietly and handled internally, leaving Granite Staters feeling unheard and the process opaque. Recent controversies remind us when trust erodes, we need stronger tools, not more of the same. That's why CACR 23 matters. This amendment gives the general court explicit power to investigate judges when warranted, formalizing a check that exists in spirit but not in practice. It would let the legislature establish a commission principally comprised of members of the general court, our elected representatives, to handle complaints, hold hearings, gather evidence, and recommend discipline or impeachment. We can design it right. Bipartisan legislatures in the majority for accountability to voters, plus public members and ethic experts for balance and expertise. No one branch dominates. I'll give you a couple of examples of states that are doing this right now. That I have several of them in my testimony, but I'll just do two. In Pennsylvania, a legislative investigation uncovered ethical misconduct by the Supreme Court Justice Ralph Larson in the 1990s. The House impeached, the Senate convicted, and removed him. Public trust rebounded, reforms followed, no chaos, just cleaner courts. In West Virginia in 2018, legislators probed lavish spending and conflicts on the Supreme Court. Hearings led to impeachments, resignations, major ethic changes. The system emerged stronger, with citizens seeing real accountability. These examples prove that legislatures can unwind the mess when empowered. Investigations build evidence, impeachment threats prompt resignations or reforms, and outcomes lead to cleaner processes, such as ethics, safety mandates, and custody. In New Hampshire, where family court complaints often go unanswered, under current self-policing, CACR 23 would provide similar tools. A legislator met commission for probes targeting patterns in family cases, bias, ignored evidence, GAL issues, and without politicizing routine decisions. Opponents say this threatens the judicial independence, but true independence thrives with accountability. Judges and magistrates wield life-changing power over families, businesses, and freedoms. No one should be above scrutiny, especially when complaints go unanswered. CACR 23 bridges that gap modestly, honoring our live free or die tradition. Government serves the people, not the other way around. So let's stand together today for transparency, for a judiciary where our citizens can trust it. I note that my bill might need a little revision, and that would be setting up the panel. And I would propose a 9-member panel, 3 members of the legislature by the Speaker, 2 members by the Senate President, 3 members of the public by the Governor, and 1 member of the bar. Also, I'd like to just make mention that last time when I was here, I was saying that I understood that our Chief Justice said that the system was broken. And then apparently somebody said that that was not true. That's not what was said. Well, let me go back to 2021. Our Chief Justice McDonald reviews access to justice as the state's most pressing legal problem. More than 90% of the litigants in some of our trial courts may be self-represented on matters involving issues of great importance. Their safety, security, housing, health care, and access to government benefits, he says.
So, Representative, my recollection is that the witness who clarified what you said exactly that the Chief Justice, when he said the system was broken, was talking about it in the context of access to justice and not enough people having lawyers, which is exactly what you seem to be saying.
Well, yes, and he's saying that there is this gap, and that closing access to the justice gap is immensely important, and he was committed to closing it. Well, that was in 2021. We haven't closed anything yet. Thank you.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Lauren Warner, please.
Good morning, honorable committee members. My name is Lauren Warner. I am the Deputy General Counsel of the Judicial Branch. I just wanted to note on CACR 23, as just discussed by the sponsor, it gives the general court power to establish a commission to investigate complaints against members of the judicial branch, conduct hearing, gathers evidence, and recommend disciplinary actions, including censure, suspension, and removal. Currently, complaints regarding judicial conduct are sent to the Judicial Conduct Committee, also referred to as the JCC. This committee is made up of 11 members, 6 of which are public members that are not a judge or an attorney and cannot be any way associated to the courts. The JCC has the power to investigate complaints of judicial misconduct, impose and recommend discipline, and when necessary, work with the legislature to secure suspension or removal of a judge. Also work with the Supreme Court. The legislature, I would like to note, the legislature currently has the ability to investigate judicial misconduct, and if it feels warranted, seek impeachment or other removal from office under Articles 17 and 73 of the New Hampshire Constitution. And so essentially looking at what this bill is seeking to do, what is it seeking to do that isn't already currently in a process? The JCC reviews and investigates complaints. If anything is found warranted, has issued discipline or has recommended further action. I know there's been remarks made to current events. In those current events, investigations were conducted, discipline if found warranted was issued, as well as that in any of those cases, the general court still had the power to investigate if they wanted to and to move further under Article 1773 of New Hampshire Constitution. So essentially, this bill is seeking to address something that's already currently in process. So I would like to know what concerns regarding the current process aren't being addressed. What is the JCC currently not doing that it should be doing? Are there complaints and allegations that the JCC isn't investigating complaints? Certainly, these would be things the judicial branch would want to be made aware of and could seek to address, as opposed to potentially additional legislation that is ultimately creating a parallel process that already exists currently today. And just some points of further clarification looking at the bill. The commission would be recommending disciplinary action. Who would they be recommending it to? Would it be the Supreme Court? If it's the legislature doesn't have the authority under the New Hampshire Constitution, nor I would argue it would violate the separation of powers of recommending discipline. Anything only that's limited to impeachment and removal from office. It requires the commission to publish an annual report on judicial performance. What would the factors be used to evaluate judicial performance? Are they looking at the current judicial performance process we have in place now? It's unclear to me what this entails. Also, the complaint process. How are complaints being brought to the commission? Currently, all complaints are required to be brought to the JCC. What is this parallel process? Are complaints now going to be required to be brought to two different places? How is this going to be handled? There's just some open-ended questions regarding this bill. And recommending discipline, ultimately, I already noted, who would that be going to and who would be doing the discipline? It's unclear and potentially could violate the separation of powers depending on who's doing the discipline. I welcome any questions the committee might have.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Liz Tentarelli, please.
Thank you for this opportunity to speak. My name is Liz Tentarelli. I'm president of the Nonpartisan League of Women Voters of New Hampshire. The League's mission is to empower voters, but also to defend democracy. Nothing like having a modest mission. It is in that spirit that I am here today with concerns about upsetting a valued part of our democracy, which is the balance of power. So if the legislative branch has the power to investigate and impose penalties on the judiciary, does the judiciary have the same power over the legislature? I don't know the answer to that. I know you have an internal ethics committee process, and I know that impeachment is possible of the legislature over the judiciary, but over yourselves as well. I'm concerned because we have a whole spate of constitutional amendments, and some of the sponsorship overlaps that seem to be raising the power of the legislature above the other branches. And that's my concern. More specifically to this bill,
the composition of the commission isn't in the text, and I appreciate that the sponsor just said it would have 3 House members, 3 Senate, and 3 members of the public. But is it bipartisan? Or will we have a partisan oversight commission over the judiciary? And that can't be good. So I'm raising questions more than establishing testimony here, but it is very much a concern of mine, and that's why I'm here today. I'll answer questions if there are any. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much, ma'am. Next, I'm going to call on Dana Albrecht, please.
Thank you, Mr. Chair. Good morning, Dana Albrecht. Was a little confused at the prior testimony. I think we might be conflating CACR 23 with House Bill 1322. They are certainly similar topically, but I believe we're on the constitutional amendment now.
That's what we're on, CACR 23.
Okay. To that end, I've passed out 2 handouts. Those were also sent out by email this morning. They're much more comprehensive than my oral testimony, but they serve as a sort of foundation for a lot of the topics today. To address the last witness first, the Supreme Court certainly has power over the legislature. They can declare no laws duly passed by the legislature and signed into law by the governor null and void. Is a concrete example of that. Just look at Senate Bill 197 from 2001 and how that was passed by a vote of 290 to 36 in the House, and 3 years later, and passed into law, and 3 years later, the Supreme Court simply said, sorry, we don't like it. Petition of the Judicial Conduct Committee 151 NH 123 2004. To that end, let me sort of switch gears into why I believe this amendment is necessary. What we have today is nothing less than a judicial crisis that echoes, quite frankly, the judicial crisis of 2000. In 2000, we had Stephen Thayer's contentious divorce that triggered a memorandum from the clerk of the Supreme Court. Now we have Chief Justice McDonald's highly contested divorce. But that's not really the point. We've had the recent events with Chief Justice McDonald and Justice Marconi, who have given directly conflicting accounts in sworn testimony on what happened with Justice Marconi's meeting with Governor Sununu. So either Justice Marconi lied under oath and committed perjury when she said the Chief Justice said it was okay for her to meet with the governor, or the Chief Justice is an accomplice to the crime she was convicted of committing. Which is it? We have no way of knowing how. What is the legislature's power to address that? In addition to that, this has been all over the news. We have the $50,000 payout to Diane Martin, orchestrated by the chief. We have an all-staff meeting convened by Justice Patrick Donovan to deal with that. We have Judge Mark Howard, who's the chief of the Superior Court. And according to the whistleblower, Justice Howard told her, you need to get rid of that effing memorandum of understanding. Yeah, get rid of it. It's none of their effing business what we do over here at the judicial branch. They're into our business. They have access to our information. Get rid of it. That's not accountability. According to the whistleblower, Judge Keating, who's now state court administrator, made clear that these orders were coming from the chief. It's not my idea, it's coming from the chief. Susan Galinas, and if I mispronounce that, forgive me, when she reported her concerns to the Division of Personnel Director Matthew Mavrogorj, and forgive my pronunciation there too, he didn't do much. What's the remedy here? We have conflicting testimony between Mavrogorj and Judge Keating. Judge Keating stated he never spoke with Mavrogorj, and Mavrogorj showed investigators something with us different. These accounts can't both be true. Who's lying? What's the remedy to investigate this? The Judicial Conduct Committee doesn't do it. They're under the direct authority of the Supreme Court. You know, that's having the fox guard the henhouse. And this was echoed back in 2001 when this body created the Judicial Conduct Commission. Back then, they said the real remedy was a constitutional amendment. And that real remedy is here before you now. And so I would urge you to pass this.
All right.
Thank you.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Vivian Gerard. I hope I have that correct.
Thank you, members of the chair. Honestly, I came here today to give a package to another state rep that has asked me for some stuff. And this was definitely a topic of my case, unfortunately. And the more I kept hearing about this, and I didn't know that if I was even going to speak today or not, but after hearing Representative DeRoy's testimony about affecting this whole bill, affecting people like me, our housing, our financial stability, our family safety. My case, I am, so if people don't know who I am the Silva v. Silva case that has gotten a lot of publicity here in the state. I had a very high contentious divorce where a lot of the situations that have come up in my case, it allowed constant harassment, a lot of unethical comments from several judges, marital master, and whatnot. And conveniently, I actually have my JCC complaint here, which was very interesting because my divorce was in 2016, and the two judges were taken off the bench since then. And I was in the court system for quite some time, went to the Supreme Court 4 times. And even after got remanded back to the lower courts, they said that they had no jurisdiction over the prior case. They did say that they wanted the lower court to make a decision and fix the remand, not to try the case, but they tried the case anyways. And they never fixed the original reason why I went in there. So the remand was never addressed. And they just said that they had no jurisdiction over the previous judge's ruling. So going back to Dana Albrecht's situation is we are having a judicial crisis of 2000. And part of my JCC complaint, I'd like to read to you a very small portion of this. So again, I was separated in 2014. My divorce was official in actually 2 dates, one in 2016. And then because the Supreme Court case, they pushed it out to 2018. But because I complained of these judges, they both, again, got disbarred. And on my JCC document, that was sent to me April 19th, 2022. And again, my divorce was 2016. So you can see how this did not help me. The JCC said that pretty much that they heard all the comments, they heard everything that happened. And in review of this report, not only has it caused the committee to review various portions
of the court's record in this case entitled, and again, in the matter of Vivian Silva, Gerard, and Robert Silva, and it also has a case number. But this also caused the committee to review a prior of reports involving Master Delbra filed between 2000 and 2021. The committee found that 14 reports filed during that time, 8 raised similar demeanant issues. So this is clear that it has been seen by the JCC, it has been recognized by the courts, and way after my case, there's no way to get remedy of something like this. So this is real problems. It affects homes, it affects relationships, it alienates the children. There's a lot of things that people are not seeing in the real world. And I know that everybody keeps seeing it, we keep talking about it, but nothing is actually getting done. And even when I brought this back to the Supreme Court, to let them know that they said that they had no judicial jurisdiction over the previous judges, they wouldn't even take the case. They said, we've already ruled on that. So after 9 years of fighting this, and even after both judges got disbarred, my case still is in limbo. Nothing's been resolved. I come here to you today showing you that this is after the fact. And it just keeps repeating itself. History just keeps going on and on. So yes, there is a judicial crisis out there.
Questions for this witness? Seeing none, thank you very much, ma'am.
Thank you.
Donald Gilbert?
Good morning, Honorable Chairman Lynn and members of this committee. Based off that last testimony, I believe I do need to at least address something in the room that I believe could be a conflict. Respectfully, Chairman Lynn, you presided over that last testimony in the Supreme Court when you were in the Supreme Court. I do believe that there's some questions of impartiality within the potential conflicts there. Moving on from that, though, the New Hampshire Constitution designates the House of Representatives as the grand inquest of the state of New Hampshire. It invests its power into the impeachment of judicial officers. That responsibility is clear. What is less clear under our current structure is how the House is meant to responsibly exercise that power without any corresponding authority to investigate. At present, the House may impeach, but it has no standing mechanisms to gather facts, compelling testimony, review of records, or develop evidentiary record prior to deciding whether impeachment is even warranted. This creates a structural gap between the constitutional duty, the institutional capacity. Impeachment is an extraordinary remedy, and it should be rare, but rarity must also be the product of accountability and not paralysis. Without investigative authority, the House is forced to rely on outside actors to surface allegations of judicial misconduct, the executive branch, the judiciary itself, or the media. That is not how checks and balances work or are meant to function. A constitutional check that cannot be exercised independently, cautiously, or based on facts is not a meaningful check at all. CACR 23 does not expand the punishment of power of the legislator. It does permit the House to overrule. It does not permit the House to overrule judicial decisions, interfere with pending cases, or discipline judges for unpopular rulings. What it does is far more modest and far more necessity. It restores the missing predicate to impeachment, the ability to fact find. Judicial independence is preserved not by insulating the judiciary from all inquiry, but to ensure that any inquiry is deliberate, transparent, and constitutionally grounded. An investigatory mechanism protects judges as much as it protects the public, by preventing impeachment decisions being driven by rumor, politics, or incomplete information. If the House retains the power to impeach, but the lack of the ability to investigate, that power exists only in theory. CACR 23 aligns the authority with the responsibility and restores balance to a system that depends on each branch being able to perform its role competently and responsibly. For those reasons, this amendment strengthens, not weakens, our constitutional structure, and I urge this committee to advance it.
Thank you, sir. Questions for this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to be heard on CACR 23? Seeing none, I'm going to close the hearing on CACR 23 and open the hearing on CACR 27. I would first recognize Representative Robert Wary, please.
Thank you, Mr. Chair and honorable committee members. For the record, my name is Robert Wary. I have the privilege of representing Hillsborough District 13, the great town of Hudson. The purpose of this CACR is to correct an improper insertion made outside of the prescribed means for changing our New Hampshire Constitution. A constituent asked me to file this CACR, and I'm trying to honor that request as best as possible. It is my understanding that in Part 2, Article 4, the parenthetical insertion that is bolded below in my written testimony was made after the amendment to include Article 72A. For reference, Article 4 and Article 72A are listed below. I believe you actually heard last week CACR 20, I believe, on a similar matter. So the main issue my constituent has with this parenthetical insertion is that there was no amendment put to the voters to change Article 4. The insertion apparently was made independent of any voter review and approval. At that time, the Constitution addressed different aspects of amending the Constitution. Articles 98, when to take effect, 99, a convention that was eventually repealed in 1980, and 100, amending by General Court or Constitutional Convention. None of these proper mechanisms were followed in order to make this change. So in addition to the failure to follow the constitutional requirements for changing the Constitution, there are two other problems I see with this action. First, Article 72A is predicated on Article 4. If anything, the first constitutional amendment that should have been put before the voters is whether Article 4 should be amended to allow for the creation of Supreme and Superior Courts. Now, I'm not against those courts, and I'm certainly not here to debate the merits of those courts, not at all. But on behalf of my constituent, I want all the constitutional amendments to be done constitutionally within the established processes. If an exception needed to be inserted into Article 4, then that should have been addressed first, and then the addition of 72A should have been addressed. As it was done, it was a proverbial cart before the horse. Second, I'd like to raise an issue that I think voters might have questioned had an amendment been proposed first for Article 4. In simple terms, I think they would have asked, what's forever for? Prior to the amendment, Article 4 read, I have it there, I won't bother to read that, but I would highlight the words forever and full power and authority. The framers of our second Constitution said, the general court shall forever have full power and authority. Does that parenthetical insertion for Article 72 now weaken this forever full power? I don't know. Perhaps. It certainly moves these courts further away from we the people. To better appreciate the potential problem, let me offer a hypothetical situation. Suppose that out of some imaginary trust fund, I was able to offer the members of this committee $1,000 a day forever. Not a bribe,
just because you're a great committee and you're doing a wonderful job. And through one of the good lawyers on this committee, we put this arrangement into a contract. But before I signed the contract, I made the parenthetical insertion, except for days ending in Y. That would have caused great disappointment for this committee. I'm sorry about that. The concept of forever in this hypothetical has now been irrevocably altered. And the parenthetical insertion in my hypothetical corrupted the original intent of forever. I think it did that in Article 4 as well. So in conclusion, the problem my constituent has is raised three issues. The first issue is that the amendment process required by the Constitution was not followed. Second, Article 4 is foundational to 72A, and an amendment to Article 4 should first have been addressed before the addition of Article 72A was proposed. Thirdly, the voters were not permitted to consider the revocation of the forever full power as it relates to the amendment of Article 4 and the addition of Article 72A. In order to correct this, my constituent has requested this CACR. Finally, I would note at the time the LSR for this CACR was submitted, this was well before the recent awareness of constitutional typos and the simple remedy to correct such typos. I don't know if this parenthetical insertion would qualify as a rather large typo. It seems beyond that scope, but if the committee believes that that approach or another approach would be more warranted or better, I'm very open to suggestions. Although this is now in your hands, I would recommend if you find a better pathway forward to correct this, please address it. So I urge you to support this CACR to enable New Hampshire voters to allow them for the first time to properly consider the amendment to Article 4. Thank you for your time, and I would be glad to try to answer any questions you may have.
Thank you. Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, call on Lauren Warner, please.
Good morning, honorable committee members. My name is Lauren Warner. I serve as Deputy General Counsel for the Judicial Branch. As noted by the sponsor, I wanted to be brief, only just wanted to note that essentially the language of CACR 27 is the exact same of CACR 20, which has the same effect. The committee heard and decided on this bill just last Wednesday of an ITL 16-2, just noting the actual effect of this bill would be to remove the Supreme and Superior Courts as constitutionally created courts if this were to move forward. Thank you. I welcome any questions you might have.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, Donald Gilbert, please.
Good morning again, Honorable Chairman Lynn and honorable members of this committee. Thank you for the opportunity to speak in support of CRC 27. This proposed constitutional amendment would amend Part 2, Article 4, by removing the exception referenced in Article 72A, thereby clarifying that the General Court holds the sole exclusive authority to establish courts in New Hampshire, eliminating any uncertainty about this fundamental legislative power. Our Constitution, adopted in 1784, reflects the framers' explicit commitment to legislative primacy as a safeguard of popular sovereignty. Part 2, Article 4 states that the supreme legislative power within the state is vested in the Senate and the House of Representatives. That broadly grant includes and has always included the authority to create, organize, and define jurisdiction of courts. This design flowed from revolutionary generations' rejection of the monarchical and judicial overreach, ensured that the people's elected representatives and not unelected bodies would control the structure of government. Historically, the General Court has exercised its authority consistently. creating the Superior Court of Judiciary in the 18th century, establishing the reforming courts throughout the 19th century, modernizing the Superior Court in 1901, and consolidating various trial courts into the modern circuit court framework. At each stage, it acted statutorily, affirming that court creation is and always has been a quintessential legislative function. In contrast, the Supreme Court's rulemaking authority under Part 273A is expressly limited to procedural and administrative rules for the courts, not creating courts or defining their existence. While the distinction has been generally understood in practice, the current constitutional language leaves room for misinterpretations, particularly regarding whether the administrative or specialized tribunals, i.e. the family court, might arise from judicial rather than legislative intuition. CACR 27 restores the clear constitutional allocation of power envisioned by the framers. The legislative creates courts and the judiciary administers them. This amendment does not diminish the judicial independence. Judges will continue to hold office during good behavior and decide cases free from legislative interferences. Instead, it preserves the balance of power and ensures that future changes in judicial structure, especially in sensitive areas involving the rights of private matter, remain responsible of the people's representatives, not the implied or assumed judicial authority. In the spirit of accountability, republic government, and in respect to our constitutional heritage, I urge the committee to recommend the passage of CACR 27. Thank you. Thank you.
Nope, you just turned the mic off. Hit it again. The red light's, there you go. Thank you.
Awesome. Thank you,
Thank you.
Honorable Lynn. Members of the committee, thank you for your time today. I'd like to address, I was here last week, I testified on CACR 20, and last week I brought to your attention that there's state Supreme Court precedent on this very matter. And so I cited Gerber v. King, and so this morning I'd like to reiterate what Gerber v. King had to say. The court emphasized that under Article 99 and 100 of the New Hampshire Constitution, voter approval of amendments must reflect a clear, informed expression of intent. The ballot question 8 was deemed misleading. So question 1 was 72A. So they've already struck down in Gerber v. King that question 8 was in fact misleading. To continue, citing precedents like Concrete Company versus Ryan Builders, in the opinion of the justices in 101-541, the court ruled that amendments cannot stand if the ballot fails to clearly convey the true effect, prioritizing voter understanding. This decision underscores the importance of transparent ballot language in constitutional referenda, ensuring that amendments reflect genuine voter will rather than hidden legislative purposes. And I would go on to say that this body, the legislature, would go on and pass statute 663, which is currently on the books today, to address this practice, which says quite clearly that the text of any proposed amendment must be in the voter's guide. In this case, it was not. And this is the underlying problem, that the voters had no idea what they were voting on. And how do you reconcile that? How do you ignore the precedent of the court itself? Because then the precedent has no value if we're going to simply go past decisions that have long-standing. This has never been struck down, and so it's a problem. So with that, take any questions you might have. I know separation of powers was raised last time I was here. Anyone have any questions on that? Separation of powers?
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
All right. Dana Albrecht?
Good morning again, Mr. Chair. I've passed out prior testimony on CACR 20 simply because this one is topically very similar, and so there's some direct relevance. That being said, the debate with both of these seems to be over which provisions of our Constitution are working versus which aren't. And so let me take a more positive note on the provision I think is working. I'm an originalist and I don't apologize for it. And Article 10 is working. What you're seeing here is a peaceful attempt by members of this body to address serious problems set forth before you in email, where the ends of government have been perverted, public liberty is manifestly endangered. In that case, the people may and of right ought to. You are seeing courageous representatives come before you doing that ought to. The question for this committee is who in this committee will exercise their duty on ought to if they believe the ends of government have been perverted and public liberty manifestly endangered. And the evidence for that is set forth fairly exhaustively in the emails that were sent out this morning. You have the full text of those printed before you, and you can refer to your inbox for all the electronic attachments. That seemed like a waste of paper. That being said, I think the original CACR 20 is superior to this version, but this version is good. So that's all I have to say.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Vivian Girard, please.
Hi, members of the committee. Again, as I had given you some of the insight from my previous testimony, but I feel that there are a lot of people that behind me would testify that here we are in a divorce situation where you have armed men coming into your house with guns, telling you how you and your children are going to live and what is to be expected. And going through a divorce, you are guilty until proven innocent. Again, I think that's against the constitutional rights. The Supreme Court, even if it goes to the Supreme Court 9 years later, the Supreme Court should be ordering a new order.
I guess I really want you to kind of tie your testimony to the bill that's before us. I'm not quite sure I'm understanding.
Well, I'm trying to get there.
Okay.
So I guess just here I am trying to explain to you, like the Supreme Court should be doing their jobs and not bringing it back to a biased judge. And even if the judges have been recused or asked to be recused, there's an imbalance of power here. And here we are supposedly having your rights through the Constitution, and your constitutional rights are violated through divorce. So as a member of the community and a victim myself, how does somebody like me get things done if we go to the court, we go to use this constitutional rights for our safety, for our security, and we can't go to somebody like a court and find that peace within our own home? So how do we get resolution on our life if we don't pass bills like this CACR 27 and protect our constitutional rights? So I'm in support of the bill, and I just want to tie this in everybody's everyday life going through divorce.
Thank you very much. Questions for this witness? Seeing none, thank you very much. Is there anyone else who wishes to be heard on CACR 27? Seeing none, I'm going to close the hearing on CACR 27 and open the hearing on CACR 29. And I would call again on Representative Ware, please.
All right. Thank you, Mr. Chair and honorable committee members. For the record, my name is Robert Ware. I have the privilege of representing Hillsborough District 13, the great town of Hudson. The purpose of this CACR is to correct a portion of Article 73A that is, at its core, repugnant to the Constitution itself under the multiple consideration for the separation of powers. As with the previous CACR presented to you, a constituent asked me to file this CACR. I'm not sure if that makes me courageous, by the way. I'm just trying to do my duty. But I'm trying to honor that request as best as possible. And this issue with Article 73A is its last sentence, and the CACR would remove that. For reference, the article is provided below. I won't read it, but the problematic sentence is bolded. The rules so promulgated shall have the force and effect of law. Now, of course, I don't think my constituent was trying to ascribe to the current Chief Justice, and certainly not to any former Chief Justices, tyrannical or maniacal use of the provisions of Article 73A. Previous testimony aside, I can't point to any personal knowledge of a specific abuse of this rules as law proviso. But the concept listed in Article 37 for the separation of powers suggests that this last sentence has crossed the line. Clearly, constitutionally, it's the bodies of the general court that are invested with the power to make laws. And constitutionally, there are controls and remedies on this power. The House and the Senate can exercise their powers to make law, but these can be checked by the governor's veto and controlled to some degree by interpretation through the courts. But for a rule as law made under 73A, there are no constitutional guardrails. There is no governor veto, and there is no independent Supreme Court to render an interpretation. There is impeachment, but again, as previous testimony today has said, that's really a rather drastic measure, and I don't think that's where we want to go. Because rules promulgated with the force and effect of law are inherently repugnant to the constitutional concept of separation in powers, and because there are no controls and guardrails for such rules, even if they may be well-intentioned and beneficial, this power must be removed through a constitutional amendment. On behalf of my constituent, and with what little courage I have, and for the due exercise of the constitutional concept of a definitive separation of powers, I urge you to support this CACR to amend Article 73A. Thank you for your time. I would be glad to try and answer any questions you may have.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you for no questions.
Liz Tattarelli, please. I'm sorry, Tentarelli. I apologize.
Thank you. I do not wish to speak at this point.
Thank you. Lauren Warner, please.
Again, good morning, honorable members of the committee. My name is Lauren Warner. I serve as Deputy General Counsel for the Judicial Branch. Just a few notes of some potential unintended consequences of CACR 29. If this were to be removed, it would in effect remove any guardrails on judicial and attorney conduct that exist within the Judicial Code of Conduct, as well as the attorney discipline rules that exist now and are created by the Supreme Court, and currently, due to 73A, have the full force and effect of law. Additionally, the rules of evidence, the rules of civil procedure would not arguably have to be enforced in courtrooms and could result in chaos, as you would see. The Judicial Conduct Committee ability to investigate complaints and issue disciplinary actions due to violations of the Judicial Code of Conduct, again, would arguably no longer be enforceable. These rules are made in place so that not only judges but attorneys' conduct is placed guardrails on and protections for the public, as well as the smooth operation of the courts having clear rules of evidence and civil procedure that help our judicial branch run smoothly. I would respectfully disagree with the sponsor that removal of this portion would potentially arguably violate the separation of powers, as Article 73A would essentially become null and void if you were to remove the full force and effect of law. The Supreme Court's ability then to make rules governing the process of courts and practice and procedure in the courts would no longer be enforceable or in effect if this were to pass. I welcome any questions the committee might have.
Questions to this witness? Yes, Representative Scully.
Thank you, Mr. Chair. So we all accept that the Supreme Court is a necessary check on the legislative branch in terms of trying to create something that is considered unconstitutional. If the Supreme Court is making its own laws, what check is there for an out-of-control Supreme Court?
So how I view this is the rules that are made specifically under 73A, the rules are limited to administration of the courts, practice and procedure to be followed within those courts. 73A does not expand beyond that. So the Supreme Court has no power to make rules that would have the full force and effect of law beyond that. And arguably under Article 37, separation of powers, the practice and running of courts are left to the judicial branch to determine. I would then also say that our state statutes are the legislature's general court's ability to have checks and balances on the judicial system. So, for example, a number of the bills that are before your committee this session that relate to judicial practice, performance evaluations, and the like serve as those checks on the judicial branch. But specifically, the rules that are made under 73A are related to court practice, so that judicial code of conduct, the conduct that judges have to follow, the attorney discipline rules, as well as just rules of evidence and civil procedure that need to be followed in courts. It's limited to that aspect.
Thank you.
Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. So as you stated, the courts can create rules which establish administrative and process. I believe that the legislature can do the same thing. My question is, which would have precedence?
I would then argue under the separation of powers doctrine and there will be a bill later this afternoon that kind of goes on to that, where the legislature has attempted to enact rules governing items that would fall under 73A as unconstitutional. So I would say 73A, as I view it and the judicial branch views it, is limited to the process that's handled within the courts, how a case is run, evidence that needs to be followed, the code of conduct that should be followed by judges as well as attorneys practicing with the New Hampshire bar as they fall under the Supreme Court rule, that this is limited specifically to that and only rules in there, and that the general court, through its power, has the ability to regulate other aspects outside of that specific administration of courts, practice, and procedure under how the Constitution currently sits.
Thank you.
Yes, Representative Page.
Thank you. I'm trying to make sense of this question. Is it possible that there are guardrails on the legislature may want more checks than it can get under the Constitution? Does that make sense, that while the legislature may have an appetite for more checks, 73A or other provisions prevent the legislature from?
I would say that's always possible, but there are other methods. I would say, which is a bill that's at the session, the judicial performance eval, that's under the general court's purview to decide what is involved in those evaluations and what needs to be reported, and that's a check.
Can I just ask a quick follow-up?
Of course.
But there are limits to that checks, just.
Oh, correct. As
Equals
each
the
branch of government
separation
has limits.
powers,
Yes,
right? Yeah, thanks.
correct.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Donald Gilbert, yeah, Mr. Gilbert, please.
Good morning again, Honorable Chairman Lynn and honorable members of this committee. I'd like to first follow up with response to some of the testimony that you just heard. The reality of it is if there was unconstitutionality in what you enacted, the judiciary does have the effect to go ahead and indicate that to you. They have the effect to go ahead and rule that statute unconstitutional for you to then readdress that. So I don't think that's an issue with what's being presented here today. Thank you for the opportunity to speak in support of CACR 29 at this public hearing today. This proposed constitutional amendment concurrent resolution would amend Part 273A of the New Hampshire Constitution by removing, the provision that grants the Supreme Court rules of force and effect of law, thereby restoring the general court's supreme legislative authority over the court procedures and administration of preservation of judicial independence in adjudication. As a concerned citizen dedicated to upholding our state's republic principles, I urge the passage of this message to address long understanding overreach and prevent further encroachments on the citizens' rights. New Hampshire's 1784 Constitution embodies the framers' vision of a government where legislative powers vested in the general court under Part 2, Article 4, serves as the primary bulwark against tyranny. The revolutionary generation, scarred by colonial experiences of unchecked executive and judicial authority under British rule, deliberately avoided granting the judiciary executing rulemaking powers. For nearly 2 centuries, the court procedures were governed by statute or common law, subject to legislative oversight, ensuring alignment with the people's will. This balance reflected in Part 2, Article 37, separation of powers, which allows interconnection among branches, but rejects anyone from being dominant. That's what we're seeing here today in our judiciary, is they are becoming a dominant force. The addition of 73A in 1978 marked a controversial departure from this framework. Adopted amid a push for judiciary unification and administrative reforms in the 1970s, the amendment empowered the Chief Justice with a majority Supreme Court justices to promulgate rules for court administration, practice, and procedure with the force and effect of law. Similar to 72A, added in 1966, the vested judicial power in the Supreme and Superior Courts while allowing the legislative to establish lower courts, a provision that, when combined with 73A, has fueled disputes over boundaries. Historical records indicate these amendments were actively advocated by the judiciary itself, with the Supreme Court leaders and the Bar Association lobbying for enhanced administrative control to streamline operations post-unification statutes in 1971. While presented as an efficiency measure, the passage raised questions over voter turnout of the 1978 ballot question was influenced by judicial endorsements. Critics at the time argued it blurred separation of powers by allowing unelected justices to enact binding rules without full legislative vetting. This judicial push echoed earlier tensions, such as the 19th century debate over court reorganization, where the legislative retained firm control. The necessity of CACR 29 stems from the Supreme Court's overreach under Article 73A, which has led unconstitutional infringement on citizens' rights. What began as an administrative authority has expanded to subjective rulemaking that circumvents the general court and erodes due process for all. For instance, procedural rules governing evidence, hearings, and case management, such as those in the family court, have effectively altered statutory rights without any legislative consent. In sensitive areas like parental terminations or custody disputes, court adopted rules that have imposed expedited processes that critics argue deprive litigants of full hearings and due process rights with access to cross-examination or access of full records, violating the First Amendment, Article 15, protections against unreasonable deprivation of liberty. The 2000 impeachment of Justice David Brock highlighted this investigations. It revealed the court's use of 73A to justify internal practices, like case assignments, ethical guidelines that shielded operations from scrutiny, prompting legislative attempts, back then it was CACR 4, to repeal the article entirely. Although Brock was acquitted, the episode exposed how force of law rules can insulate the judiciary from accountability, fostering perceptions of unanswerable elite status. More recently, rules on the court access, electronic filing, evidentiary standards have been challenged as oversteps, with lower courts applying them in ways that subjectively impact outcomes, such as limiting appeals or imposing fees without the democratic checks of statutory enactment. This overreach is not mere inefficiency. It infringes on the fundamental rights of the citizens. Citizens face the courts, often in vulnerable moments like family breakdowns or civil disputes, encountering rules that act as de facto laws, yet lack transparency of legislative debate. The questionable manner of 17.3a's adoption, driven by the judiciary advocacy rather than the grassroots demand, compounds that issue. As it deviated from the framers' intent without broad public discourse on its long-term implications, CACR 29 rectifies this by repealing the force of law clause, ensuring Supreme Court remains advisory and administrative unless enacted by the General Court. This does not undermine the judicial's independence. Judges retain the authority to adjudicate cases free from interference as protected by the lifetime tenure during the good behavior, Article 73, and removal only via impeachment, Article 17 and 38. Again, with the earlier mention, going ahead and giving the legislative the ability to investigate so that they can actually impeach. Currently, they have no ability to really impeach without understanding the facts behind what they're trying to impeach. Instead, it restores the constitutional balance, preventing future overreach and reaffirming the people's sovereignty through their elected representatives in the spirit of New Hampshire heritage of accountable government, from the 1784 framers' rejection of arbitrary powers to the legislative historical role in court oversight. I urge this committee to pass this amendment.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Daniel Richard, please.
Good morning, Chairman, honorable members of the committee. My name is Daniel Richard. I'm a citizen of New Hampshire. I'm here today to voice my strong support of repealing the 1978 constitutional amendment to Part 2, Article 73A of the New Hampshire Constitution. This amendment improperly granted the Supreme Court the authority to promulgate rules that, quote, have the force and effect of law, shifting core legislative power to the judiciary in violation of our state's foundational principles. Prior to this amendment, the legislature's rightful exercise its constitutional authority under Part 2, Article 4, which establishes rules, laws governing court administration and procedure. This ensured accountability to the people through their elected representatives. The 1978 change, however, encroaches on the legislature's exclusive domain, as only the general court has the power to make laws and bind citizens of the state. This amendment directly contravenes Part 1, Article 37 of the Constitution, separation of powers. The three essential, quoting, The three essential powers thereof, to wit, the legislative, executive, and judicial, ought to be kept as separate from and independent of each other, and the nature of a free government will admit. By allowing the Supreme Court to create rules with the full force of law, without legislative oversight or approval, it blurs those lines, undermining the independence of the branches and the democratic process. History shows that before 1978, court rules were subject to the legislative review, preserving this balance. Furthermore, the validity of the 1978 amendment itself is questionable under the set precedent of Gerber v. King. In that case, the New Hampshire Supreme Court invalidated constitutional amendments because the ballot question misled the voters about the true effects, failing to provide a clear, informed choice. Similarly, in 1978 ballot question 73A, described as making the Chief Justice administrative head of the courts, authorizes rules for administration and procedure. Did not transparently convey these rules would carry the binding force of law, potentially misleading voters on the amendment's sweeping transfer of power from the legislature to the judiciary. Repealing this amendment would restore the proper separation of powers, reaffirm legislative authority over lawmaking, and align with the principles of transparency and voter intent upheld in Gerber v. King. I urge the committee to advance this repeal and protect our constitutional framework and ensure that the laws made by those accountable to the people. I'd like to add one closing point. I brought this to Bill Gardner's attention when he was still Secretary of State, because obviously he's in charge of elections, and what I discovered horrified me. That language, quote, the rules suproglated shall have the force and effect of law, was not in the voter's guide. The voters had no idea what was about to happen. You know how it got inserted? He was strong-armed by members of the bar who told him to insert the language after the fact, after it was passed by the voters. That file still sits in the Secretary of State's office. He showed it to me. And that's not the way we should do business. We're talking about process here. Despite the good or the bad or otherwise, what good are the law, what good is the Constitution if people will just arbitrarily put it aside to advance an agenda? And this is a continuation, as you heard my testimony earlier, with 72A. 72A made the courts so-called constitutional. This power would then be abused as a follow-up with the 73A change, which again led to the current statute that's on the books, 663:3, which says very clearly that the text of any proposed amendment must be on the ballot. And that's not happened here. And both of these, 72A and 73A, have the same fatal flaw. Questions?
Questions for this witness? Yes, Representative Ford.
Well, this is more a question for the chair. Is it possible to have research draw up some sort of summary of the actual history behind the 1978 constitutional amendment? We've heard a lot of history about it and a lot of assertions made about what was in the voter guide, et cetera. Would it be practical to have our wonderful research staff like draw up at least a brief summary what the known facts are about that amendment?
I think the answer to your question is yes. The question is when, and that's and given our schedule, I'm not. I mean, I will certainly speak to our staff and ask them about that. But I mean, it's not happening this afternoon. That's for sure.
Okay. Yeah.
If the chair would let me address that issue, I have a certified copy from the state archivist. And so it's readily available. You can still see the voter's guide on both 72A and 73A. They're available to you if you want to get there. But I understand the time constraint, and it may not get to this committee this afternoon, but it is available to you.
Thank you. Thank you. Other questions for this witness? Seeing none, thank you very much.
Thank you.
Dana Albrecht, please.
Good morning again, Mr. Chair and members of the committee. I said earlier I was an originalist. It appears Ms. Warner is the antithesis.
Yeah. Let's just stick with what you have to say, okay?
It's directly relevant to the bill, sir, or the amendment. I've heard arguments across all these that essentially for 182 years, from 1784 to 1966, our Constitution was somehow broken that for 182 years, we didn't have separation of powers under Article 37. And I've heard arguments that if somehow we remove these provisions, all of which are very modern, that it would somehow break the Constitution. That's an insult to the founders that created something that worked for 182 years. Moving on, quite frankly, this provision enables an imperial judiciary. The force of law, that's imperial. And what has the force of law in this scenario? As you heard in the emails, the force of law, the taxpayers of New Hampshire are defrauded by a scheme of the Chief Justice of the Supreme Court, in which the head justice of the Superior Court says, get rid of the effing memorandum of understanding. That's what we're talking about, having the force of law here with this amendment in place. This is not to lend the force of law to the Judicial Conduct Committee, which ignores such complaints. This is not to lend the force of law to rules of evidence, which are routinely ignored in family court. This is not to lend the force of law to any of the allegedly positively things brought up. This is to lend the force of law to all of the misconduct that has been laid before you in the emails you received today with all of the supporting evidence and attachments. And so I would urge you to support this constitutional amendment and strike this language. It's abhorrent to a free society. Thank you.
Questions for this witness? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you for taking my question. And it'll be a would you believe, since you mentioned originalism. Would you believe that Alexander Hamilton in Federalist 78 said that the courts must be independent to serve as a check on legislative overreach, calling the judiciary the least dangerous branch, only so long as it's insulated from political control? And would you believe that James Madison in Federalist 51 said separation of powers is essential because ambition must be made to counteract ambition? And would you further believe, and lastly believe, that in the debates at the New Hampshire Constitutional Convention in 1783 and later revisions, the framers explicitly modeled Article 37 on the Enlightenment separation of powers theory of Montesquieu?
Absolutely, sir. And to this date, if I may further add, if you look at the federal framework, the federal courts are constructed largely by federal statute. We don't have specific provisions. We have Article 3, but when you look at the divergence of the federal district courts are a creature of statute, and there's nothing wrong with that. They operate independently.
All right. Other questions? Seeing none, thank you very much, sir.
Thank you.
Is there anyone else who wishes to be heard on CACR 29? Seeing none, I'm going to close the hearing on CACR 29, and I'm going to turn the chair over to my vice chair because I'm the sponsor of the next bill.
All right, we're going to open the hearing on House Bill 1001, and I recognize Representative Lynn to introduce the bill.
Thank you, Mr. Chair and members of the committee. My name is Bob Lynn. I'm a state representative from Rockingham District 17, town of Wyndham. And I appear here as the sponsor of House Bill 1001, which essentially allows the county attorney again, assuming that there are appropriations available and with the approval of the county commissioners, to appoint investigators within the county attorney's office who have law enforcement authority and are subject to supervision by the county attorney. As I understand it, and I suspect that there will be witnesses here who will have more details to provide about this, but that there is some problem or issue about the county attorney being able to have investigators who have law enforcement authority to be able to make arrests and do other things like that. But that work for the county attorney's office. In fact, it seems to me that it may, when I discuss this with representatives from the county attorney's office, it seemed to me to make sense that the county attorney should have that authority. Again, assuming the county commissioners agree and that there's money available, and so that's the basis of my proposing the bill. And as I say, I'm happy to answer questions that I can, but in terms of the details of problems that might exist of why that is necessary, I would suggest that the people behind me probably have much more information on that than I do. But if you have questions for me, I'll try to answer.
Thank you. Are there no questions for Representative Tripp?
Thank you, Mr. Acting Chair. Thank you for taking my question. It seems that there's a contradiction in this LSR. If you look at lines 7 and 8, it says that any person appointed shall be certified or eligible for certification as a police officer. And then when you go down to 13 and 14, it says nothing in this section shall preclude county attorneys from appointing investigators who are not certified. Can you explain the reason for the section 3?
Sure, yes. So as I understand it, the situation that exists right now is that the investigators who work for the county attorney's office right now are the investigators who would fall within section Roman numeral 3. In other words, they don't have law enforcement authority. The investigators are, and so the purpose of the bill is to allow the county attorneys to appoint investigators who do have law enforcement authority. But the reason for paragraph 3 is to say we want this bill to allow new investigators who have law enforcement authority to be appointed. We don't want to diminish the county attorney's ability to have investigators who don't have law enforcement authority.
Follow up.
So the reason is section 3 would allow the county attorneys to retain the existing investigators.
Right.
Right. Thank
Exactly. You. Yes.
Representative Birch.
Thank you. And thank you, Mr. Chair, for taking my questions. And understanding what you were saying, I'll try to limit them to at least your understanding of what this bill is trying to do. And I will say, since the gentleman came in at an early hearing talking about a police officer from Cheshire County, Mr. McLaughlin, who is now a county investigator and had a certain amount of scandal attached to his career, it fashions my questions about giving him a gun. So let me ask first, if I may. The purpose of this bill is to give these investigators statewide law enforcement authority that's complete to do traffic control, to work with ICE, to assist on a burglary situation, arrest people and the like. Is that correct?
Well, if you're asking, would they potentially have that authority? I suppose I suppose the answer to that would be yes, but they would be happy. I mean, since they're operating under the authority of the county attorney presumably that would only happen if the county attorney said, you know, to one of these investigators in Cheshire County, go to Coos County and arrest somebody for committing, you know, one of the offenses that you talked about. So I mean, if you're saying theoretically would they have that power? Yes, I would assume that that they would operate under the authority of the county attorney, who would have them, you know, exercising their law enforcement authority in connection with investigations that the county attorney was carrying out.
I can follow up. I'm not sure if I should direct it to the deputy chair or the chair. Am I incorrect in understanding that county attorneys are not law enforcement officers and do not have law enforcement authority?
That's my understanding, that you're correct, that they do not have that.
But this bill would allow the county
Would you
attorney.
like another follow-up?
Thank you.
Yeah, that's one.
So, still trying to understand the bill. This would allow somebody who is does not have law enforcement authority to direct an employee to go out and do law enforcement work. Is that right?
Right, which is something that happens all the time with police departments. I mean, in other words, I have to take my personal experience from the federal level, but I don't think it's any different in the state level. If the FBI was working with the U.S. Attorney's Office in connection with an investigation, it would not at all be unusual for the U.S. Attorney, who has no law enforcement power, to say, okay, we've got enough, you know, we have enough to arrest Mr. X for bank robbery or whatever. Go out and arrest him, or you know, go get a warrant to arrest him. I assume that would happen at the state level also.
Representative Turner, you have a question?
Yeah, thanks. And thanks for taking the question. Maybe along the similar lines, but I guess I'm a little confused by the order of things in terms of saying that this would authorize someone to be effectively a police officer and make them eligible for certification, which they may not subsequently achieve. So would we be essentially, and I don't know how this process works normally, but creating essentially officers who may ultimately not be able to be certified as officers? So line 9 says fails to achieve certification, but line
Right.
6 says shall have statewide law enforcement authority.
Right. I think the intent would, I think of the way it's worded is that somebody would have to either be a certified law enforcement officer or have eligibility to be certified in order to have the law enforcement power. And I think the last sentence is designed to cover the situation of someone who doesn't, you know, who either loses that eligibility from the police standards and training to be certified as a law enforcement officer, or goes through the process of trying to be certified and fails. Then that person would no longer be eligible to serve in the position.
Can I ask one quick follow-up? Yes. So basically, they would be able to act as law enforcement without having that certification from the time that they're placed in this position.
Yeah, I see what I think I see what you're saying. In other words, I think that the way the bill is worded, and maybe this, you know, maybe this creates a loophole that we ought to change the language a little bit, but I suppose what could happen is the county attorney could hire somebody who appears to be eligible, who is not certified as a law enforcement officer at the moment, but is eligible for certification, and could then enter on duty, presumably continue with attempting to be certified, and then ultimately not succeed in being certified. And for that period between the time he was hired and the time he was not, you know, he failed the certification, yes, he would have that authority to act as an investigator. I don't know whether that applies, for example, whether a police officer who is hired as a new police officer and gets, goes and is must already be certified in order to be hired as a police officer, or if you can be hired and be eligible for certification. I just don't know the answer to that. But if it's not, I would certainly agree that if the wording of this bill is different than what happens with somebody who is just a regular, a new hire as a police officer, then we should change it because there shouldn't be that difference.
Thank you. Rep. Scully?
Thank you, Mr. Chair, and thank you for taking my question. It was always drilled into my head that the first thing we should always ask is demonstrated need. And so the question I ask you is there a shortcoming or flaw in the current system that creates a demonstrated need to warrant this legislation?
That's an excellent question. And as I understand the issue, and it may be that we're going to hear some debate about this because this may not be, but as I understand the issue from the county attorney's office, the lack of having a in-house, so to speak, investigator with law enforcement authority is that means that the county attorney's office, when they need somebody with law enforcement authority, are having to rely on either the sheriff's office or the local police department. And I think that there is a sense on the county attorney's offices that they ought to have somebody when they're conducting investigations, particularly that is sort of under the control of the county attorney's office that has law enforcement authority, because I think, and again, having been a former prosecutor, I'm keenly aware of this issue. There can sometimes be real tension between the prosecutors and the police officers as to what should be done, how it should be done, when it should be done, that kind of thing. And I think that's one of the things that this is designed to address.
Thank you.
Thank you.
Representative Burt, do you have another follow-up?
I did, thank you.
Okay. Do you still have one?
I still.
Okay.
Mr. Chair, you've talked about the person who is hired that is certified. You've talked about the person who eventually doesn't pass certification. I'm wondering if there's like a huge loophole where a county attorney hires somebody who might be a friend, might be a colleague or whatever, who's not certified, who never applies for certification. It seems to me that person can continue under this statute forever.
Again, you may be right. The way this is worded, you may be right. And if that's an issue that you that we should amend the bill to say only a certified person, I suspect that what the county attorney may have had in mind here is you may have a situation of for example, a retired police officer who wants to come to be a county attorney's investigator, who has, because they've retired, has let their sort of law enforcement, certification expire, but are still eligible to get recertified, so to speak, and is designed. The language here would allow them to start working while they go through that process of getting recertified. That's what I'm sort of thinking is the way it was proposed to be worded this way, but this is a minor aspect that I'm certainly not, it's not a beach I want to die on. And if we had to change the language, I'd be happy to do that.
Representative Smith?
Thank you very much. Did your desire to file this bill come from a request from all of the county attorneys or from just one?
My recollection is there was one, I believe it was Merrimack County that was the county attorney's office there, I think, was the prime person that I spoke with, but I think there may have been at least one other county attorney, but I didn't, if your question is, did all of the county attorneys kind of say that they universally supported this? No.
Thank you very much.
Okay, any other questions about law enforcement or certification of law enforcement officers for the prime sponsor? Or any questions at all? Seeing none, thank you.
Thank you.
Sheriff Bill Wright?
Good afternoon, Chair and members of this committee. I am Sheriff Bill Wright. I am the Belknap County Sheriff. I have 28 years law enforcement experience. I'm in my third term as sheriff, so I'm just starting my 6th year. And I also serve in the capacity of the New Hampshire Sheriffs. I'm the president of the New Hampshire Sheriffs Association, in which that's what I'm representing today, as well as myself. I have submitted written testimony, and I won't read through the entire testimony, but I'll hit some highlights on this. The New Hampshire Sheriffs Association, so that represents the 10 county sheriffs. We do not support House Bill 1001. Therefore, we're in opposition of this. House Bill 1001 blurs the longstanding separations between prosecution and law enforcement. It weakens the critical checks and balances associated with criminal investigations. The county attorneys are constitutional officers, just as sheriffs are, who in their particular role is to prosecute cases, not to create them, not to supervise them, or to operate an independent law enforcement entity. Because ultimately this bill would make them, in essence, a police chief or another constitutional officer that deals with law enforcement. Allowing county attorneys to establish investigators' positions with law enforcement authority creates the risk of prosecutorial overreach and conflicts of interest, particularly in charging decisions. When we take in a case and we investigate the case, we submit it to the county attorneys to review the cases and make the determination on the prosecutorial processes there forward. When they're directing these investigations to happen directly out of their office, we believe that it creates a flaw within that system. The bill raises serious accountability and oversight concerns, including who sets policies, enforces discipline, and investigates misconduct. Because again, this will establish a new police department. So are these certifiable officers or what have you, are they actually bound to adhere to the Police Standards and Training Council's rules and regulations, and as well as New Hampshire laws like RSA 106? House Bill 1001 provides no clear framework for internal affairs, civilian oversight, or external review of investigator actions. As a matter of fact, I believe that it actually closes that ability to actually find out more about cases. There is no uniform statewide oversight, certification, or training standards proposed in this process in creating inconsistent practices across all the counties. We already have things in place at the county level, and we are county officers as sheriffs. We have the ability to assign investigators to these county attorneys if they come up with an agreement. It's unclear whether these investigators would operate in uniform or in plain clothes, or what authorities they have, and what would they represent for visibility to the public? How are they answerable? The bill introduces ambiguity regarding arrest authority and use of force, the liabilities and indemnification of that. Law enforcement agencies are required to comply with the NIBRS reporting system, which is the National Incident-Based Reporting System, and other state-mandated data and compliance obligations, where we haven't heard anything about how the county attorney's office would operate as a police department and fulfill those same obligations. It doesn't address how it would be met. Police executives are responsible for training, certification, use of force policies, evidence handling, records retention, and accreditation, if they chose to go that route, functions outside the role and expertise of prosecuting attorneys. They're a prosecutorial authority, not a law enforcement investigative service. Existing law already allows county attorneys to work collaboratively with state, county, and local law enforcement without creating a parallel investigative structure. House Bill 1001 duplicates services, increases taxpayer costs, expands legal exposure for counties, and risk eroding of public confidence. For these reasons, the New Hampshire Sheriff's Officers Association strongly opposes House Bill 1001, and we request that it go to ITL.
Thank you. Any questions? Representative Manos?
Thank you, Mr. Chair, and thank you for taking my question. I believe you testified that sheriffs can assign investigators to a county attorney's office. If that's correct, could you be a little bit more explicit about that or a little more detailed about that?
Sure. Under agreements, sheriffs such as myself, I can very easily assign an investigator to a county attorney's office to handle any investigatory processes or anything that the county attorneys need. Now, that employee would fall into my purview, which, again, I'm law enforcement. I've already got established policies and procedures. Their daily activities would be monitored and run through the county attorney's office as kind of their quasi supervisor, if you will. But as the sheriff, I would have the authority to handle all the disciplinary processes, the reporting requirements, everything that's associated with that. So it would be in a cooperative process. We're all county officers. We should be working collaboratively anyhow.
Follow-up?
Thank you, and thank you again for taking my question. If you assigned an investigator, would it be on a per-case basis, or could you assign an investigator, for example, for a specific period of time, or to investigate, for example, the category of child sexual abuse cases? Thank you.
Sure, that could be done on any basis that we want it to be, as long as funding's there, as long as personnel are available, what the actual roles and responsibilities are. We have the ability to create these positions, and with the approval through the funding processes to allow that to happen, we can most certainly, hire personnel and assign them to these assignments. We do it regularly. We do it with matter of fact, all of our offices throughout the state. We all operate a little differently in different areas and aspects, and we assign people to the different various assignments. So it would be an assignment, but again, they would be accountable to the sheriff of that county, and that's the law enforcement. The county-wide law enforcement is your sheriffs. We've been here since biblical times, so we plan on staying here.
Thank you. Any other questions? Nope. Seeing none. Thank you.
Thank you very much.
Paul Halverson? Push the button.
Hi, Paul Halverson, Merrimack County Attorney, and I am certainly coming into the lion's den, I see, with this Bill 1001. I would like to start my testimony by answering a couple of the questions that you all posed prior to my coming up to the desk here. One of the questions had to do with whether or not a county attorney is a law enforcement officer. County attorney is the chief law enforcement officer of the county. County attorney is able to direct the policy of the county as far as law enforcement goes. There's a Attorney General memo that goes back into the early 2000s that addresses that issue. The county attorney does not address how a law enforcement officer would do their job, but certainly can direct general direction within the individual county. And that's a part of the constitutional role that the county attorneys have as chief law enforcement officer. The bill talks about, in regard to the question, certified, non-certified. The top couple paragraphs of the bill address the certification process, hiring someone who's certified. Paragraph 3 addresses the ability to hire a non-certified person. If a person does not meet the requirements to be certified as a law enforcement officer, they would not get the powers of a law enforcement officer. They're two separate items. And one of the questions that was posed to Representative Lynn was, what happens if they hire someone who's not certified? Well, they wouldn't get law enforcement powers until they were certified. They would serve as a non-law enforcement investigator. Historically, and I can go back probably close to 20 years, because I've been practicing in Merrimack County since 2003, a prosecutor since 2003, and county attorney since I was sworn in January of 2021. The Merrimack County Sheriff's Office had sworn in the investigators for the county attorney's office. They were indeed sworn officers. Police standards and training standards. There was a question about meeting police standards and training requirements. That would be done by the county attorney's office. They'd be responsible for, if they elect to hire somebody as a law enforcement officer, they'd be required to meet all of the requirements and do all of the certification with police standards and training. Regarding support, the Attorney General's office is in support of this. 9 county attorneys are in support of this. I was unable to reach one this morning to get his comment on it, but 9 of the 10 county attorneys are in support of this. I will say that I spoke with Director Skippa, Director of Police Standards and Training, just this morning. And his comment to me regarding this, and I'm paraphrasing here, regarding this legislation, is that as long as the county attorneys address the issue of all the requirements for law enforcement authority, his concern had been met. That's the certification requirements, the training requirements. So as I said, I spoke with him early this morning. There was a comment about increasing costs. I can tell you from my office, I have 2 investigators. They're paid what they're paid. And whether or not they're sworn or not sworn, basically the same pay scale. So from my office, there'd be no increase in cost. There'd just be the added benefit of having them as a law enforcement officer. There seems to be a little bit of confusion about the roles of the local police departments and the roles of the county attorney's office. County attorney's office is indeed a prosecutorial office, but keep in mind that local police departments and the county attorney's offices proceed under different standards. A prosecutor in the county attorney's office moves a case along and has to meet a beyond a reasonable doubt standard for conviction. Police departments, when they do their investigation, they have to get to a probable cause standard, more likely than not that a certain individual had committed a certain crime. 2 different standards. And that's why the follow-up investigation that may be needed to close that loophole to meet the burden of proof beyond a reasonable doubt may be necessary, and that's better done internally. The ability to do that is best within the county attorney's office. Remember, the county attorney's office, in prosecuting a case, they have a theory of a case. They have attorney work product that the investigator has access to. Police departments generally don't have access to it. And there is a reason for that, a separation between the prosecutorial duties and the initial law enforcement function. The local law enforcement officers are those initial responders. They do the initial investigation. If there are specifics that need addressing, that's done afterwards, either by a request to the law enforcement agency who did the initial investigation or by the internal investigators. It basically bridges the gap between the initial investigation police department and the court process. Answering those questions, I'll move on to some of my other comments. I guess there was one comment and testimony regarding confusion or added problems with this legislation. I would refer you to RSA 21-M:3. That is a Department of Justice, a statute that applies to the Department of Justice. 21-M:3, Roman 7, talks about the Attorney General nominating criminal justice investigators, and I quote, each of whom shall have statewide law enforcement authority, shall be a peace officer as defined in the appropriate RSA. Then it goes on to talk about the term. The paragraph continues to say, any person nominated for such a position shall be certified or eligible for certification as a police officer pursuant to 106-L:5. So if there is a problem with House Bill 1001, then there is a problem with 21 M37 regarding the Attorney General's investigators. And I can tell you that this bill, when I called and spoke with Representative Leonard Lee, was last summer when we spoke, the language of the bill was coordinated with the county attorneys at that time, as well as the Attorney General's office. And as I said, the Attorney General is on board with it. And I'm not talking about their office generally or the deputy. I'm talking about Mr. Formella. He's on board with this. Please bear with me answering your questions. I'm going to try to truncate some of my other comments. In 2025, the nexus of this request was that one of my investigators retired. He was a certified law enforcement officer and deputized as a sheriff. When I was replacing that individual, the sheriff declined to swear in that individual as a law enforcement officer. I still have a sexual assault investigator who was in the same boat. That in late 2025, the county sheriff elected to withdraw her credentials as a law enforcement officer. So as of December 31st, that was done by the sheriff and discharged her as a deputy. The impact of that is that any function that they did as a law enforcement officer, I'm now asking those investigators to push those back to the local police departments. The impact of that for small police departments can be devastating. Take a police department in the west end of Merrimack County with 3 individuals, maybe 2 individuals on the police department. Maybe they don't have a big caseload. Maybe they don't have a lot of experience. My sexual assault investigator, who has 22 years of experience, could definitely help that organization out. Search warrants, arrest warrants, items such as that. But because they're now no longer certified officers, some of the immunity that goes with being a certified officer and acting as a certified officer goes away. So I am not going to put that person in a position of working on something where she may not have legal protections, or he may not have legal protections from my other officer. As I said, I coordinated with Director Skippa, coordinated with the Attorney General's office, spoke with all the county attorneys' offices, and I even spoke with several police chiefs within Merrimack County, especially ones in the smaller departments. And the ones that I spoke with are, again, on board with this. I talked about 1001 being a parallel statute to the governing statute for the Attorney General's office. 1001 also bridges an evidentiary gap. I touched on this a couple moments ago regarding the probable cause standard for police departments beyond a reasonable doubt standard for prosecutors. The local prosecutors do the initial investigation. Our prosecutors can help bridge that gap when an attorney sees an issue with a case where we need to close a certain loop. We can do that. And that attorney would have the theory of the case and access to attorney-client product that the initial investigatory agency would not have. There is also an ability with an in-house prosecutor, for the in-house prosecutor, to talk with the in-house investigator regarding the status of the case and have an action quicker than that may be involved with contacting a local agency to have them follow up with the investigations. There's also the ability to review reports. A trained law enforcement officer, and I'll be honest, when I hire somebody as an investigator, I look for someone who had been an officer, had been a detective for many, many years. These are skilled people. They're able to review the documents that come in, and when an attorney has a question, hey, what's wrong, what's good, what's bad with this investigation, what's good, wrong, or bad with this report, they have the ability to say, this was a good report, they're missing a gap here that the attorneys may not know because they're not trained investigators. There's also the ability to work to minimize witness intimidation. Some victims of sexual assault, and I'm going to try to keep my comments general here because involved a recent case. The individual testifying, the victim in the sexual assault, was scared beyond belief to come into court and testify against her assaulter. And we had the ability with the law enforcement officer to provide some degree of escort and comfort to that sexual assault victim coming to court to testify. (1001) gives a county attorney options. It mandates nothing. It protects attorney work product, protects the theory of the case, and in ways augments local law enforcement, and in ways augments the sheriff's department, locating witnesses, serving subpoenas, assisting with initial and follow-up investigations for those smaller departments. It addresses vital safety concerns that a civilian individual would have hands down. Going to a homeless camp to serve a subpoena, going to a homeless camp to find somebody. There's a degree of protection that comes with that law enforcement officer. Whether or not everyone agrees with it, there's a societal norm. You don't attack a police officer. And if you do, that police officer should be able to protect themselves to the level that they're trained, and that could involve the use of firearms. I will tell you that that going to some of these small homeless camps and large homeless camps is a very threatening environment. If a civilian investigator has to go there, they're going there unprotected, and who are they going to call to come and escort them down to that camp, the local or the sheriff's department, local police department or the sheriff's department? I'm sure they'll gladly help us, but it takes that local law enforcement officer away from his normal patrol. It takes that deputy sheriff away from their normal duties.
I can just interrupt. It's been about 15 minutes, and we are behind. So if you could make your point, wrap it up.
I'll sum it up. It doesn't obligate state funds. Doesn't obligate any kind of hiring. Doesn't obligate county funds beyond what would be obligated in the normal budgeting process. It doesn't reduce a law enforcement agency's personnel, whether local or the sheriff. It does not require a sheriff to be detailed to the prosecutor. It does not replace local or sheriff's obligations. They're still the primary investigator. It's a force multiplier for small departments. It allows law enforcement agencies like the sheriff's department, like a local police department, to pursue accreditation. To backtrack a little bit, one of the reasons I was given for not certifying these officers as law enforcement officers was that the sheriff was unable to meet the requirements of accreditation because he didn't have control of the individual who was working within our office, meaning supervision. That supervision fell to me as the county attorney. So with this, with 1001, it would allow police departments to go ahead and meet those certification standards. It's a solid proposal. It parallels that the county attorney's, that the Attorney General's office has, and I'll gladly answer any of your questions now, or if anyone sends a written request to me later.
Any questions? Rep. Tura?
Yeah, thanks, and thanks for taking the question. Did I understand in your testimony that you had an investigator that had police law enforcement authority, and then when that person retired, you weren't able to get someone else in the same position? I was just curious. Do you have this ability currently in some form, and this tries to change how you would get an investigator with law enforcement?
I was able to hire.
Did I misunderstand that?
I was able to hire an investigator, a new investigator, as a replacement to the individual who retired, but he does not have law enforcement credentials. He was a certified police officer. He is a certified police officer in New Hampshire. He was a law enforcement officer for 20 or 21 years, retired from that, then went to work for the University System of New Hampshire, two separate entities regarding law enforcement, but he is a certified officer, but he's not sworn.
Follow-up?
Follow-up, thank you. So the person who was replaced, you did have an investigator with law enforcement authority. I'm just curious sort of how that came about without a provision like what we're looking at here.
The individual who retired was sworn as a deputy, And historically, that position had been sworn as a deputy, much like the sexual assault position that was in our office was a sworn deputy, and that was by agreement with the sheriff's department. The sheriff elected to, he can elaborate on that if he wishes. He elected for one of the reasons to withdraw the credentials from those two positions for command and control reasons, for him to meet the accreditation requirements that his department's trying to meet.
Representative Scully has a question.
Thank you, Mr. Chair, and thank you for coming and testifying.
Certainly.
Do you have letters of support from the State Attorney General's office and the other county attorneys that you could provide to the Judiciary Committee?
I do not have letters. I can tell you that I came from a county attorney's meeting with the AG's office right up to here. I verified that the Attorney General Formella was on board with it. The individuals who were there today for the county attorney's meetings had told me individually, in person or by email, that they were in support of 1001.
Thank you.
Representative Tur?
Yeah, thanks for allowing one more question. Going back to that same scenario. So if I'm understanding right, in the past, this happened through the sheriff's office. And for whatever reason, in the replacement, the sheriff's office declined to provide the same deputization or law enforcement authority to your new hire. So I guess I'm wondering, does this basically override the relationship between the county attorney's office and the sheriff's office in a way that disrupts the way things have existed in the past for perhaps good reason?
I can tell you that that Sheriff Cross and I have known each other probably close to 20 years. We have a pretty good working relationship, I must admit. We just disagree on this issue. I don't think it affects our working relationship one bit involving other issues with law enforcement. I routinely speak with him and his detectives, and I've received no indication that there's any problem with his support to our office. We just disagree on this one issue.
Representative Tripp?
Thank you, Chair. Thank you for answering my question. So this bill states that the people would have to be able to become certified law enforcement officers. I understand from your testimony that they have to be sworn by someone. Does this bill define in any way who would be swearing them? Would the county attorney's office be swearing them?
My conversations with individuals I spoke with, it would be the county attorney as swearing them in as law enforcement officers, and the county attorney's office would be responsible for making sure that they meet all the requirements for certification, as well as continued certification, as well as all of the requirements that police clearance and training imposes on a department.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Steve Enders?
Good afternoon, Chairman, members of the committee. My name is Stephen Endres. I'm an attorney who's been practicing criminal law for about the past 25 years. The majority of my career was as a prosecutor, and I did spend 7 years working at various county attorney's offices. I spent 2 years at the Rockingham County Attorney's Office and 5 years at the Merrimack County Attorney's Office. When I was in those county attorney's offices, both of them had investigators at the county attorney's offices. And as Attorney Halverson said, those investigators generally were retired law enforcement officers. In Rockingham County, there was a retired officer from Manchester, as well as a retired state trooper. In Merrimack, there was a retired Concord officer and a retired Bow officer. Those retired officers were given law enforcement authority as deputy sheriffs through the county sheriff, pursuant to RSA 104.3. And it was my experience that that was generally a ceremonial position or a ceremonial title. And I say that because I don't think they ever actually used their law enforcement authority. In terms of doing follow-up investigations, certainly one doesn't have to be a certified law enforcement officer to do a follow-up investigation. One doesn't have to be a certified law enforcement officer to issue subpoenas or serve subpoenas. In my experience, the county attorney's office prosecutes cases that are brought to them by the local police department. So if a person actually goes to the county attorney's office and says, I want to report a crime, the county attorney's office isn't going to take that report. They're going to refer them to the local police department. Over the last decade, law enforcement accountability has been a national topic. We've had discussions about body-worn cameras. There have been discussions about implicit bias. In 2020, Governor Sununu created a commission on law enforcement accountability, community, and transparency. That commission made extensive recommendations to both the legislature as well as the governor, and many of those recommendations were implemented. There's now a conduct review committee at Police Standards and Training Council. There's a law enforcement accreditation commission, which was formed as a result of another executive order, which helps agencies set best practices in law enforcement. None of those things existed 5 or 6 years ago. And with those increased demands for police accountability, I think the sheriffs became reluctant to deputize individuals working in the county attorney's office outside of their control. And I say that especially since there is a statute in New Hampshire, RSA 10428, which makes the sheriffs personally liable for the actions of their deputies. So the sheriff deputizes a person and is then personally liable for what that deputy does. Certainly, the sheriffs are free to execute memos of understanding with county attorneys' offices, to continue to deputize the investigators in the county attorney's offices. They can certainly do that. But I think it does make sense, if you're a sheriff and you're personally liable for this person's actions, you want some level of supervision, or at least knowing what they're up to. I think there's a number of problems with this bill, and I actually think Republican Birch hit it on the head with accountability. Whether or not the county attorney is a law enforcement officer, I think we could have a very interesting philosophical debate on that. But the fact of the matter is that law enforcement officer is defined in New Hampshire law under RSA 106 L2 subsection 4. And clearly the county attorney does not meet that definition, because if the county attorney were in fact a law enforcement officer under that definition, they would have to become certified by the Police Standards and Training Council, and that's not the current state of the law. All law enforcement officers in New Hampshire have to be certified by the Police Standards and Training Council. And they're responsible and answerable to the Police Standards and Training Council. Police chiefs, sheriffs, everyone who's a certified law enforcement officer is responsible to Police Standards and Training Council, and there's statutes which require those chiefs to make reports of misconduct to the Police Standards and Training Council. So essentially, if there's a report of police misconduct made to a police chief or a sheriff, they're obligated to follow up with Police Standards and Training Council. County attorneys aren't answerable to the Police Standards and Training Council, so it's unclear whether they would be required to make those reports. As I said earlier, the sheriffs are personally liable for the actions of their deputies. I would ask that any county attorney in favor of this litigation should be asked a simple question. Would you be in favor of an amendment adding a provision similar to RSA 10428, which makes the county attorney personally liable for the actions of these certified investigators? And if a county attorney isn't in favor of that, then that should be something that gives you great pause. Another problem with this bill is that law enforcement in New Hampshire is a highly self-regulated industry. Police departments have standard operating procedures and rules that they employ within those departments. Some of those standard operating procedures are actually required. There's an executive order, again, from Governor Sununu 2020-19, that requires law enforcement agencies to have certain standard operating procedures addressing certain issues. My experience with law enforcement is that these standard operating procedures cover a multitude of topics, from how to make an arrest, how to handcuff a suspect, a code of conduct in terms of how to maintain yourself well, both on duty and off duty, when you can tow a car, how to report incidents of misconduct, and even what firearms you can carry when you're off duty. County attorney's offices don't have any of those standard operating procedures because, again, county attorney's offices were never directly hiring law enforcement officers or police officers. The third issue is, I think, within the hiring process itself. Before I went to law school, I went to the University of New Hampshire as an undergrad, and I was fortunate to have been able to do some internships with the New Hampshire State Police. I spent 6 months in the major crime unit and then ended up going over to support services for another 6 months where I worked with training and recruitment. And what people may not realize is that hiring a police officer isn't like you get a resume in the mail, you have an interview, and then you hire the person. There's actually, there's administrative rules from police standards and training again that have certain prerequisites to hiring police officers. In New Hampshire, to hire a police officer, you must have a background check. That background check has to list that person's residences for the past 10 years. You need their work history for the past 10 years. You need a financial history, a history of financial obligations, a history of drug use, a psychological screening. This is a very involved process. I don't know that the county attorney's offices are necessarily equipped to start hiring law enforcement officers and complying with the current standards for hiring police officers in New Hampshire. Attorney Halverson had mentioned that the Attorney General's office has certified police officers, and that's absolutely true, that the Attorney General's office has people working there who do have, in fact, law enforcement certifications. But you have to remember that the Attorney General's office is different from any other prosecutor's office in the state. And I say that because, for example, they enforce all of the election laws. So if you go to a local police department and say, I have a complaint regarding an election law, you're not going to have a regular police officer who necessarily has experience in election law, knows anything about election law, or has anything to do with election law. So it makes sense that the Attorney General's office can investigate election law crime. They have a public integrity unit. So it makes sense that they have law enforcement that can investigate those very specialized, specific crimes. Unfortunately, I think this bill would allow a county attorney to essentially create their own police force, which would have statewide authority and may not actually have any policies or accountability. It would give that same authority, it would give that same county attorney no accountability themselves for the actions of this police force that they've created. So in my opinion, law enforcement officers should be hired and supervised by other law enforcement officers within a framework that's already in place in this state, and that elected attorneys shouldn't have the ability to create their own police force. And I'm certainly happy to answer any questions.
Any questions? Representative Birch?
Thank you. Thank you for your testimony. I wanted to clear up what's a little confusing in my mind. What I think the county attorney said was, in terms of hiring this investigator, the county attorney would hire, do the certification investigation, and do the certification, thereby completely cutting out the Police Standards and Training Council, all the other requirements and the like. Assuming this is correct, how would we deal with a situation that could occur in my county where the county attorney already has an investigator who is well known, Mr. McLaughlin, for alleged serious misconduct, but the county attorney says, fine, I'm going to certify you and here's a gun, irrespective of reprimands for misuse of a gun earlier in history?
So I don't think it's true that the county attorney would be able to certify this person as a police officer. The county attorney would have to go through the hiring process that's already been established in administrative law and do an appropriate background check, physical fitness testing, psychological reviews, and all of these things. Once the county attorney hires that person, the person would then have to go to the Police Standards and Training Council, go through the academy, and gain certification. There are certain disqualifiers that would prevent a person from going through Police Standards and Training Council and becoming certified. For example, like you had said, if the person has incidents of misconduct in their past or is, psychologically unstable or that type of thing, Police Standards and Training Council can say, ultimately, we are not going to certify this person as a law enforcement officer. And then the county attorney would have to decide either do I keep them on as a non-certified investigator, or do I then fire them and try again with someone else, essentially?
You clarified the process.
Thank you.
Thank you. Any other questions? Seeing none, thank you.
Thank you.
Sheriff David Croft.
Good afternoon, Mr. Chair, members of the committee. My name is David Croft. I am the Merrimack County Attorney. I am serving on my third term as the county attorney, as the county sheriff. I feel that I'm probably the reason for this bill. You've heard that Attorney Halverson brought it forward because of my lack of being willing to swear in his new investigators. And although that's true, it's not totally true, and I think it's important that I clarify that with you. As Attorney Enders just alluded to, over the last 5 years, we've seen some drastic changes in law enforcement and accountability, and rightfully so. A lot of committees were established at Police Standards and Training to hold questionable officers accountable for their actions, and I think that was way overdue, and we've seen a lot of success with both those committees. But what that did is that raised a lot of concern for me. And just to reiterate, as Attorney Halverson alluded to, I had two of his employees sworn under my badge, assigned down to his office, with absolutely no accountability or knowledge of what they did on a daily basis. So that certainly brought a huge concern up to me, where these men and women were not only carrying my badge, but they were carrying my handcuffs, my pepper spray, my firearm, and so on and so forth. And liability-wise and accountability just wasn't there. So I tried for months to come on board with Attorney Halverson to sign an MOU just to establish guidelines of how my deputies that were assigned to his office could be held accountable. He and I couldn't come to an agreement. And it wasn't for lack of trying, it wasn't a lack of numerous attempts, but it didn't work. And I was troubled by that because I also have a deputy that's assigned to my house of correction. And the folks down there understood my concerns, were very quickly on board to signing an MOU. And all the MOU basically did was just allow those deputies to check in with one of my supervisors on a weekly basis to keep him or her updated on what their daily status was with utilizing their law enforcement authority. So I'm opposed to this bill. I think, I've been in Merrimack County now since 1984. I've been doing this job for a long time. I've seen civilian investigators at the county attorney's office. I can recall a civilian sexual assault investigator that used to work at DCYF, retired from there and went over to do sexual investigations at the county attorney's. It was probably the most incredible investigator there ever was. Never had a badge. My office is open constantly for questions, for assistance from the county attorney's office, as Attorney Halverson alluded to. We talk all the time. We're always comparing cases. I think bringing on this extra police department, it's not only, there is going to be a cost. I mean, nobody's talked about retirement. Are these going to be Group 2 employees? Or are they going to be Group 1 employees? If they're Group 2 employees, obviously that's going to cost more money. So I'm totally opposed to this. Most of my colleagues prior to me pretty much hit on the topics that I wanted to mention, but I did want to come up and say I'm probably the reason for this bill, but I certainly wanted you to have an understanding of what my mindset was, why I did it, and I'm happy to take any questions.
Thank you. Any questions? Oh, seeing none, thank you.
Thank you, folks.
Is there anyone else here that wants to be heard on House Bill 1001?
thank your Honorable Chairman Lynn and members of this committee. I wanted to wait and come up and testify until after all of this was debacled, because there is, you know, this back and forth between two agencies, it seems. I'm going to approach it from a different light. I'm going to give you my background that I did not give you earlier. I'm work closely with two organizations, one in the criminal justice side of things, one in the civil justice side of things with the Family Division and DCYF. I'm not going to name those today, but you can adequately find that with no problem at all by searching my name. I've seen and overseen hundreds of cases in the family court and nearly almost 1,000 cases in the criminal court in the last 5 years. I know exactly 3 of these investigators that are problematic, who used to be on the Lori's list, who had their names exemplified and can now become certified police officers again, even though they were on the Lori's list for decades. We won't, mention their names here currently. These officers, when they were police officers, created huge liabilities for their departments and counties, some of them totaling millions of dollars in federal lawsuits out on the seacoast. That is one of the most notable ones. And that person was, and I believe to my knowledge and retort with the police training standards, is still a private investigator for one of the counties today, and is still creating liabilities for the state, the county, the sheriff's office, the police department that they're actually certified, which is not under the county. And these investigators are going out into the communities representing that, they are, representing the county as a law enforcement officer, and kind of going a little willy-nilly in their investigative tactics. They're encroaching on private properties to do investigations on if people are breaching bail conditions, and the likes of that. So I think this is a highly volatile bill. I do believe that, as you heard from the sheriff's departments here today, that there needs to be oversight further directly regarding this. And I don't think giving that to the prosecutor's office, who, again, no fault to Attorney Halverson, but yes, his job is complicated by not being able to meet his burden, but that is the law enforcement's job to create that burden for him. So I do thank you for having me today.
Thank you. Any questions? Seeing none, thank you. Now, is there anyone else that wishes to speak on House Bill 1001? Seeing none, I'm going to close the hearing on House Bill 1001 and turn it back over to Chairman Lynn.
Thank you. So I know we're running way over. I just want to say, and I'm really directing this to the committee. We've got to get 6 bills that are on the early list exec, and we got to get that done by February 9th. That would be next Monday at the latest. The calendar for next Monday is as busy as this one is. So my suggestion would be, I've talked with the ranking member, and I think that there, of the 6 bills we have to exec, at least with regard to several of them, my understanding from speaking with him and from speaking to my own caucus is that there's not, it seems likely there will not be any dispute as to that. So what I propose to do now is to start executing some of these bills. And what I would suggest is we'll try to do that as quickly as we can. We'll then resume with the hearings at 1 o'clock. And since once we go to hearings, it will not be necessary for us to have a quorum. And so if some of you are hungry or thirsty and wish to get something to eat or drink, step out and do that, and the hearings will continue. Sure. We'll take a 5-minute recess. So I'm going to call the Judiciary Committee back to order, and I want to initially apologize to the public. I know we're first of all, we're behind, and we're under pressure because we have a number of bills that have to be exact and that are early bills. So I'm going to, I know we're behind on opening the hearing on HB 1064, but we're going to delay that for a few minutes. And I'm going to turn to recess the hearing on 1064, and I'm going to open an executive session on House Bill 1671, and the chair recognizes Representative Smith for a motion.
Thank you, Mr. Chair. I move interim study.
Is there a second? Representative Page?
Second.
All right, so it's been moved by Representative Smith, seconded by Representative Page for interim study on House Bill 1671. Representative Smith, would you like to address your motion?
The bill would prohibit state Medicaid payments to facilities that discriminate against employees and others for exercising lawful medical or religious vaccine exemptions. The bill combines civil rights issues and Medicaid laws. The sponsor and others acknowledge the lack of clarity in applicability. The committee concluded that the bill raised important issues but required in-depth consideration before it was ready to be voted on.
All right. Anyone else wish to be heard on House Bill 1671? I guess I would just I want to be heard just very briefly to say I agree with Representative Smith, and I think one of the big issues is getting Medicaid involved in this at all, as opposed to simply a law that would say employers can't engage in the kind of discrimination in question. But that's for another day. I fully support the interim study motion. Anyone else wish to be heard? All right. Clerk, please call the motion is interim study on House Bill 1671.
Vice Chair Mannion.
Yes.
Rep Tripp.
Yes.
Rep Andrews.
Yes.
Clerk votes yes. Rep Perez.
Yes.
Rep Scully.
Yes.
Rep Ball.
Yes.
Rep Birch.
Yes.
Rep Smith.
Yes.
Rep Page.
Yes.
Rep Manos.
Yes.
Rep Turer.
Yes.
Rep Rombo.
Yes.
Rep Bergeron.
Yes.
Chairman Lynn.
Yes.
15 yeas, 0 nays.
Anyone objected to going on consent? All right, we on consent. Representative Smith, can I ask you to write the report?
Yes.
Thank you.
I've already sent it to Paul.
All right. I don't do that. I just don't. I don't. All right. So now I'm going to open up. Return to.
Close the executive session.
Close the. Sorry. I'm going to close the executive session.
Are you putting that on consent?
Yes, we're putting on consent. Yes, and Representative Smith is writing the report. All right. So I'm going to now open the hearing on House Bill 1064 relative to liability of governmental units, and I will recognize our colleague Representative Kutab to introduce the bill.
What is this?
Thank you, Chairman Lynn and honorable members of the Judiciary Committee. For the record, my name is Representative Caitlin Kutab. I'm here to introduce House Bill 1064 relative to liability of governmental units. I want to start by giving a little bit of background on this legislation. In
In 1974, the Merrill v. Manchester decision abolished the common law doctrine of municipal immunity in New Hampshire. Cities and towns became liable for injuries negligently caused by their agents and employees in the course of their employment or official duties and could be held liable like private corporations. In response to this decision, the legislature introduced SB 4 in 1975 to address the issue of municipal liability. Originally, this bill included only political subdivisions and the state, but due to the fact that state immunity was still intact, it was later amended to only cover political subdivisions and to establish a study committee for the state portion. As a result, the law essentially granted towns immunity from liability, except in cases involving motor vehicles, limited liability related to buildings, and then later added to have limited liability for hazardous conditions on sidewalks, streets, and highways only when there is advance notice. After the state statute was so carefully studied and crafted, we never revisited the political subdivision statute to align more closely with the state statute, despite the thorough study of the latter. As a result, towns and schools have very limited liability, primarily related to the vehicle or building operation and maintenance. Last year, a student at a public high school in New Hampshire suffered a serious injury while participating in a career technology education program involving work on a barn. The student fell from a ladder at a height of nearly 30 feet, resulting in paralysis and a traumatic brain injury. Despite the significant height at which the student was working, his teacher failed to adhere to basic safety requirements and to ensure that the students were utilizing the equipment necessary to perform the work safely. As a result of those failures, the student suffered permanent life-altering injuries that will have a profound impact on him and his family for the rest of their lives. The law as it currently stands, however, so significantly protects and limits the liability of the school that this student and his family will likely be left with no financial recovery. In the 1974 Merrill decision, the New Hampshire Supreme Court emphasized the importance of liability in promoting responsible government and ensuring that parties are held accountable for the injuries that they cause to others. This highlights the need for liability to encourage proactive risk mitigation in high-risk programs. They further emphasize that compelling a citizen to bear his loss himself when injured by the negligence of a municipal employee offends the basic principles of equality of burdens and of elementary justice. The proposed bill aims to align political subdivision liability with that of the state, which has been in effect since 1976. It seeks to indemnify employees of political subdivisions similar to state indemnity from personal liability when they're acting within the scope of their employment or office, provided their actions were not wanton or reckless. Previous attempts to address this issue were hindered by concerns about potential effects on qualified immunity, which really means official immunity because qualified immunity actually applies to constitutional violations, where official immunity applies to common law torts such as negligence. The approach, however, taken in this bill ensures that such effects will not occur, as it mirrors the state statute that has been in effect since 1976 and provides assurances that state employees, including state troopers, are not being personally sued. The language was carefully worked through with a group of multiple attorneys, and I'm happy to take any questions. I have the whole legislative history and all of the case law relative right here in front of me.
Questions for this witness? Seeing none, thank you very much. Okay. Next, I'd like to call on Representative Gabby Grossman, please. And I'm going to ask that because of time constraints, that except for the sponsor of each bill, for the rest of the people that are testifying on any bill, not just this bill, I'm going to ask you to please limit your remarks to 3 minutes if you would. Afternoon.
Good afternoon. Good afternoon, and thank you, Chairman Lynn and honorable members of the Judiciary Committee for the opportunity to speak today in support of House Bill 1064, relative to the liability of governmental units. My name is Representative Gabi Grossman, and I represent the town of Exeter. I'm here today as a legislator and a parent to a 17-year-old son that suffered from a traumatic and devastating 30-foot fall while working at a job site through our public school high school program on February 5th, 2025, almost a year to the moment right now. He sustained multiple life-threatening injuries, and thanks to a med flight and his care team at MGH, Oscar is alive today. His entire skull was removed in surgery within hours to reduce the swelling of his brain, which we now know saved his life. He's still fighting hard to walk and recover from his traumatic brain injury and spinal cord injury, which requires constant care and rehabilitation. Our lives are forever changed, not to mention the emotional toll this has had to his twin brother, his brother with autism, our entire family and community. It was our community and medical team that supported us through this nightmare. Oscar spent 3 months in the ICU and another 3 months at Spalding Rehabilitation for intensive neurological and physical rehabilitation. What should have been a safe and positive learning experience became a painful and deeply traumatic event for our family and community. Oscar loved all things HVAC and trades, dreaming of owning his own business someday. Through this horrifying experience, we saw how difficult it can be to pursue accountability because of our existing statutes shield governmental entities with very limited liability and caps on damages, even in cases where negligence has clearly occurred. HB 1064 seeks to address this imbalance by ensuring that government organizations, just like private ones, are responsible for their actions or inactions that lead to harm. This is not about blame or financial gain. It is about accountability, fairness, and safety. When our laws ensure that public programs are held to reasonable standards of care, everyone benefits, families, schools, and communities alike. The current caps on damages has a huge impact on families that love and care for individuals that are forever changed like ours. In a case of catastrophic injury like my son, even the maximum recovery under the present law would cover only a fraction of the medical expenses our family has already incurred for his care, and it fails completely to account for the care and treatment he will likely require for the rest of his life. By protecting our government entities, the existing law shifts this immense financial burden from the responsible party onto individuals and families already shaken by tragedy. I urge this committee to vote ought to pass on HB 1064. It is a balanced and necessary step toward ensuring that all New Hampshire families can have confidence in the institutions that serve them. Thank you for your time, your service, and your consideration. And I do have a few photos that I can pass around to you, but this was Oscar and his twin brother Oliver the summer before the accident when they were volunteering at an adaptive water skiing program for their brother with autism on Squam Lake. Oliver's sitting in a sit ski and they're just having some fun. This summer, Oscar will probably be sitting in that sit ski, participating now as a participant and not as a volunteer helping. And there are some photos as well from the ICU that I'll pass along.
Thank
you.
Questions for this witness? Seeing none, thank you very much, ma'am. Next, I'm going to call on Mark Bodwin, please. Bodwin?
Good morning, Mr. Chairman, and members of the committee. Thank you. My name is Mark Bodwin. I am a member and here to represent the New Hampshire Police Association. I've been a former director of the association. I'm a retired trooper as well, too. And I know before you, you have a document that was submitted to you by the State of New Hampshire Employees Association of New Hampshire. I'm not going to take up a lot of your time because a lot of my comments would mirror pretty much with what is written in that document that's submitted to you. I just want to say it's heart-wrenching to hear a story that was just presented, and it's completely understandable that you'd be looking to sue the city or the town or wherever this was from. However, the issues that the NHPA has with this legislation is that there's a change here, and the changes can come with unintended consequences. This could open this up a lot more liability for both cities and communities and employees as well too, that are just trying to perform their functions as a public employee. Some of the things that are concerning are some of the language changes in there, such as it says appropriate standard of care in one of the lines. I'm not entirely sure what that is supposed to mean. There's another thing where it says property damage is allowed when equity and good conscience require. Again, I'm not entirely sure what equity and good conscience means. And these are the types of things that I'm talking about that could have unintended consequences, as this would need to move through the court system and have the court try to interpret what those actual definitions mean. So there's some concerns there. So the concerns, as the SEAO also pointed out, was the expanding of liability exposure for public employees and employers. Like I said, the mandatory indemnification language is kind of misleading and insufficient. Undermines discretionary function protections because it then limits exclusion to executive discretionary or planning function rather than just discretionary function. The inclusion of an exclusion will then tend to water down official immunity as well too. And it will increase costs to taxpayers and public services. As a taxpayer myself, I know that my property taxes are significantly high, and they continue to climb every single year, especially during the March warrant article season. But this is something that would also cause towns to have to plan for increased litigation costs and increase in policies. Another issue from an employment perspective too is, again, this is,
sorry, you're up at your 3-minute limit, so I'd ask you to please.
I'll wrap it up real quick for you, Mr. Chairman. Will worsen recruitment and retention issues of public employees that we're already having issues with. And there's already existing laws here that take care of this. Finally, there's also a concern with Article 28A of the Constitution, because it's a mandatory requirement to the towns. May have some impact on that as well too. So we would urge you that you would inexpedite the legislature on this due to all the issues that are outlined as well in the written testimony that was provided by the SEA.
Great. Thank you very much. Questions for this witness? Representative Birch.
Thank you, Mr. Chair. Would you concede that some of the language that you said would be hard to define are already in the law under Section 541B1, and that the courts interpret the terms that you raised a question about all the time as part of their job, and they've been doing it historically?
They have, and that's it. The reason why the Supreme Court is to try to interpret the law and interpret some of these. And some definitions have a long history of, it's been defined by case law after case law after case law. These would be new terms, and we don't know, some of these would be new terms, and we don't know how that would roll out and what the decisions would be. So that would be the concern. The overarching concern here is that it would have unintended consequences that we just want to be very careful about.
All right. Other questions? Oh, I'm sorry. Yes, Representative Smith.
Thank you, Mr. Chair. Do you believe that when an individual becomes a public employee, during that entire time that the individual is a public employee, that individual should not be held responsible for actions that in another context would be inappropriate, unacceptable, whatever.
Individuals and public employees are held accountable all the time for their actions. They can be disciplined, they can be terminated, they can be removed from their positions. I think we're talking about a couple different things here. We're talking about official immunity. We're talking about indemnification issues as well too. But this opens up litigation, for municipalities and counties, and for decisions that you want your public employees to be able to make without the fear of litigation.
I could just follow up.
Yes.
I guess I want my public employees to behave with impeccable standards. And if they're not, I think they and their employers should be held accountable. And after all, in the private sector, they would be. Why would they not be held accountable here? I assume that there are very few bad apples. And in this case, it might have been a very good apple. I have no idea who was just at that moment acting inappropriately. But the result has incredibly important implications for the whole community. So I don't understand why you would think that accountability is not
I'm not
good.
Yeah, I'm not saying that they shouldn't be held accountable, and I can't speak to this specific incident that was just discussed because I don't even know anything about it. I can tell you that they are held accountable. Like I said, they could be disciplined, terminated, and such. But then you're also opening up what this bill really is looking to do is to open up the possibility of towns and counties to be sued, whereas now they're sued under very limited circumstances. You're asking now to open this up, and there's implications when you start opening that up a little bit further and saying, okay, we're going to sue for a little bit more here, a little bit more there. What happens there now is, again, this goes back to, and you're right, you're absolutely right, it does affect the communities and the people in the town because it affects their taxes as well too, because there are going to be increases to liability insurance. There may be increases to other costs, litigation costs associated as well with the towns too. So I'm not saying that I don't want anybody to be held accountable. I mean, I think people should be held accountable. I'm just saying be careful what you're wishing for when you start looking at this and trying to adjust the statute. That's been around for a long time.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on Holly Haynes, please.
Thank you, Chairman
Hi,
Lynn.
welcome.
And thank you, members of the committee, for hearing my testimony today. I'm here to speak in support of House Bill 1064 and ask that you vote to pass. I know that there have been quite a few concerns raised by the New Hampshire Municipal Association and by Mark Bowden from the New Hampshire Police Association. And I just wanted to address briefly some of those concerns and explain to you why I don't believe this statute is going to result in any significant increase in exposure and liability or in claims for municipalities. First of all, my name is Holly Haynes. I'm an attorney at Abramson, Brown & Dugan in Manchester, New Hampshire. I'm a resident of Ware, New Hampshire, and I have been practicing medical malpractice law on behalf of plaintiffs for the past 20 years. New Hampshire is a very small bar. There are not a lot of attorneys here, and I think I have I'm a former president of the New Hampshire Association for Justice, so I feel I have a good feel for the types of claims that are being brought by other attorneys as well against municipalities. This statute the proposed changes to the statute have very minimal changes, and it's a very small increase in damage caps. It's designed to address a very unique situation it was actually our office that was unable to bring a claim on behalf of Representative Grossman's son. And it pained us tremendously to not be able to bring a claim on her behalf. But it's very difficult to bring claims in New Hampshire. And the reason this isn't going to result in any flood of claims or consequential change to the reserves in municipalities that they already have for claims is because attorneys just don't bring frivolous claims and they can't afford to. The system already has so many built-in protections to prevent that, that work, and they prevent frivolous claims from being brought. First of all, attorneys like our office, we work on a contingency fee basis. We front all of the costs for investigating these claims, for hiring expert witnesses, for bringing these claims. This can cost sometimes hundreds of thousands of dollars to bring a claim forward. At least in the medical malpractice case, it could cost thousands of dollars in a smaller claim. Second, we're required, and in this case, I appreciate that Mr. Bowden raised the change to the language to the standard of care. That's the same language that's required in the statute for medical malpractice cases. And when you're dealing with standards of care, it requires you to hire experts to deal with that. And supporting claims with testimony from independent experts on the required elements of liability and causation, it's not an option. If a plaintiff can't get an expert to support their claim on what the school employee should have been doing, what the police officer should have been doing, what the bridge builder should have been doing, how it should have been designed, the claim is not going to be able to be brought forward. These are independent experts who have to be willing to testify. So it's very difficult to bring any claim that's not frivolous. Third, if we bring a case and lose at trial, the plaintiff and the plaintiff's attorney is responsible for those costs. Plaintiff's attorneys aren't going to bring claims because they're responsible for their own costs, and plaintiffs, if they lose at trial, may be responsible for the other side's costs. It's a very expensive gamble if you don't have a very solid case supported by expert testimony on every element. Fourth, New Hampshire is a very small bar. Our reputation means a lot, as does the reputation of expert witnesses who testify in New Hampshire. No one is going to bring a claim or testify in a claim that they don't feel is valid.
Ms. Ames, your 3 minutes is up. Can I just ask you to finish up, please?
Yes, Chairman. I just want to give you an idea of how rare these claims are. 5 years ago, our office actually calculated the claims data for cases that we take. We average 150 calls or emails at that time from plaintiffs each month asking if they have a claim. It's approximately 1,800 contacts a year. Of those, we requested records for review by an expert on average in 1 out of 10 cases. Out of those, we probably filed suit in 1 or 2 of the cases that we had reviewed by medical experts. We bring claims in less than 1% of the suits that we are contacted about. It is a very rare thing, and I believe that most other attorneys in New Hampshire feel the same way. And municipalities already have reserves set for claims. Those shouldn't change with this mild increase in the damage caps.
All right. Thank you very much. Questions for this witness? Yes, Representative Page.
Thank you. Thank you for taking my question. Thank you for testifying. So I'm guessing that, and we've already had a taste of it, but we're going to hear more testimony that's sort of going to be a parade of horribles if this legislation was passed. But if I'm hearing you correctly, it sounds like the marketplace of the law has a way of winnowing out claims that might be frivolous or costly, that the lawyers, plaintiff side lawyers, have a way of monitoring and self-regulating, because of all the reasons you said, to sort of self-regulate, I guess, to make sure that the claims that have merit ultimately see trial or filed or whatever, right? Is that fair?
That is absolutely fair. You hit the nail on the head. And if someone brings a claim without merit or not supported by expert testimony, the judge is going to take care of it and dismiss the claim.
Thank you. Other questions for this witness? Seeing none, thank you very much, Ms. Haynes.
Thank you, Chairman.
Next, I'm going to call on Barrett Christina, please.
Thank you, Chairman Lynn. Good afternoon, members of the committee. Barrett Christina, Executive Director of the New Hampshire School Boards Association. We are opposed to House Bill 1064. Our biggest concern with the bill is that it's going to shift the priorities of school districts away from providing an education to our students and rather put them in a defensive, bureaucratic mode of focusing primarily on risk behavior rather than educating students. The other concern that NHSBA has is that our public schools and our public school grounds are seen as a heart or the heart of many of our communities, where we open up our school facilities and our school grounds to members of the public. The library may be accessed by members of the community. Most schools have a policy that allows outside groups such as a church club or the Boy Scouts or the garden club to come in and use school facilities after hours or after the weekends. Our playgrounds are used by everybody in the community. And as I'm sure everybody on the committee knows, we're in annual meeting season on any given night for the next 2 or 3 weeks. And the next 6 weeks, we're having dozens, if not hundreds, of people from the community entering our school grounds for the purposes of deliberative sessions and annual meetings. Our concern is that by increasing or by removing some of the immunity provisions within current law, our school districts are going to be focused on risk aversion. Do we close the playground to members of the public on the weekends? Do we stop allowing these outside groups to come in and use our school facilities if we're going to have increased risk and increased potential litigation? So those are, in the interest of time, I'm going to sort of limit my comments to that, is that if you want school districts to still be sort of the center of the community and allow great public access for outside organizations for using the playground for annual meetings, we need to be mindful if we're opening up additional liability to school districts and putting districts at risk under this bill. So with that, I'll close my testimony. Happy to answer any questions.
Questions? Yes, Representative Smith.
Thank you very much for taking the time to be here. I've read this bill a couple of times, and can you show me in the bill where there's any mention of the situations to which you refer? Every place that I look, it talks about an employee or official of a governmental unit having acted with wanton disregard, or whatever the language is. I see no place at all where any public employee would be held accountable for a wanton or reckless action by anyone who is not an employee.
Thank you for the question, Representative. Well, the liability attaches to the governmental unit, but the liability attaching to the governmental unit can be attached due to the actions of an employee. Page 1, lines 4 through 6. The governmental unit may be held liable for A, bodily injury, personal injury, death, property damage, so on and so forth, caused by the government unit or its officials or employees acting within the scope of their authority when the appropriate standard of care when that duty was owed. I mean, so we're removing the immunity provision and putting a simple liability standard and a negligence standard. Was there a duty owed, and was the action reasonable under the provisions, rather than, as the previous speaker talked about, the difference between sort of liability, immunity, and indemnification? This bill changes that.
Yes.
I hear exactly what you say, and I obviously wasn't speaking clearly enough. My point is, I see no place in here where the governmental unit would be responsible if someone comes in, if a citizen, if an individual comes into, that citizen used to be a good word, now it's, an individual goes into a library and has a problem, and a family is playing in the playground, and I see no place in this where the public employee or the public entity is going to be held responsible. This talks only about someone whose responsibility is to work in the gym, to be there when the kids are there. And that is, in fact, part of that person's official responsibility, or doing anything else. I have no patience, truthfully, and I guess I have to say it, for people who come and you didn't, but people who come and say, well, you know, this is going to raise the property taxes. I mean, we choose to pay everything with property taxes. That's our choice. What I'm concerned about is I don't think you said anything at all that had relevance to this bill, because this bill is not talking about people who recognize the importance of public schools and worship public schools and use public school facilities and have an accident. This bill talks only about public employees. Tell me where I'm wrong.
Thank you for the question. I guess we'll disagree on that. Appreciate the lecture. Thank you. And with that, Chairman Lynn, I'm not going to take any more questions.
I do apologize for the lecture. You're absolutely right. I wanted to put it within the context of support for public schools.
Thank you, Representative. Thank you, Chairman Lynn.
Thank you. All right, next I'm going to call on Sarah Burke Cohen, please.
Good afternoon. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. The New Hampshire Municipal Association opposes this bill, although we support fair compensation for injured residents. NHMA opposes this bill as it goes too far and shifts immense financial risks onto local taxpayers, which in turn could threaten essential services, risk pool stability, and the fiscal stability of small towns. We've talked about this is going to expand liability for municipalities. I understand, I think I understand what the previous person testifying the question being raised was. This isn't just holding responsibility of negligence to employees. It is going to cause defensive governing. That means that municipalities are going to have to really think about what they're doing, community events, playgrounds, services they're providing, because if someone falls, if someone is injured on their watch, that means a lawsuit can be filed. That's what this legislation does. And I appreciate previous testimony about the potential for frivolous lawsuits not being filed, and that the statistics that was presented indicates that frivolous lawsuits aren't filed currently, but that's under current law. People understand what current law looks like and may not file those claims. If people are filing claims, the other issue to consider is sometimes they don't get attorneys involved. They file claims themselves, they settle. Municipalities will be more likely to settle weak claims because as litigation progresses, that means more time has to be spent not providing services to the public, but rather preparing for litigation. It does take time and effort for litigation, not just by the attorney, but those that are going to be deposed and have to gather evidence for things. At the end of the day, this is going to increase property taxes. Insurance caps will because the insurance cap is increasing, so too will the premium amounts. It could also cause instability for risk pools depending on how many claims are made. Additionally, with mandatory indemnification, there is loss of local decision making relative to indemnification that is currently in statute. In some, this is going to cause a massive shift in municipalities that is going to be detrimental to both the taxpayers and public services that are able to be provided. I'm happy to take questions.
Questions for this witness? Yes, Representative Page, then Representative Perez, and Representative Birch.
Thank you. Thank you for taking my question. I think I heard you correctly in saying that if this bill passed, municipal employees and entities would then have to think about how they operate in a defensive posture, at least to reduce risk, I guess, or injury. Is that right? Are they not doing that now?
First. Thank you for the question. Yes, governments are looking at risk aversion now. But with the introduction of this legislation, if it should pass, that means every single decision they make, they may feel like they need to talk to their legal counsel about it. Is this community event going to open up? Have we had injuries in the past? What does that look like? For example, Concord has a community event called Winterfest. They're sledding. Do they want to still offer that on public property? Have there been injuries? What does that look like? Is that going to be costly? Are people going to continue to, or will people file claims in response to that? So I think that municipalities are looking at risk aversion, at trying to determine what risks are out there when they're providing services. But I think this will make them really have to determine to a greater level whether the balance of whether this is going to cause multiple lawsuits or not. Right now, I think they do weigh that. Is this going to cause injury to people? But if this opens liability to a negligence standard, injury could be an injury not as catastrophic as one that happened, and it's the litigation that costs money too.
Representative Perret.
Thank you. Thanks for taking my question. A couple of things that you said. You used the term on their watch. So if an event is taking place and it's on their watch, which means you would have municipal employees, okay, involved in it, then they should be watching what's going on and be. As far as things like festivals and stuff, I know my town, we just changed our old home days over from being a town run to a volunteer run. So if it's volunteer run, that takes the liability away from, because the employees are not the ones. My concern is that sometimes it's not all about the money, that it's going to cost the taxpayers more. Sometimes it's more about what is right and protecting the innocent that are hurt because of neglect or not thinking by a public employee. And I think, don't you think that public employees at all times, at all 100% of the time, that their foremost thing should be, I mean, I was a nurse for 42 years. Every time I stuck a needle in somebody, I was careful to make sure I didn't do it wrong. I wasn't protected by anything except my insurance that I kept myself. This is a no-brainer to me. If you're not doing what you're supposed to be doing, why shouldn't you be liable? We're not saying, I don't know. I just think, I think you're making this more about, oh, it's going to cost the taxpayers and, they'll be defensive and all that. That's not what we're talking about. We're talking about individuals being catastrophically hurt by a neglectful act. Don't you agree that there's a big difference between a neglectful act and just going to work every day and doing what you're supposed to do and watching your back? I mean, and, doing what you're supposed to and watching what you're doing?
To answer, I think, your question, I think there's previous testimony regarding this. There is already a system in place of accountability for individuals, that if something happens, people get terminated, disciplined, etc. I hear what you're saying, that this isn't necessarily about money, it's about accountability. But this bill also includes an indemnification, a mandatory indemnification. So it is, in fact, not the individual that will be at risk. It will be the municipality or the governmental unit.
Representative Birch for a question. Thank you.
Thank you, Mr. Chair, and thank you for your testimony. I may be echoing a theme here, but my question involves the prior testimony and your testimony, which involved a balancing between, in one case, teaching and risk aversion. That's how it was phrased. Your phrasing was perhaps different, but defensive, governing versus regular work or whatever. My question has to do with the complete absence of the word safety that I've heard yet in the testimony. So my question to you is it not true that the more you give immunity to somebody or some group, the less they pay attention to the consequences of their actions because they have immunity?
I would not agree with your statement.
All right, any other questions for this witness? Representative Mannix.
Thank you, Mr. Chair, and thank you for taking my question. I heard you say that the NHMA opposes this bill, but you support compensation. And without liability, how can there be compensation?
My understanding, there is some liability available under the statute currently. So there is compensation in certain circumstances.
Yeah.
So is it the increase in the levels of liability that the NHMA opposes? It's set out on page 1, paragraph Roman numeral, lines 26 through 31.
Increasing the caps and liability will likely increase the premiums that municipalities will be required to pay.
Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Nicholas Klein, please. Button. There you go. Thank you.
Good afternoon. Thank you. My name is Nick Klein. I'm a partner with Shaheen and Gordon. I live over in Dover. And I'm testifying in support of House Bill 1064. First thing I guess just to say is related to the caps. I think the last time this statute was changed was 2018. It moved from $275,000 to $325,000. And of course, the statute loses its effectiveness over time if those caps aren't updated. I would also say that this House bill amendment brings municipal caps into line with state liability caps, $475,000. And the vast majority of these claims are not statutory cap claims. So amending that cap is obviously the right thing to do for people who are extremely hurt, like Representative Grossman's child. And I just doubt it affects the majority of claims. And I think it's the right thing to do related to the cap. The second thing, I wanted to compare 507B, which is the municipal immunity statute, what's being amended here, with 541B 19, which is the immunity statute for claims against the state. And I've said before many courts now that the statutes work in opposite ways. RSA 541B 19 allows all claims against the state, except for a couple that it enumerates. 507B works in the opposite way. It prohibits any claim against a municipality, except for claims that relate to streets and sidewalks and premises. And I should say that even those claims, especially related to streets and sidewalks, are limited by statute. It's RSA 231. So I don't think there's any fear about runaway claims related to cracks in sidewalks. It's just not the way the existing law works. So what is between those two things? All claims that you can bring against the state versus these very limited claims you can bring against municipalities. And one answer is that there are already a lot of municipal immunities that sort of reduce that number of claims that can be brought against municipalities. So as I think someone brought up earlier, when a volunteer is involved in not being paid, you can't bring a claim against a municipality for that. It's a separate statute. There's a recreational use immunity statute. We were discussing playgrounds earlier, very difficult claims to bring when there's been no charge for, for use. Certain legislative functions as well. So what is in between what we're talking about is oftentimes these sort of in between claims like the child who was hurt on the ladder while he was participating in programming. That is a claim that RSA 507B prohibits right now. It's a claim that would be allowed against the state. And
Mr. Klein, your time is up, so I'd ask you if you please, if you want to wrap up, that would be important.
sure, if we enact 507B, this provision, House Bill 1064, it will fix that. Those claims will be allowed. It will be in line with liability and immunity statutes with claims against the state. And it would restore that balance, as has been discussed, about accountability. When someone does something wrong, does not behave in accordance with the standard of care, and someone else gets hurt who has, they can bring a claim.
All right.
And I urge the committee to pass. Thank you, Mr. Chairman.
Questions for this witness? Seeing none, thank you very much, sir. Is there anyone else who wishes to testify on House Bill 1064? Seeing none, I'm going to close the hearing on House Bill 1064, and I'm going to open the hearing on House Bill 1116, and Chair recognizes Representative Jack Flanders, the primary sponsor of the bill. Flanagan, I'm sorry. Flanagan.
Representative Flanders.
Flanagan, sorry about that.
That's okay. Would you like to take a break or anything?
The answer is I would love to take a break, but we're not going to because we got too much to do.
We're only halfway through the day.
Well, thank you, Mr. Chairman. Thank the members of the committee for listening. And thanks for coordinating. What ended up being a trip never happened because the plane never got off the ground during a snowstorm. For the record, my name is Jack Flanagan. I represent Hillsborough 45, which is the towns, the large electoral, of Hollis, Brookline, Mason, and Greenville. I bring you a bill with almost two parts, this bill and actually another bill later on. And the reason why there are two parts is because OLS were cutting off the ability to introduce legislation, if you remember back, what was it, in October or November. And there was also an amendment to this bill on 1116. Mr. Chairman, I think I sent an email to you, but I had copies made yesterday that was going to be.
That's Amendment 362H, is that right?
I believe so, yes.
Yeah.
And that, to give you a little background, is I've been working with various members of the Judiciary to put together this bill. The first part deals with judicial privileges. I should probably give you a preamble of where that came from. I'm good friends with the Marconis, Justice Marconi and, of course, Gino Marconi from the Seacoast. As a matter of fact, I know other family members, too. I've known them for at least a decade, if not longer. And I understand that there's a policy in the Judiciary, Supreme Court, that says that if you're subpoenaed and you had first-hand information, that you have to answer the subpoena. Well, our Supreme Court Justice McDonald did not do that. He ignored his own policy. So the purpose of the first part of this bill is to codify that policy that says it is now law. If you get subpoenaed and you have first-hand information, you must answer the subpoena. No maybes, not when I can get around to it. It's you have to answer the subpoena. That's sort of bothering to me because I know the merits. I know the whole issue of that case with Justice Marconi. And there's enough time in this hearing date to tell you what I know. But anyway, that's the first half.
I have something called 0362.
Yeah.
That says it replaces
Section 2. It's, in other words, Section 1 of the original bill would remain.
Right, that's the judicial privileges. Right.
Right.
And I'll explain that to you, Representative Smith. Just give me a second. No, I'll always be happy to answer your questions. I know, I heard that.
So what happened was, when I originally introduced this bill, you might see from the original copy, was I had some personal experience with small claims court. And it took 60 days to get service. In the old days, it was 10 days via certified mail. So I said, this is ridiculous. And then after I got judgment, which the judgment wasn't verified because the person didn't get their mail or whatever it was, but they required another 60 days to enter default judgment. So the person, if it was not a business and say it was an individual, they could have skipped town because you've got almost 6 months to play with the system. So I put in a bill that said that you had to get service within 10 days. Well, I heard from the circuit court, Judge Christo, and we had a long conversation, very nice woman. And she agreed that we should probably have a committee to establish maybe some improvements to the e-file system that we had, especially in her comments was the email system that they used is just not working out. So with her advice, we drafted the amendment that I attached with this for section 2. So the first section deals with codifying the subpoenas. The second section deals with a process in which the small claims court, district court, or circuit court rather, can improve the process. And that's with the help of the circuit court. And I think that pretty much nails it down. I honestly believe that if a agency, whether it's a judiciary or a Department of Justice or any other agency, has a policy that they choose to ignore, then it's our responsibility to make sure that that is codified and then they were violating the law if they choose to do it again.
Questions for this witness? Yes, Representative Birch.
Thank you, and thank you, Representative Boyce.
Good seeing you, Representative Birch.
My question is about the first part, about judges testifying.
Yes.
And I want to ask you if you intended to make this bill include not non-judicial firsthand observations, the ones that also occur within the judge's chambers or activities that the judge does, might be talking with the law clerk or whatever. So I want to know, do you want this bill to require a judge to testify about matters within their official duties?
Oh, absolutely. If it's within their official duties, by all means. I mean, in this case, Representative Birch, he's got a habit of doing this because he just recently did this with other judges and the legislature, advising them to go talk to the legislatures. In the case of the Marconi instance, he encouraged her to go talk to the governor, which started this whole cascade. And then he refused to be deposed. So the question is, I think you're asking is, would that be considered a personal conversation? I think so.
If I could follow up.
Always.
What I'm and there may be an argument about whether that's part of the judicial function or acting as a friend or whatever. But my question is, would this allow a judge to be subpoenaed to discuss a conversation with law clerks as they work on issuing an opinion or things like that? Because it would seem to cover that.
I see your point. One is more of a personal conversation, whereas, right, and how do you weigh that? I guess it would have to be then the trying judge if you had if the person refused to provide the information, that the judge would then have to use his purview, I suppose. I didn't really give it much thought because, I mean, if you have there's certain discussions that are protected under 91A anyway. So I'm sort of spitballing this here because I don't know legally, and I know you're a counselor. I don't know if there's a situation would arise that what you're saying could come to fruition. In the case, an example that I cited is by all means, it's germane to a legal case. So maybe it would be only if it was a legal case involved, but that would be a deposition, and that's sort of what we're addressing here. I don't know if that answers your question, but it sounds like it might be one in a million, but I understand what you're saying.
Other questions for this witness?
Seeing none, thank you very much, sir.
Wow.
I'll
I'll see you at 3:30 maybe?
Is there anyone else that wishes to be heard on House Bill 1127? Oh, I'm sorry. House Bill 1116. Anyone else?
I put my card for the other bill, but we've got a little time for
Yeah,
that
we got a
too.
little time. All right. Oh, I'm sorry. Did you want on the bill we're now hearing? Oh yeah. Well, come on up.
Come on up.
Please come on up.
Let me get out of your way.
Good afternoon, honorable committee members. My name is Lauren Warner, Deputy General Counsel for the Judicial Branch. I didn't plan to testify in this bill. It's just Representative Birch, brought up a good point as to the scope of this bill. I would just note there are some cases to say, and how I was understanding your question would be potentially a conversation between a judge and a law clerk as to a case in front of them. For an example, a domestic violence matter. Those are closed cases. They're confidential under statute. If a judge, by some hypothetical reason, was brought into another criminal matter, asked to be essentially subpoenaed to discuss their work on that case or their discussions on that case, that would violate, there are instances where that would violate a state statute. There are certain confidential cases, domestic violence ones, certain child protection matters, and the like, that where a judge would legally be unable to discuss the case and whether or not they were subpoenaed. That's all I wanted to note.
Questions for this witness? Seeing none, thank you very much.
Thank you.
All right. Anyone else who wishes to be heard on House Bill 1116?
Could you just put a pink card in quickly for that, if you don't mind? Thank you.
Oh, yes, thank you. All right, seeing none, I'm going to close the hearing on HB 1116, and I'm going to turn the chair over to Vice Chair Mannion so that I may introduce House Bill 1127.
All right, thank you. We're going to open up the hearing on House Bill 1127, and I recognize Representative Lynn to introduce this bill.
Thank you, Mr. Chair, members of the committee. I'm here as a prime sponsor of House Bill 1127, which proposes to update to make it consistent with the Commission on Uniform State Laws, what is now known as the Uniform Fraudulent Conveyance Act, and it adopts the Uniform Voidable Transactions Act. It makes a number of changes to the law in this area, which basically is designed to protect creditors' rights. And I guess I have to say, and this is, I don't want to say I'm not familiar with this area of the law. I am familiar in general with this area of the law. And I went through with Mr. Mooney, who is a commissioner, the various sections of the law, the various sections of the proposed bill, which I think make appropriate changes to the existing law and make it consistent with what the uniform commissioners propose as what should be the law, and I think is the law in many states. But in terms of the details of how some specific provision differs from what is now the law, you will be taxing my memory if you ask me questions along that line, and I think Mr. Mooney might very well be in a better position to answer those questions. The one thing that I would say, and I hope that somebody who's going to be testifying after me will address, is I know that there was a concern raised by Mr. Perlow, and maybe there's others that have this, about some potential that this proposed legislation would interfere with certain kinds of trusts. I'm not completely clear that I understand how the interference would be, and I hope somebody will explain that. Obviously, if there is interference and it's, something that would be a bad thing to do by public policy wise, then sure, we should make an amendment to the bill so that we don't do that. But I hope somebody will explain exactly what the concern is. And with that, I'm happy to take any questions.
Any questions? Representative Manos?
Thank you. Thank you, Mr. Chair. I don't want to tax your brain in this subject area, but I was just wondering if you know page 8, the section titled Application to Series Organization. I'm an attorney, but I'm not familiar with this area of the law at all. Do you happen to know?
You and I are on exactly the same page, because what I do remember is having a specific conversation with Mr. Mooney in which I asked him, what's a series organization? Okay, and he gave me the answer and I understood it. But as I sit here right now, I have to tell you, maybe I'm having a senior moment. I don't remember what the answer was, but there is a good answer, and I'm sure he has it.
Okay, thank you.
Any other questions? Seeing none, thank you. Charles Mooney, the man with the answers.
Good afternoon, Vice Chair Menyon, members of the committee, and I thank Chairman Lynn for not putting any pressure on me. I'm one of the 2 appointed commissioners on uniform state laws in New Hampshire. And since this is the first time I've testified before the committee, I thought I'd take just a minute or two to explain something about the Uniform Law Commission. I'm sure some of you are familiar with it, but it's composed of volunteer attorneys that provide states with nonpartisan, well-conceived legislation in areas that states need to have legislation on. The commissioners are practicing lawyers, judges, legislators, legislative staff, and law professors who've been appointed by state governments. And New Hampshire has enacted and has on the books more than 50 of these uniform laws, including the Uniform Fraudulent Transfer Act, which House Bill 1127 would update. The Uniform Fraudulent Transfer Act that's on the books has been around for quite a few years, and it was updated by the Uniform Voidable Transactions Act, which is incorporated in HB 1127. It's a result of a multi-year project with drafting committees meeting for 2 days at a time over more than 2 years, and ultimately a vote by the states at an annual meeting of the conference. Some of you are familiar with fraudulent transfers, and I think Chairman Lynn explained very well. These are to protect creditors, and the general idea is that if I'm a debtor and I transfer an asset with the intent to hinder, delay, or defraud a creditor, put it out of their reach, or transfer it and don't receive reasonably equivalent value, coupled with my insolvency or financial distress, then that transfer can be avoided, bring it back into my estate for the benefit of my creditors. The bill addresses, and that basically does not change, some tweaks, but no basic changes in this bill from current New Hampshire law. There are a couple of important things it does do, which I believe bring certainty and clarity, and practicing lawyers have talked about this quite a bit. One thing it does is adds a governing law rule, which is not in the current statute, and it provides that when there's a transfer and the creditor has a claim that it should be avoided under the Act, it's governed by the law where the debtor is located. And that makes some sense because that's likely where most of the debtor's creditors are located. And also that's the place where under the Uniform Commercial Code, one would file a public filing when there's a security interest in personal property where the debtor is located. A second clarifying change is on the standard of proof. And it would make the standard of proof for a claim to set aside to avoid a transfer the preponderance of the evidence, which is the standard for most civil claims. Some case law holds that that should be a clear and convincing standard based on the idea that common law fraud often had that standard of proof, but the fraud in this act is different even when it's intentional. Moreover, there are lots of transactions, as I mentioned, for an undervalue where there's no fraud at all, just a need to claw the asset back. So preponderance of the evidence is proposed to that standard. Before I forget, what is the series? Well, there is a uniform law that deals with series, and a number of states have adopted that or have their own series laws. And it's simply the idea that a legal entity, say an LLC or a corporation, can in effect divide itself into series, and each of those series will have their own assets and their own liabilities. So instead of the entire entity being liable for obligations, each series is separately liable. And it's simply a way that companies can do this without having to go through the process of having multiple subsidiaries or affiliates, which they could do that exactly with that method, but this makes it an easier and more straightforward way for a company under common management to have these separate series, and they're treated like persons under these statutes. Finally, as Chairman Lim mentioned, the New Hampshire Trust Council has raised some concerns, and I believe they submitted some testimony, and you will hear from them, in particular about the choice of law and the burden of proof. On the choice of law, these spendthrift trusts that are organized rely heavily for assets coming into New Hampshire on the law where the trust is located. The trustee is located, not the debtor. And it, I think, would be a serious interruption to the business plan if that were changed. Similarly, there's case law on clear and convincing evidence. My view is that we should have the Uniform Voidable Transfer Act enacted as good law for general applicability. But given the New Hampshire public policy with respect to these trusts, I don't think that the process of enacting a uniform law should be the forum where we should try to examine that whole thing. If the legislature wants to do that, that's fine. But I would prefer to make amendments to the statute which essentially preserve the status quo for those trusts in New Hampshire, but get the benefits of the increased clarity and modernization of the statute as a general matter for debtors and creditors in New Hampshire. So I urge your support for HB 1127 with any necessary amendments, as I mentioned, relating to these transfers to these trusts, and I'm happy to answer any questions you might have.
Are there any questions?
Yes, Representative.
Thank you, Mr. Chair. And thank you for taking my question. I just wanted to know whether this has any implications or effects on cryptocurrency specifically. Thank you.
No, except that it's very clear under Article 12 of the Uniform Commercial Code that a digital asset, which terms them controllable electronic records, which would include cryptocurrency, is an asset in which there can be a property interest. And to that extent, like any other asset, a transfer would be subject to this law. But other than that, there's nothing specific that would relate to that, to those assets.
Any other questions? Seeing none, thank you. Glenn Perlow? Oh, yes. Thank you. I didn't want to know how to pronounce that last name, so I appreciate that. Thank you.
My name is Glenn Perlow. I'm a director and general counsel at Jordan Park Trust Company in Portsmouth, New Hampshire. With me today is Heather Perkins Ogmanson, who is our trust counsel. I am not a trust counsel, and so like several other lawyers in the room who are apologizing for what they don't know, I am something more of a generalist, and Heather will absolutely be able to answer more specific questions. I have submitted testimony in opposition, but let me be very clear. I had the good fortune to meet Professor Mooney last week. We have been dialoguing, and Heather and he have had a Zoom meeting, and we're actively trying to see if the goals of 1127 can be met without some of the concerns that you'll see raised in our testimony. And I would like to say that I'm very confident in having dialogued with Professor Mooney that we will commit to trying as hard as we can to dovetail our concerns and this moving forward. And I guess I would just make an ask, depending on the committee's time and the chair's time frame, that we have a sort of week or two to go back and forth, because we have several practitioners on our side.
Yeah. Is it an early bill?
It's not an FA.
Not an early bill. Okay. Any questions? Yeah. Yeah, that makes sense. So some time to get it, it's not an early bill, so some time to get it done right is probably the best course of action. So
we would appreciate that, and we'll make sure that the chair is kept abreast of where we're at.
Yeah. And are there any questions at all?
Could I just raise just a request? It would be very helpful, I think, to the committee if you are able to come to an agreement here to suggested changes. If you could actually give us the language,
absolutely,
in the mark up the bill with the proposed language that you think should be inserted. That would be very helpful.
Yes, and we'll do our best to put it in as close to OLS format as we can do.
We appreciate that. All right, thank you.
Yeah, this when's the regular deadline? Is March? Is it March 5th? Yeah. March 5th. Yeah. So we have to be able to have. Yeah, 2 weeks. Yeah. I mean, if you get this done in 2 weeks, that'd be great.
I have every reason to believe we'll make that.
Excellent. Okay, and with that, I'm going to close the hearing.
Thank you so much.
Unless there's anybody else that wants to speak on this bill that hasn't turned a pink card in. Okay, so I'm going to close the hearing on House Bill 1127, and we have a few minutes here before the next one. I'm going to turn it over to Chairman Lynn. Okay. Do you have a pink card a pink card filled out? Representative,
Did you fill out
you,
a pink card?
yeah, before you
Yeah.
introduce.
Oh, you did, okay. All right.
It was hidden.
I'm going to open the hearing on House Bill 1322, but I'm just, Representative, just to let you know, I'm waiting for people to come back. When they come back, I may suspend the hearing to take up a matter that we're going to exec, another bill, okay, just so you understand.
Roger, sir.
All right. Which is 1130, right, yeah. All right, so I'm opening the hearing on House Bill 1322, and the chair recognizes Representative, I'm sure I'm going to, Saborn Deschanel.
That was great, Chairman Lynn. Thank you, sir. Thank you, everyone, for having me today. State Representative Matt Saborn Deschanel from Rockingham 30. Thank you all for hearing HB 1322. This bill establishes the Judicial Conduct Commission. Before I explain what it does, let me explain why we need it. My constituents contact me about the courts. They have concerns sometimes about how their case was handled, sometimes about things they've read in the news. And they ask a simple question: whom do I call? And I don't have a good answer. The Attorney General has said publicly that his office does not have any oversight authority over the judicial branch. The Committee on Judicial Conduct reports to the court it's meant to oversee. There is no independent body where citizens can bring concerns and know they'll be evaluated by someone outside of the system. This isn't a new problem. In 2001, after a very difficult period for our courts, this legislature passed Senate Bill 197 by a vote of 290 to 36. That bill created an independent judicial conduct commission. 3 years later, the Supreme Court struck it down. But the court was clear about what the legislature can do. The court acknowledged that a commission authorized to investigate and report to the legislature on conduct that may warrant impeachment or removal, that function is not something the court would interfere with. Those are the legislature's constitutional powers under Part 2, Articles 17 and 73. And HB 1322 is drafted to fit within that line. And I would like to credit the Office of Legislative Services for the work on this bill. They took a policy goal, give the legislature an investigative mechanism to support our constitutional responsibilities, and drafted a bill designed to respect the boundaries the court identified in 2004. Here's what the bill does. First, it creates an 11-member commission with a public majority, 6 public members, 3 judges, 2 attorneys appointed by the governor, Senate President, Speaker, Supreme Court, and Bar Association. Second, it gives the commission authority to receive complaints, investigate, hold hearings, and issue subpoenas. Third, and this is critical, the commission can only recommend action to the legislature, it cannot impose discipline. The legislature then decides in its sole discretion whether to pursue impeachment or address. Fourth, the bill explicitly states it does not replace or limit the Supreme Court's inherent authority over judicial discipline. The two systems operate concurrently. Mr. Chairman, this bill is not about any particular case or any particular judge. It's about a structural gap. The legislature has constitutional authority to remove judges, but no formal mechanism to investigate whether that authority should be exercised. HB 1322 fills the gap. I ask the committee for an ought to pass recommendation. And that is my testimony. If the committee wants to get into the technical drafting choices, OLS can speak to those better than I can. I am not a lawyer. Thank you.
All right, thank you very much. Any questions for this witness? Seeing none, thank you very much, sir.
Cool. Thank you, Chairman Lynn.
Next, Representative Wood, please.
Microphone, please.
Yeah, place
I put it on.
Thank you.
I shut it off. Thank you, Mr. Chairman. Unique experience for me testifying in front of this committee. I too have been sent here by constituents. Actually, constituents asked me to vote for this. I looked through the bill a bit. It's a little outside of my pay grade. However, I did notice some things that I thought were interested in the bill. I'm not aware of why the bill, the commission was disbanded. It sounded like there was some legal reason, so I'm not speaking on that at all. But I thought the legislation that was put together didn't expand a lot on the existing law, in my opinion, and basically allowed for a clear control of the complaints. It just seems like there's problems out there. Now, again, I'm sure we're not the only representatives that are getting this brought to our attention, but there's problems out there that the unskilled in the law feel like they really need an avenue to either vent. Part of it is probably venting. At least that's how I get it as a representative. I'm sure you feel that many times with problems out there, or some legal action that they could probably take to better their case or to make it right. So I just would, I will leave my write-up here for you. And I hope that you do consider this bill or do consider some kind of legislation that could be used to help in this regard. Thank you so much.
Thank you. Questions for this witness? Seeing none, thank you very much, sir. Next, Lauren Warner, please.
Good afternoon, all of the members of the committee. My name is Lauren Warner, Deputy General Counsel of the Judicial Branch. As I previously testified earlier today, there currently is in existence the Judicial Conduct Committee. I think I'll keep mentioning this over and over to you all. But that is the current process. I think the sponsor mentioned constituents have come to him unsure of where to go if they have a complaint about the judge. The proper place is the Judicial Conduct Commission, which is will investigate judicial misconduct, which violates judicial code of conduct, as well as then there also is the Attorney Discipline Office under the New Hampshire Bar Association, which would investigate actions outside of the judicial code of conduct but violate the attorney discipline rules. Filing a complaint under this process, individuals may do so submitting a written report, as well as the report must be filed within 2 years of the alleged misconduct. As noted earlier, the legislature still maintains the ability to conduct investigations into judicial misconduct without a commission as it stands currently for actions they feel might violate Article 17 or Article 73 of New Hampshire Constitution for impeachment and removal of office. Noting some aspects of the current bill, the bill as written extends not only to judges but to clerks of court. Currently, clerks are not obligated to, under the Judicial Code of Conduct, that's limited just to judicial officers, not clerks of court. They would fall under the attorney discipline rules. This expansion would also not necessarily qualify a clerk for impeachment under the New Hampshire Constitution. That's limited to judicial officers or other state officials. Clerks of court are not such individuals. So arguably, this bill expanding the impeachment investigation process to clerks of court does not align with the current New Hampshire Constitution. Just noting section 494-A:11, Roman numeral 2, many complaints that come to the JCC currently involve ongoing or current litigation. So there is a prohibition in this bill for the complainant and the judge to communicate during the investigation. This would pose a problem, say, if it's a current ongoing case. How does that case move forward if now the judge cannot communicate with that complainant? It poses a problem and could effectively stall cases for ongoing litigation. And I think there's also could be a fear of could this be used as a tactic in some cases where it is quite adversarial between the parties for one party to file a complaint to stall a case. It's just potential unintended consequences that could occur from this bill. I would also note public hearings. It contemplates for public hearings on complaints that the commission would find potentially valid and warranted in some cases. So say, for example, as I noted earlier, a domestic violence matter or some child protection cases, they are confidential under state and federal law. You would not be able to hold a public hearing on that would involve potentially a domestic violence case or some of those that are protected under state and federal law for confidentiality. I would note the bill provides for the ability for the commission to vote for certain aspects of that hearing to be non-public, but still requires then the commission to issue a report after the hearing is concluded that would note the parties and a summary of the case. Again, that would violate state and federal law in some of these cases that need to be confidential. Just for example, domestic violence cases, we receive federal funding for help on these. If we were to violate that federal statute, that also puts the state at risk for sanctions and withdrawal of federal funds. Just noting too, the complaint would deprive an individual intended to be protected by confidential nature of case type. The commissions would be privy to confidential information regarding some of these highly sensitive cases. I would say say, for example, domestic violence case, a victim might not necessarily want to have their information out there, to have their case reviewed. It's just, there's some aspects of this bill I would recommend be looking further into. Also, this creates that parallel process to the current Judicial Conduct Commission. What happens if the JCC finds differently than this proposed commission? How does that work? I know the bill, if it finds sanctions lesser than impeachment, recommends discipline to the Supreme Court. I would argue that could potentially be a violation of separation of powers. The court case was in 2004 that previously found the old Judicial Conduct Commission under the previous 494 chapter to be unconstitutional. And just noting that the proposed makeup of this Judicial Conduct Commission mirrors that of what is currently in place. An 11-member commission made up of majority of public members is what currently exists right now. I welcome any questions the committee might have.
Questions for this witness?
As well, probably noted while I was out of the room, but this is reviving, the Judicial Conduct Commission was established in, I think, 2001, and then in 2004, it's not meeting because it was found unconstitutional. We didn't get around to deleting it from the law books until last year, or 2 years ago. So, to the best of your knowledge, is this bill simply reestablishing the laws passed in 2001, or are there any differences?
I would have to compare. So I tried to do a search finding the exact language that existed in 2001. Wasn't able to find. It's similar to that, but I can't speak as to the exact language. If it is.
Thanks. Are there any other questions? Seeing none, thank you. So what I'm going to do now is I'm going to recess the hearing on HB 1322 until 2:55, and I'm going to turn to House Bill 1130 to take up executing that bill, and I'm going to recognize myself for a motion to adopt Amendment 2026-0410H to House Bill 1130. And
I second that.
And that's moved by me and seconded by Representative Perez. I'm just going to briefly speak to it. The only change that this amendment makes to the bill is that it provides that the commentary that are contained in questionnaires that are part of a judicial evaluation shall not become part of the public reporting on the performance evaluation. They still get reported to the court, but they are not reported as part of the public evaluation. And I say, as I said during my testimony, a number of the judges, particularly the circuit court judges, have expressed concerns about that, and I think well-taken concerns that people who are, disagree with a judge's decision will file these commentaries and often containing really scandalous kind of allegations that would end up in the public record. And I think there's a valid reason not to have those as part of the public record. And so I hope people will, however they may view the underlying bill, will support the amendment. That's all I have to say. Yes, Representative Birch.
Yeah, just in summary fashion, I don't think that this amendment solves the problem of turning a teaching and improvement process into a potentially political event. And even worse, I mean, when we get our emails from constituents, we can see which ones are coming from individuals talking about their life experiences and which ones have 400 of the same language. And this will have the same problem, is that we'll get a total, public will get a total at the end that 300 people don't like this judge, but we don't know why, and 20 do like the judge, and we don't know why, and there's no way to distinguish. It just becomes who can send the most letters in. And for that reason, I'm planning to vote against the amendment.
Any other comments? All right, so everybody, let me ask you this, can we do the vote on the amendment by a show of hands? Anybody object to that? All right, so all those in favor of amendment 2026-0410H, please raise your hand.
Done.
All right, so we had, all right, let me count again. One. All right, so let me count. So one, please keep your hands up. 1, 2, 3, 4, 6, 7, 8. All right, 8 voting in favor. Of those opposed, please raise your hand. 2, 4, 5, 6, 7, 8. All right, so an 8 to 8 votes. So the amendment fails. So now 8 to 8. All right. So now we are on to back to the bill, and I guess I would move ought to pass on the underlying bill. I'm sorry that we don't have the amendment, but that's I would move ought to pass. Is there a second?
Yes, I'll second that.
All right, moved and seconded. I will recognize you in just a moment, but I guess I would say I should point out the judicial branch, and I've spoken to the Chief Justice about this. The judicial branch, at the level of the Chief Justice, has indicated that they don't really have that he doesn't really have any problem with the basic part of the bill. In fact, he did not express to me any concerns about even the public making the commentary public. Although, as I said, a number of judges did that. So I think that the judicial branch recognizes that there needs to be some upgrading of the evaluation process, and I think that this bill accomplishes that. I would have rather had it with the amendment, but that failed. So I propose to move forward on the ought to pass. Representative Smith.
Thank you very much. I do have a couple of quick comments to make. If we're going to pass this bill, I wonder if we should consider an amendment which gives the judicial branch the power to evaluate each one of the legislators, taking comments from the public and observing us. I mean, we could have the head of the School Boards Association, for example, comment on the conduct of the members of the committee and publish it. I don't think that's a good idea, and I would think you don't think it's a good idea. I believe that the purpose of the judicial performance evaluation is to end up with better judges. And sometimes that means pushing a judge out, but frequently it means educating, training, giving them an understanding of how their colleagues act. I think there's one good thing in this bill. I like the section about evaluation, of observing the judges in court, which I don't think is part of the current judicial whatever it is, judicial performance evaluation. But I think this is a misguided idea. 10 years ago, or 12 years ago, when we did a big change in terms of the judiciary did a big change in terms of judicial performance. It works, and it encourages judges. They know they're going to be evaluated by their peers and by those who come into the courts, and it's used to make better judges, not to turn this into yet another opportunity for attack. And so I'm going to vote against the bill. I hope everybody votes against the bill, and I hope that when we do vote against the bill, we make clear that we expect the judicial branch to constantly work to improve the quality of the judicial performance evaluations.
Anyone else? Yes, Representative Manning.
Thank you. Just quickly in response to my esteemed colleague's first part of her testimony about the judiciary branch and evaluating us. We're elected officials, we're evaluated daily. I go on social media and I see public comments against me all the time. Well, not all the time, I lied. But,
Tell me who, I'm correct.
but come November, they can vote me out of office. So that's my judicial review for elected officials here. Thank you.
Anyone else to be heard? All right, so I think we're ready for a vote, and this will be a roll call on the motion of ought to pass. And ask the clerk to call the roll, please.
Vice Chair Mannion,
Yes.
Rep Tripp,
Yes.
Rep Andrews,
Yes.
clerk votes yes, Rep Perez,
Yes.
Rep Scully,
Yes.
Rep Ball,
Yes.
Rep Birch,
No.
Rep Smith,
No.
Rep Horrigan,
No.
Rep Page, Rep Manos,
No.
Rep Turer,
No.
Rep Rombo,
No.
Rep Bergeron,
No.
Chairman Lynn,
Yes.
8-8.
All right, so it'll go to the floor.
No, we still have to exhaust the motion.
Oh, all right, I'm sorry. So is there any other motion? Is there another
I
motion?
move ITL.
All right,
Second.
I'm sorry, who's up second, Morgan? Okay, hang on. ITL.
Oh, I'm so sorry. I didn't know. I didn't move that. Mark Page moved it.
All right,
You just thought I did.
all right. All right, anybody have any other, anything else they want to say on the motion for ITL? All right, then I ask the clerk to call the roll, please.
Vice Chair Mannion,
No.
Rep Tripp,
No.
Rep Andrews,
No.
clerk votes no, Rep Perez,
No.
Rep Scully,
No.
Rep Ball,
No.
Rep Birch,
Yes.
Rep Smith, Rep Horrigan,
Yes.
Rep Page, Rep Manos,
Yes.
Rep Turer,
Yeah.
Rep Rombo,
Yes.
Rep Bergeron,
No.
Chairman
Oh, wait a
Lynn.
minute, I had a yes here.
I'm sorry, what? Do you want to change your vote?
I do, because I looked at the wrong bill.
Okay, so what do you want to make your vote? Chairman Lynn?
No.
8-8.
All right. So, it'll go without recommendation. I will write the report. What? We could, anybody, we could have another vote. I suspect the outcome would be exactly the same, but anybody want to move interim study? All right, see nobody, all right. All right, so I will write the report in favor of OTP, and who will write? Representative Page will write the report of ITL, is that correct? Yeah, okay, all right. All right. All right. All right. Let's go back. Yeah. All right, so I'm going to close the executive session on House Bill 1130, and I'm going to resume now the the hearing on House Bill 1322, and I would call Dana Albrecht, please.
Good afternoon, Mr. Chair and members of the committee. I support this. If you look at this, the history of this was addressed in one of the emails sent out this morning that you have hard copies of earlier. Essentially, what happened in 2001 with Senate Bill 197, in which RSA 494A was passed in the first place with a vote of 290 to 36 in the House, 22-0 in the Senate, was signed in and became law. So clearly in 2001, it was very popular. The people wanted it. The only thing that happened is the Supreme Court didn't like it, and 3 years struck it down as unconstitutional in a petition of the Judicial Conduct Committee. One moment for the record, 151 NH 123, 2004. Most importantly, the opinion acknowledged what the legislature could still do. To the extent that the commission, I'm quoting from the opinion, to the extent that the commission is authorized to investigate and report to the legislature on conduct by a judge that may warrant impeachment or removal by address, we decline on justiciability grounds to interfere with those functions. So what this basically does, as far as I construe it, is just to take the statute that was there before, fix up the parts the Supreme Court didn't like, take them out, and make this pass constitutional muster. So we're back where we were when the people wanted this 290 to 36. So that's sort of the first piece of it. The second piece of it, to address some arguments I heard earlier, I don't think we can have the fox guarding the hen house. While there may be a report to something called the Judicial Conduct Committee, that's all under the judicial branch. It's all under the Supreme Court. There's no external accountability. Same with the Attorney Discipline Office. Clearly, this was meant to implement something else. Clearly, the people wanted something else. If the judicial branch is allergic to any sort of accountability, that's the sense I'm getting today. I suppose that's their prerogative, but we had something that was clearly very much wanted and very much popular with a little defect, so why not put it back without the defect? With that said, I'll take questions.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Is there anyone else who wishes to testify on HB 1322? All right, seeing none, I'm going to close the hearing. Oh, I'm sorry. Ms. Nixon, please come up.
Good afternoon, members of the committee. My name is Leslie Nixon. I'm an attorney. I live in New Boston. And I've been, at one time, was privileged to be a member of this body for a very short time, and also a member of the last constitutional convention that was held in this state in 1984, in which, as a member of the Judicial Power Committee, we addressed many bills similar to this one and passed none of them. This bill, I basically have two problems with this bill, both as an attorney and as a taxpayer. As a taxpayer, I object to the additional bureaucracy and cost this would impose on our taxpayers to provide for and support another commission, another regulatory body. And as an attorney, I am concerned that it would subject judges to standards not based on ethical or legal terms, but to political concerns and political complaints. An independent judiciary is the very fabric of our, very underpinning of our democracy. It is important that if judges are going to be evaluated and judged, that it be based on solid grounds, on legal grounds, and not because someone is dissatisfied with a particular ruling or dislikes on political grounds a particular ruling. And so for that reason, I oppose it. Again, as a taxpayer and as an attorney.
Questions for this witness? Seeing none, thank you very much, Ms.
Thank
Nixon.
you.
All right, anyone else who wishes to be heard on HB 1322? Seeing none, I'm going to close the hearing on HB 1322, and I am now going to open HB 1322 to an executive session, and the chair recognizes Representative Rombo for a motion.
Thank you, Mr. Chairman. I make a motion of ITL on HB 1322.
Is there a second? All right. Representative Rombo, do you wish to be heard on your motion?
No, I don't need to add much, just that I would echo the testimony and the concerns we heard about maintaining the integrity and the independence of the judiciary. And I think we've heard the testimony today. That's all for me.
All right. Anyone else wish to be heard? So I guess I think I should comment very briefly. I think that, first of all, despite the fact that this bill is somewhat different from the bill that was found unconstitutional, and maybe it's enough of a difference that the Supreme Court would not find this unconstitutional. To me, the main thing is this bill is totally unnecessary. The idea that there's no way in which the legislature can investigate impeachment, whether somebody should be impeached, that's just absolutely not true. I mean, we had impeachment proceedings. The legislature certainly, if there's a basis for impeaching a judge or anyone else, there's certainly procedures for doing that. In fact, and I think this tends to reinforce what the last witness had to say about concerns in this area. In fact, we had, if I recall correctly last time, a bill asking the legislature to move forward with impeachment proceedings against Judge Ruoff, basically because he wrote a decision that in the Conval case that certain people didn't like. And I have to say, I'm one of those people. I thought that Judge Ruoff's decision was incorrect. But the idea, Judge Ruoff is a fine judge, fair, impartial, smart, hardworking. And the fact that I might disagree with him on a particular decision, the idea that that should be the basis for impeaching him is beyond the pale. I mean, it's just completely beyond the pale. So I totally support the idea of ITLing this really unwise bill. Anyone else wish to be heard? Representative Patab.
I just want to say briefly that we did hear testimony regarding the constitutionality of this. We have another CACR before CACR 23 that talks about adding this to the Constitution, and I think for those that are in support of this, that's the right vehicle for it. Thank you.
Anyone else wish to be heard? Yes, Representative Scully.
Thank you, Mr. Chair. I guess I'll just state for the record my personal bias, which is to always have the legislature, which is accountable to the people, have the ability to oversight for a branch of government that is essentially accountable to no one. So I would, in this case, I'm going to vote against the ITL. I do think, for no other reason, that the perception of our public that we do have, we take seriously the idea of having checks and balances on all branches of government is extremely important. And so for that reason, I will be saying no, and I appreciate you hearing me out.
Of course. All right. Anyone else wish to be heard? All right, so I think then we're ready, and I'd ask the clerk to call the roll. The motion is ITL on House Bill 1322.
Vice Chair Mannion,
Yes.
Rep Tripp,
Yes.
Rep Andrews,
Yes.
Clerk votes yes. Rep Perez,
Yes.
Rep Scully,
No.
Rep Ball,
Yes.
Rep Birch,
Yes.
Rep Smith, Rep Horrigan,
Yes.
Rep Page, Rep Manos,
Yes.
Rep Tur,
Yes.
Rep Rombo,
Yes.
Rep Bergeron,
Yes.
Chairman Lynn. 15-1.
When do you need that by? I can be home by 5. I will send it to you directly. Yes, there'll be a minority report. Yes.
House Bill 1825. Whoop, I recognize Representative Saborn Duchesne, please.
Thank you, Chairman Lynn. Thank you all for having me again. I'm excited to introduce this bill this afternoon. I think it's going to be a good conversation. We have a lot of folks that are here to testify on this. I encourage you to listen to everyone. This is HB 1825, what I like to call the Freedom to Practice Law Act, a new initiative for our state. There's a lot of technical drafting in this bill, I want to say, and I'm grateful for OLS for their work on that. But the policy goal of this bill is simple: to treat the legal profession the same way we treat every other licensed profession in New Hampshire that falls under the purview of the legislature. Let me tell you where this bill came from, the inspiration. I watched someone represent themselves pro se in family court. Years of litigation, years of learning the hard way, and I thought, why couldn't the worst years of this person's life become training for a new career, perhaps? Why couldn't real world experience count for something the way it does in our Learn Everywhere program for students? And that's the inspiration. And here's the problem it addresses. According to the American Bar Association, New Hampshire has 2.47 attorneys per 1,000 residents, the lowest in New England. Maine is next at 2.65. This is an access to justice issue. 90% of family court litigants in New Hampshire represent themselves pro se. That's not a system working well. New Hampshire is not alone in looking at reform. Texas and Florida have recently ruled that their state bar associations no longer have final decision-making authority over who can sit for the bar exam. Additionally, California, Washington, Virginia, and our New England neighbor, Vermont, all offer law office study programs, which are apprenticeships where someone works under a licensed attorney or judge for 4 years and then sits for the bar. No law school required. So here's what HB 1825 does. First, it establishes multiple pathways to licensure: traditional law school, apprenticeship, or direct examination with supervised practice while maintaining competency standards. Second, it opens the bar examination to the public. Anyone can take the exam for credentialing purposes, even without seeking licensure. This includes minors. Third, it makes bar association membership voluntary and eliminates mandatory continuing fees beyond initial licensure. And fourth, it creates a legal licensing board with mixed appointments from the governor, the legislature, the Supreme Court, and the public to administer licensure. Fifth, and this is critical, the bill preserves the Supreme Court's constitutional authority over practice before the courts. It includes a constitutional savings clause so that if any portion is found to conflict with judicial authority under Part 2, Article 73A, the remainder continues to function. The bill covers general practice, legal advice, drafting documents, negotiating on behalf of clients, representing clients in administrative proceedings, and encourages judicial deference to legislative licensure standards while respecting the court's role. Mr. Chairman, more pathways to the bar means more lawyers. More lawyers means greater access to justice. Free market principles can make it easier to become a lawyer and easier to afford one. I ask the committee for an out-to-pass recommendation. Thank you.
Questions for this witness? Seeing none, thank you very much, sir. Next, Marissa Chase, please.
Thank you, Mr. Chairman. Thank you, members of the committee. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which represents the plaintiffs' bar. We are here in opposition to this bill. The most obvious issue is it just doesn't really make sense. The bill itself acknowledges that per the New Hampshire Constitution, the New Hampshire Supreme Court, in Part 2, Article 73A, gets to regulate who can practice in front of the courts of the state. The bill would basically create a tiered class system among attorneys, those who are allowed to go to court and those who can't because they passed the state licensing, but not the Supreme Court standards for whatever reason. I'm not sure how that would work in practice. The bill allows for any person, regardless of age and educational background, to sit for the bar exam. So in theory, a 15-year-old could pass, and then we'd be trusting that individual to represent the legal interests of other people. They'd not be old enough to open, say, an IOLTA account. And I'm not sure that we really want people without high school diplomas representing others in legal matters. It seems ripe for abuse and exploitation. The bill creates a competing attorney discipline system, which seems like a logistical nightmare. Would they create their own rules of professional conduct? What happens when they revoke a law license, but the Supreme Court doesn't, or vice versa? It just seems to be that this has a number of issues that would necessitate being thought through a little further.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Daniel Richard, please.
Good afternoon. Thank you for hanging in there. It's been a long day for you. I know it has. My name is Daniel Richard, citizen of New Hampshire, and I want to set up some guideposts for this conversation based on my historical understanding of the evolution of our practice of law in the state. I want to begin with 1873. The state legislature granted the Bar Association its original voluntary status and created a charter for them, again, under a voluntary association. Section 6 of that charter is still in effect today. That charter, that Rule 6 establishes that only the legislature that created the entity, and only the legislature has the ability to alter, abolish, or regulate the bar. This would happen, this would carry into 1968. 1968, the Bar Association at that time would go ahead and petition the state Supreme Court under original jurisdiction to unify the bar. The problem with that is twofold. There are two serious problems with that event. Number one, that they circumvented the charter. I don't know where that they have the authority to suspend under Article 29 of the state constitution. Only the legislature has the ability to suspend the law. So if it created the charter for the bar to operate as a voluntary association, it's clearly bypassed that authority when it made it mandatory in direct violation of Article 83, the Monopoly Clause. In 1903, the state legislature, or I should say, there was a con that produced an amendment adopting the Sherman Antitrust Act, which violates the Monopoly Clause. And that issue is clearly in conflict. So I don't know how the bar can work with the Supreme Court to suspend the existing charter and take away the legislature's oversight. And not only did it do that, it also allowed the practice of corporate law. And so this, in my estimation, completely violates Article 14. Article 14 was there to allow the following, excuse me. Part 1, Article 14 of the Bill of Rights. Every subject of the state is entitled to a certain remedy by having recourse to the laws. or all injuries he may receive in his person, property, or character. And here's the catch: to obtain right and justice freely, without being obliged to purchase it, completely and without any denial, promptly and without any delay, conformably to the laws. So what we have with a mandatory operation is that if you can't afford a lawyer, how do you get help? It's a big problem. Citizens all over the state, you hear this everywhere you go, that if you can't afford one, where are you at? You don't get any justice. So for that reason, I oppose this. I'm sorry, I support it. But what I oppose is the mandatory, and again, if the Constitution requires that there be no monopoly clause, that's exactly what the bar unification did. It violated the monopoly clause.
All right, questions for this witness? Seeing none, thank you very much, sir. Next,
Thank you.
Lauren Warner, please.
Good afternoon, honorable members of the committee. My name is Lauren Warner, Deputy General Counsel for the Judicial Branch. HB 1825 purports to create a new attorney licensure type and regulation process that would run in parallel to, not replace, the current attorney licensure and bar admission process for the state. Just to note, I'm not aware of any state in which admission to practice law is housed outside of, other than the highest court within the state. The judicial branch just would like to highlight a number of potential unintended consequences and some concerns we have with the proposed legislation. As already noted, arguably this can be unconstitutional. The bill defines as one of the definitions for practice of law as representation of one before a court or an admin body. Specifically Article 73A, the Chief Justice of the Supreme Court shall be the administrative head of all courts. He, with the concurrence of the majority of the Supreme Court justices, shall make the rules governing the administration of all courts in the state and the practice and procedure to be followed in such courts. Just noting, the judicial branch has a few significant public protection concerns with this bill. The court instills two important factors as part of their current bar licensure process to ensure public protection, specifically evaluating potential candidates on competency and character and fitness. Competency currently is met by way of two items. So passage of, after attending a law school accredited by the ABA, passage of the uniform bar exam. New Hampshire is one of 43 states which is a partner to this uniform bar exam. It's a rigorous exam. It's a 2-day examination, including multi-state performance test, multi-state essay examinations, and multi-state bar examination. This proposed bill doesn't include such a bar exam. And also the fact that we're part of one of the 41 states, there's portability for anyone who passes the UBE who then would seek to practice law in another state that examines or issues the UBE would be able to do so. The other method the Supreme Court evaluates competency is the Daniel Webster Scholars Program. So there's two ways in which you can become a member of the bar: passing the UBE or being a graduate of the Daniel Webster Scholars Program, which is run by the UNH School of Law. It's a rigorous 2-year bar practicum program where students at UNH Law apply. There's certain academic credentials they need to meet in order to apply. They are interviewed, and then it's a 2-year bar practicum where each student will take additional courses, creating them practice ready from mock trials, pre-trial negotiations. They work with practicing attorneys and are assessed by practicing attorneys on their skills and determine whether at the end they would graduate the program, and upon graduation are admitted to the New Hampshire bar. I would also note to take the UBE, you have to pass the Multi-State Professional Responsibility Examination, so the MPRE. This is usually done for students in law school after they complete the ethics course. So that's another examination in which they have to pass in order to be admitted to the bar. As well as character and fitness, the Board of Bar Examiners under Rule 42 created the Committee for Character and Fitness. This committee will rigorously scrutinize any application for the bar. This includes a background check. They have the ability to interview candidates and will make recommendations to the Supreme Court whether or not a person should be admitted into the bar. So these are just some additional factors to ensure that those that are being admitted to practice law in the state meet certain standards for public protection. I would also note additional costs to the fiscal notes beyond what was provided by the judicial branch. Essentially, this would create a de-unification with the New Hampshire Bar Association, not requiring individuals to be members. Part of this current membership, the New Hampshire Bar Association manages the attorney registration, annual registration process, as well as all the CLEs for attorneys within the state. We have around 5,000 members. If this occurs, that no longer would be happening, so those dues would not be paying for that, and that would be an additional cost that would be required. Just one final note, just based on my reading of the bill, it's unclear where this licensing board would be housed. Would this be under OPLC as a professional licensing board? If that is so, there would be additional costs to whatever executive agency that might be managing this board, as the one-time licensure fee would not be sufficient to run a professional licensing, an attorney licensing program. And just to also note, OPLC, their boards typically are made up the majority of members of the profession that are assessing the credentials of those that are seeking admission into each profession. This bill essentially states there will be no attorneys on the board, determining whether or not someone should be admitted into the practice of law, and is made up with other members, which doesn't align with current licensing boards under the OPLC, which are primarily made up of members of the profession and 1 to 2 public members. I am happy to take any questions the committee might have.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Veronica Tomasco Silva, please.
Hello, thank you. So I am here in my own personal and professional capacity. I am a licensed attorney here in the state of New Hampshire. I practice estates and trusts in Cheshire County. And I have a number of issues with this proposed legislation. First is we have a very well-functioning Board of Governors already within the New Hampshire Bar Association. We elect them as attorneys. We have 6 officers, 11 county governors, so we represent every county. We have 5 governors at large. We have an at-large member for the public sector and an at-large member to manage our out-of-state membership. There's nothing in this proposed legislation that ensures that every county will have equal representation, which is a major issue considering that there are multiple counties in New Hampshire that are routinely underserved. Cheshire County, Carroll County, Sullivan County, and Coos County being all counties that have approximately 100 attorneys or less, with Coos County having approximately 14 attorneys. Subjecting them to additional standards would be overly burdensome to our counties that are already considered legal deserts. Additionally, the New Hampshire legislature has in the New Hampshire Bar has already committed to administering the next gen bar exam for July 2028. This legislation proposes changing the bar exam and allowing the legislature to come up with the rules that we would follow for our bar exam. However, the CLEAR committee, which is made up of chief justices and court office administrators, has already come up with many new ways to modify the existing bar exam. Chief Justice McDonald of New Hampshire is the chair, one of the 2 chairs of this committee. It does not appear that this proposed legislation has looked into that research. It is very extensive and interviewed numerous attorneys and law students from all over the country. And we already have great pathways to becoming a lawyer in New Hampshire. We have the traditional way of taking the bar exam. You can take the bar exam and become licensed and practice in another state for 3 to 5 years and waive in. We have the Daniel Webster Scholar Program, and you can be a foreign attorney with a legal education and become licensed in New Hampshire. Severing the authority over the Supreme Court and the legislature from determining who is not an attorney creates a significant enforcement risk. We already have a severe issue getting current contact information from all of our attorneys licensed in New Hampshire. I know because I'm on the Cheshire County Bar Association, and we only have less than 100 lawyers, and it is difficult for us to get current information from all of them. It would be nearly impossible for us to figure out who is licensed at the state level with the Supreme Court and who is licensed with the legislature. And it would create massive problems for lawyers like me who operate in estate and trust and probate administration. So if I was, for example, a new attorney who was going to be preparing probate or trust administration, am I allowed to draft all of those documents and not appear in court if I'm called? Because most probate cases do not require physical appearance in court. They're usually waivers of administration. So that would be an issue that would also be in question. Additionally, I have not met a lawyer who has a severe issue with the bar, with the New Hampshire Bar Association. Our dues pay for so many more things based solely on the money that we pay. So we have the lawyer referral service, which addresses indigent clients. The lawyers of New Hampshire spend countless hours providing pro bono service through the lawyer assistance program and through the lawyer referral service, through the modest means program. Those are all things that are paid for with our dues, and our board does not receive compensation. I also have a big issue with the proposition that the members of this committee would be paid and compensated for their service when the existing members are on a volunteer elected basis by the existing attorneys in the state of New Hampshire. So thank you for your time.
Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Donald Gilbert, please.
Good afternoon. Thank you, Honorable Chair Lynn and members of this committee. I want to walk you down a path of history briefly of how the hijacking of the New Hampshire Bar turned into the hijacking of our judiciary under 73A. And that's kind of where we're at. So this bill is the vital to our judiciary from being hijacked by the New Hampshire Bar. Historical shift from the mandatory membership created a self-serving monopoly that limits the access to justice. Part 2, 73A of the New Hampshire Constitution has entrenched that control. In the early American Republic, law practice was open to anyone with knowledge and skill who could appear in court without a mandatory bar restriction, entry, honoring the foundations of the vision, access of justice. Our Chief MacDonald has actually spoke about this quite frequently, about how the access to justice is limited in New Hampshire. In 1873, New Hampshire incorporated the first modern bar as a voluntary group. By the 20th century, they were facing significant financial pressures. You actually just heard about that this would create further financial pressures for the bar. There was 88 unpaid memberships and 158 paid memberships at $50 in 1968. To secure the funding from all attorneys, the association pushed for the unification. A 1968 meeting, a vote of 72 to 34 for it, and a referendum among all of the members, 706 members out of the 750 members, passed narrowly, with 231 voting in favor and 188 opposed. There was another, 300 or so that abstained from voting. The recollection of what's indicated is they abstained because they did not agree with what was occurring at all, that there was even a proposition for this vote. Despite opposition and limited turnout, the Supreme Court approved the unification in 1968. Not the legislators who had the authority to do so, the Supreme Court. This was before the 1978 enactment of Article 73A, which would have given them that power to do so. So they were already breaching their duty years prior. This gave the bar monopoly control over licensing, disciplinary action passed to the bench, since all judges are required to be appointed or nominated by the Bar Association. They are vetted by the Bar Association before they're brought forth for nomination. This stranglehold on practice and mandatory admission enabled the bar's influence to extend further into that 1978 vote, which I spoke to earlier, about how they lobbied and the Supreme Court lobbied to have that amendment passed. To the administration head of all courts, with the power to make rules governing administration, practice, and procedure with all the force and effect of law. We heard that earlier today from myself and many other of the constituents you heard. While aimed at modernizing and unifying the court management, like the 1966 amendment and 1971 unification, this amendment adopted in the judiciary now dominated by the bar-licensed, bar-influenced judges centralized the authority to a self-regulating branch. The bar's control over who could become the lawyer created a closed loop and effectively shaped nominations, approvals for judicial roles, reinforcing the dominance without a sufficient public or legislative checks. Again, the checks and balances necessary for our constitutional democracy. HB 1825 breaks that cycle, creating the re-involuntarying the bar admission, no forced dues beyond the licensure, with an independent board of public members for transparent oversight. I do believe that there probably is definitely some amendments that need to occur for this bill, but that is for you to obviously take forth and consider as this moves forward. I would motion for you to ought to pass on this bill.
Thank you, sir. Questions for this witness? Seeing none, thank you.
Thank you.
Next, I'm going to call on Dana Albrecht, please.
Thank you, Mr. Chair and members of the committee. I would echo that for anyone who thinks this is a good idea but needs technical amendments, that's a valid route for just about any bill that comes before this committee or any other committee. That being said, I heard a few things in testimony earlier that were a little concerning to me because I think they're just inaccurate with regard to what the bill says. As far as I can tell, this decouples or attempts to decouple passing the bar is a sort of low-grade credential with actually being licensed to practice and represent someone. So maybe somebody wants to pass it for a college graduate school application. Maybe somebody wants to say they have some knowledge of the law because they want to run for public office. I think that's certainly a valid thing for someone to want to be able to do. That being said, with regard to the current law, and I would respectfully ask any member to interrupt me if I'm wrong on this, it would be my understanding that the governor could nominate, theoretically, a non-attorney to serve as Chief Justice of the Supreme Court, and the Executive Council, upon confirmation, could confirm any such individual with no credentials whatsoever, and nothing prohibits that. In practice, perhaps not so much, but I think that is relevant to what I heard when I heard somebody earlier say, this doesn't require any lawyers. If you look at page 2, line 15, you've got all these members appointed by the Supreme Court, the governor, the speaker, whatever. I would be surprised if they chose to appoint only non-attorneys to those positions. Possible, but and last but not least, I think all else being equal in professions, everything else is regulated by OPLC. I think it's a valid question to ask why attorneys are special. And maybe there's a good answer to that, but I think that's the question a lot of people are asking. Doctors, lawyers, dentists, everybody else, they've got their licensing scheme. Attorneys are separate. And the other thing you see in a lot of those other professions is a lot of sort of tiers of credentials. Dental hygienists, full dome, and we have that less so much in law. And I think this is just meant to open up the playing field a lot, where as long as everybody's honest about what their credentials are, that we have some different credentials out there. And I would point out, as of today, in existing law, that a non-attorney can represent someone in court under RSA 311.1. That already exists. So all this does is expand out, or and maybe intended to do, is to expand out some options where people might be able to better say in an objective way what they are and aren't capable of. And I think that's the intent of this. And if the technical drafting fails, the solution to that is an amendment, and not to throw the idea out altogether.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'll call on Leslie Nixon, please.
Thank you, Mr. Chairman, members of the committee. Again, my name is Leslie Nixon. I am from New Boston. I'm an attorney. I have been practicing for some 40-something years or so. And I speak to you in opposition to this bill. Again, as I stated in my previous remarks, essentially two reasons. As a taxpayer and as an attorney. As a taxpayer, I note in the fiscal note, this is estimated to cost $1 million at least in the next fiscal year by establishing yet another bureaucracy and commission and all the support needed for that. It is also in my capacity as a lawyer, I take very seriously the oath that we are required to take as attorneys. And that is actually reproduced in this bill, but it's in current RSA 311. Every attorney licensed to practice shall take and subscribe the oath to support the Constitution of the state and of the United States and the oath of office in the following form. You solemnly swear or affirm that you will do no falsehood nor conduct that any be done in the court. And if you know of any, that you will give knowledge thereof to the justices of the court, or to some of them, that it may be reformed, that you will not wittingly or willingly promote, give, or procure to be sued any false or unlawful suit, nor consent to that same, that you will delay no person for lucre or malice. Lucre is an anachronistic word for money, and will act in the profession of an attorney according to the best of your learning and discretion and with all good fidelity, as well as to the court or to your client. So help you God, and under the pains and penalties of perjury. That is an oath that every single lawyer and judge practicing in this state takes. And violation of it is subject to severe penalties, including suspension and disbarment. This law, this act, would create a board composed of people who have not taken such an oath, but yet are under this bill as I read it, and it is confusing and conflicting, it seems, but the board has the exclusive authority to grant, deny, renew, suspend, and revoke licensure to practice law in New Hampshire. So it would be non-attorneys who have not taken this oath, who are subject to political influence, who are subject to conflicts of interest, that will be passing judgment on who or who should not be able to practice law in the state. It is rather confusing in the sense that it retains some authority in the Supreme Court, but it appears that there would be people who are not subject to the same code of ethics or the same oath as attorneys and judges are, who would be licensing lawyers. An extreme concern to the independence of the practice of law and to the judiciary. And finally, on the issue of the unification of the bar, that also was the subject of the Constitutional Convention, the last one of which I was a member in 1984. And that was debated extensively, and as a previous speaker has alluded to, the Bar Association serves many purposes beneficial to the public. There are good reasons for having the requirement to be a member of the New Hampshire Bar. In fact, my father, who served in this body for many years, was the author of that, the original provision requiring unification, and the bar has become strong and effective as a result. But there is an opt-out. Currently, RSA 311(7)G says that the Supreme Court may require all persons engaged in the practice of the state to be members of the New Hampshire Bar, except pursuant to paragraph 3. And paragraph 3 says that the Bar Association shall require its members to vote every 5 years as to whether they want to remain a unified bar. And so there is an opt-out for if it came to the point where there was a majority of attorneys in the state who did not want a unified bar and wanted some other system of regulation to do so. So I would urge again that you vote this inexpedient to legislate and take any questions if there are any. Thank you.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to be heard on House Bill 1825? Seeing none, I'm going to close the hearing on I'll close the hearing on House Bill 1825, and I'm going to open an executive session on House Bill 1825, and the chair recognizes Representative Page for a motion.
So I'll move ITL.
Is there a second?
I second.
Second by Representative Andrus. Moved by Representative Page, second by Representative Andrus. Representative Page, do you wish to speak to your motion?
Not particularly. I think I'm all set. Thank you.
All right. Anyone else who wishes to speak to 1825? Well, I guess I do very briefly, and I apologize. But first of all, I think that there is at least a substantial issue as to whether this bill would be unconstitutional. But even if you put that aside, I have to say my basic reaction to this is what exactly is the problem that is trying to be addressed here, and I don't see the problem, and I think the current system of attorney licensing seems to be working well. And I would note here that to the extent that there is a flavor here of trying to expand the availability of legal services in one form or another, I would note that the New Hampshire is actually under the current system is moving down that path. First of all, we have the Daniel Webster Scholars Program, which is designed to get to have lawyers have more practical experience as they become members of the bar. I note that there was recently there's provisions that call for allowing paralegals to appear in court in connection with certain types of cases, and I think that the court would be very open to even further moves in that direction. And so my suggestion is that, you know, those who think that we should be moving in that direction, maybe they should address their comments to the Supreme Court or the Supreme Court Rules Committee. And the last thing is on the integration of the bar. I think, as Attorney Nixon pointed out, there is now a provision that allows for periodic votes by members of the bar. And I have to say candidly, personally, I have kind of gone back and over the many years that I've been a member of the New Hampshire Bar, I've kind of gone back and forth on the issue of whether an integrated bar is a good thing or a bad thing. I would have, you know, if the bar voted to not to deintegrate and to do away with integration, I'm not sure I would be all that upset. Although I think, as Representative, as Ms. Warner pointed out, the integrated bar performs a number of things now that are paid for by the members that I think there's a very good chance would end up being paid for by the taxpayers through the state budget if they had to duplicate the things that the bar does in a non-bar format. So for all those reasons, I wholeheartedly support the ITL motion. And I'm sorry I've talked too long. Anyone else wish to be heard? Yes, Representative Kutab.
Very briefly, I just want to say, you know, this is an early bill. Today's kind of our last day that we're voting on early bills, and I think several testified that this does need an amendment. It has $1 million fiscal note on it, and unfortunately, you know, there's no time to get any amendment out, and in its current form, it's just not ready for prime time. Thank you.
All right. Anyone else wish to be heard? All right. Then we're ready for a roll call vote on this. The motion is ITL on House Bill 1825.
Vice Chair Mannion.
Yes.
Rep Tripp.
Yes.
Rep Andrews.
Yes.
Clerk votes yes. Rep Perez.
Yes.
Rep Scully.
Yes.
Rep Ball.
Yes.
Rep Birch.
Yes.
Rep Smith. Rep Horrigan.
Yes.
Rep Page.
Yes.
Rep Manos.
Yes.
Rep Turer.
Yes.
Rep Rombo.
Yes.
Rep Bergeron.
Yes.
Chairman Lind.
Yes.
16-0.
All right. Any reason it can't go on consent? All right, consent. And Representative Page, I'm going to call on you to write it. Please get it to me by 7 tonight. Thank you. I really appreciate that. All right. Last bill of the day, House Bill. I'm going to close the executive session on House Bill 1825 and open the open the hearing on House Bill 1608, and I would recognize Representative Flanagan, the prime sponsor of the bill. Whoop, whoop.
Thought we were going home.
So what's worse, being the bill right before lunch or the bill at the end of the day? Mr. Chairman, thanks again. To review, Representative Flanagan, Hillsborough 45. Should I stop and wait?
No, go ahead, please. Oh, no, please go. Please go ahead.
Hillsborough 45, which is the towns of Hollis, Brookline, Mason, and Greenville. You've got another bill in front of you that was 2 items into one through OLS because of the timing issue. And when we run out of time to introduce bills in this session. So the first part deals with grand juries. And if I remember correctly, grand juries originally serviced the defendant, but now it serves the prosecution. And a lot of times the prosecution doesn't share the information from the grand jury, which to me seems exculpatory. The defendant should get the information that they're trying to prove. Just by way of example, and I mentioned the getting a little loud in the back. The Judge Marconi and Gino Marconi's case. Gino Marconi had 4 grand juries. And since the defendant didn't know what was included in the grand jury, his wife didn't know what they were looking at.
and she had to recuse herself. Sound familiar? And then what happens is she tried to explain herself, and then that led to her issue. So part of the bill is that I feel that the defendant should have the information that the grand jury is seeing. If it's exculpatory, I don't understand why it isn't included. So that's the first half. The second half is I was approached by, I'm not sure if it was the county attorney or one of his staff.
I'm sorry, go ahead.
Okay, I didn't want to interrupt
No, no,
anything.
that's all right.
Representative Birch is a very important member of this House.
Thank you.
What happened was in Hillsborough County, they limit the indemnification of their attorneys. And it's a very significantly small number. And what happens is, I think a lot of the defense attorneys know this. So when if they lose, what they do is they make the attorney's life miserable and sue them for whatever and I don't know the specifics. Attorney Coughlin's here, he can probably shed some more light on it than I could. But I think that's wrong, because as we all serve our counties, I don't want to lose some of our attorneys. Some of them are really good attorneys and they're hardworking. And if we don't indemnify them, just like we don't indemnify a lot of the other employees, or if we didn't in other areas like in the state or the town, we're going to lose them. And I serve on the labor committee, and we're always doing things that are, hopefully helping the employees and the businesses, in this case, the state and the counties. So that was it. I don't want to lose these people. I don't want to go through a hiring process. I don't want to lose a training process. And if we have good attorneys, I want to keep them. So with that, questions,
Thank you. Questions for this witness?
please. If you don't ask me questions, that means you don't like the bill.
Right, seeing none, thank you very much.
You want to go home? I'll leave it with that.
Next, I'm going to call on Attorney John Coughlin, please. All right.
Good
Sorry.
afternoon.
Attorney Coughlin, please.
Yes, good afternoon, Mr. Chairman. I'm here to address the issue of sovereign immunity indemnification regarding such protections are currently afforded to include assistant attorney generals by statute. I'm here in support of expanding the sovereign immunity to include county attorneys, assistant county attorneys, and municipal prosecutors. My experience as Hillsborough County Attorney, I've been there for 5 years. Prior to that, I was a member of the state court for 15 years, retired to run for Hillsborough County. And fortunately or unfortunately, I got elected back in 2020 and been serving in that capacity. Well, thank you. We're the largest prosecution office in the state of New Hampshire. I would venture to say we're larger than the Attorney General's office, larger than the U.S. Attorney's office. Business is too good. We have a lot of crime. We're the only county that is divided into 2 districts, separate districts. We have the Northern District in Manchester and the Southern District. And I spend my time between each of these offices. Each of these offices has an assistant county attorney, have assistant county attorneys and first assistants running the office. We've had a number of complaints filed against our prosecutors with the Professional Conduct Committee complaint. And then goes to the ADO, Attorney Disciplinary Office. What does it take to get a complaint? It takes very little, a sentence or 2. That's it. And it starts in motion a lot of bad things to the attorneys. The attorneys have to get an attorney to represent them. They have to take time off from work. Currently, each county, basically, my understanding, is on their own with regard to these types of complaints. Hillsborough County, we have Primex, and they allow us $5,000 for attorney's fees. They've increased that recently, but $5,000. I was a practicing attorney for many years. I don't think lawyers could say hello when for $5,000. It's going to cost a lot more, and it has cost a lot more. So what we see is a weaponization of these complaints against the prosecutors. When I was running for county attorney in 2024, my opponent filed a complaint against me. It was literally one line or two lines. And I had to respond. I had to hire an attorney. And I hired a good attorney. I hired Rick Lehman. But they're not cheap. You get what you pay for. So currently in Hillsborough County, each of the attorneys is on their own regarding finding an attorney, and then if it's over that amount, having to make arrangements to pay for the attorney. I know there's been some discussion regarding that we're not state employees, but let's look at this. We are state employees. We represent the state of New Hampshire. When we present indictments to a grand jury, we're not there as in the capacity as Hillsborough County. We're there, the state of New Hampshire versus John Doe, not Hillsborough County. The Attorney General has to approve of all my nominations, if you will, for assistant county attorneys. They have direct supervision over all the assistant county attorneys, including the county attorneys and municipal prosecutors. The AG's office often provides guidelines that we must follow, and they have the authority to take over our office by both case law and statute. And they've done that. They did that before I was there. We, as assistant county attorneys or county attorneys, are sometimes considered designees of the Attorney General's office. In cases like where we have, there's an issue of competence, and after there's been an evaluation, the person is found to be not competent, not restorable, but are they dangerous? In that procedure, we have to seek permission as a designee from the Attorney General's office to go forward, representing, I believe, the Attorney General's office. So this would be more, think of it as fair play. If the assistant attorney generals can be represented by counsel provided by the state, why can't the county attorneys who are there in place of the Attorney General? No, we are, and we consider ourselves an arm of the Attorney General, because again, we are representing the state of New Hampshire. Our retirement system, for example, we don't fall into county employee, even though we're county employees. We pay into the state system, and we receive a state retirement when we're eligible. So for all intents and purposes, we are state employees. I think it's important to have a simplified process by which all 10 counties are not clamoring to find protection and legal counsel for their assistant county attorneys. And I think this bill would provide that. Thank you.
Questions for this witness? Yes, Representative Perez.
Thank you. Thanks for taking my questions. Why do you think, twofold, do you feel that you have more complaints in your area, and if so, why?
Well, I think it's a weaponization. It's a way to put our prosecutors on the defensive. I like aggressive prosecutors. The only thing I ask my prosecutors is to be respectful, and professional. That's the only two. And we are professional. We require that. If someone on the other side wants to attack us, that's an easy way to attack us. Simply file the complaint. There's no recourse for them. They file the complaint. They're protected. It's only us having to respond to it.
And then on my other half, do you feel that your area has more complaints than?
Well, because we're in the trenches. There are a lot of bad people doing bad things to people out there. And Manchester and Nashua are the epicenter of that. We have a whole unit dedicated to a special victims unit against children, where people sexually abuse children. They're absolutely horrible cases. They're horrible. They're very complex, very complicated. And I would rather make sure that my lawyers are protected, and that if a complaint like this is filed, that they know that somebody has their back on this. because they have very important work that we do, and we take it seriously.
Representative Tripp.
Thank you, Mr. Chair, and thank you for taking my question. Do you have any comments on the first part of the bill?
No, no.
Other,
So,
oh, yeah,
Follow-up?
follow-up? Sure, of course.
do you believe that the benefits of the second part of the bill over compensate for the weakness of the first part?
Well, I think you bifurcate it. Are we talking about the grand jury?
Yes.
Yes. Well, I have a lot of respect for Jack Flanagan. I've known Jack for many years, but I really haven't studied that. So I came here on the issue of the immunity indemnification, not on the grand jury. If I had a chance to study, I probably would have an opinion.
All right. Well, thank you very much.
Other questions? Any other questions? All right, seeing none, thank you very much.
Thank you,
Next,
Mr.
I'm gonna
Chairman.
thank you. I'm going to call on Carl Olson, please.
Good afternoon. My name's Carl Olson. I reside in Manchester, and I also work for John Coughlin. I'm an assistant Hillsborough County attorney. I've been working for him for about almost 5 years now. I've been a member of the New Hampshire Bar since 1990, mostly as a defense attorney. What I will say, I'll comment on both the issues. So the first issue, the issue, the second part of the bill, which is the indemnification. I actually was unaware until John called me earlier today and said, hey, there's this bill up there. And I was unaware that there was no indemnification, unlike in contrast to what happened to the Attorney General's office, or that they're covered. And I think the valid point here is that we represent the state of New Hampshire, and it's not the county of Hillsborough against an individual person, it's the state of New Hampshire. And we represent them in the superior courts, which is really where the rubber meets the road. At least, you can argue that the district courts, more humanity goes through there, but the really serious cases, they all go to the superior court. And that's where the real rubber, where the jury trials happen, where people can get sentenced to life in prison or many years or go to prison or whatever. And we're in there, and that's what we do. And so the Attorney General handles a small number of cases. They handle some homicides. But there's a lot of cases that county attorneys have to get permission from the attorney generals, and I'm not saying they don't grant it, but for example, like attempted murder, there's certain homicide or there's certain drug offenses based upon either sales, the amounts or prior record, or death resulting. There's certain AFSA sections where when the penalty is a potential life or a term to life sentence under the statute, requires attorney general's permission. Do they come in and prosecute those? No, very, very rarely. We handle those cases. And the issue here is, I guess to some extent, weaponization. I mean, I've been fortunate. I've never had a complaint filed even since I've been there as a prosecutor. But I also know that other people in my office have had that. And so it just feels like if the state feels it's necessary to protect their prosecutors who handle a very small number of cases, albeit very serious cases, homicides, they should extend that to the prosecutors who are doing the vast bulk of the work in this state. We do the cases in the district court or in the superior court, we obtain the convictions, and then the state takes it over, the attorney general takes it over and does the appeals and defends those convictions that we obtain before the Supreme Court. The other matter, just briefly, which regards the grand jury, that's a bad idea for a couple of different reasons. First off, very rarely does there actually have live witness testimony in the grand jury. In the sense, they have witnesses, but they're not necessarily the witnesses to what actually is happening or what happened. There is a mechanism in the statutes, in the grand jury statutes, for witnesses to be brought in and for those testimony to be recorded and transcribed. But that requires permission from the Superior Court judge. I think the Attorney General's office do that more frequently. And it's very rare, I think, with county attorneys to do that. And usually it might involve something where there's concerns about, well, it could be an investigative grand jury, or it could be situations where there's concern about, health of a witness or something like that. And those can be recorded, and my understanding is they would normally be transcribed. But people are talking about, well, exculpatory. So first off, what would normally happen in a grand jury wouldn't be a situation that even if it was transcribed, it would be necessarily admissible in court. But the other thing is that there's already strong rules, both within the court rules, statutory rules, and constitutional rules that require prosecutors to turn over exculpatory evidence or evidence that might be exculpatory or that might lead to impeachment or other things of corollary. So it's pretty broad. New Hampshire has, to the most extent, what's called open file discovery. So people are not hiding the ball. They're certainly not, because if they do hide the ball, then it would be legitimate. If you're hiding exculpatory evidence, then you probably should be in front of the Professional Conduct Committee. But that's not an issue. Grand jury, you don't record them now. You can't record the hearings without permission from the court. It's very special circumstances. And there's really, again, there's no reason. I don't think there's any reason to do that. And it would be a tremendous expense. And it would also slow down things tremendously too. So that's my position. So I would support the second part of the bill, but I think the grand jury thing is just, it's not a necessary thing.
Questions for this witness? Representative Birch.
Thank you, Mr. Chair. Thank you for your testimony. This bill says that a criminal defendant would be entitled to everything. It had to do with this case, had his name on the top or her name on the top. They get everything. Are there things that come up in a grand jury that perhaps involve vulnerable witnesses and the like, which potentially are not covered by Brady or Giglio or things like that? And would this bill force the disclosure of that kind of information to a defendant?
No, I don't think so. Because first off, most of those times, like a victim of, they very, very rarely would be brought before the grand jury. Again, you have to understand what the grand jury is. It's not a trial. It's to present evidence in a secret proceeding for people to decide whether there's sufficient evidence there to warrant having somebody be formally charged and then have to face the consequences of going through the whole process. But yeah, if I'm aware of certain evidence that would be potentially lead to exculpatory evidence, either under Brady or Giglio or a variety of other Davis v. Alaska type situations, I have an affirmative duty not only to turn that over, I have an affirmative duty to inquire of the police department or officers or investigators whether they might have to have that information. And in fact, information that might be held by a government agency may in fact be imputed to me. So I need to make those inquiries otherwise, because it might come out later, oh, well, you should have asked them because they had some information there. So the grand jury is not, these aren't trials going on. These are just, this is the information that we have. We think there's enough here to have somebody be formally charged. And then once they get to that stage, they have an enormous amount of procedural, constitutional, case law protections and requirements to protect their right to have a fair trial.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Is there anyone else who wishes to testify on House Bill 1608? Yes, please. Got to give me a card, okay? It's all right. Thank you. Sure, come on up. Just please, both of you identify yourself, please. Please, have a seat.
Thank you. Mr. Chairman, my name is Susan Grandis, and I'm the mother of Elena Bendavid, nice to meet you all. Thank you so much for your time today.
And I've come to speak in favor of the second part of this bill. I'm a resident of Concord, Massachusetts, not New Hampshire, and I've come up today because I am hoping that this body will recognize what even those attorneys working in the county offices are unaware of, which is that they are serving the public, they are protecting the population of New Hampshire against criminals, and they are uninsured beyond $5,000. That is not even a retainer for many good attorneys. And unfortunately, that has come to my attention, and I'm here today because I will tell you that people who choose to go into the public service, and my daughter is one of them, and she works with John Coughlin in the Hillsborough County office and chose to come and work there in order to serve the public and to protect them. If you have laws which you're responsible for passing, and those laws are broken, your first line of defense is the police. They have insurance, they are indemnified, they have help if they are sued. But those attorneys that are seeking to enforce those laws, to bring those people who are charged with crimes to trial, and it's a very, as I'm sure any of you who've ever watched Law and Order or any of those other shows know, it's a very difficult job. It is not glamorous. It is not well paid. It exposes them to danger. I can't tell you how many times I've been afraid for my daughter's safety in the course of her doing this work to protect the public in New Hampshire, and to find out that an attorney who represented a criminal defendant who was charged with arson did not succeed after trial, and the case was lost. The judge in that case did not find fit to bring charges against my daughter or to reprimand her, but that attorney filed a complaint with the ADO, and 3 years later, that case is still ongoing. The attorney for the ADO has said that that the complaint would not result in a suspension, but I can tell you that it has been torture for my daughter, for her husband, new husband, for our family, and to try and have someone who has given so much. She was a Daniel Webster Scholar. She came and chose to work in New Hampshire because she loves it, and she loves the people and the teachers that she met while at the University of New Hampshire Law School, and she respects the people with whom she's working. You heard Attorney Coughlin. This has been a torment that won't end, and no matter how much money is spent by the family to try and bring it to a finish, because that's the only objective, it doesn't end. It hasn't ended. And what I would ask is that in the future, when county attorneys like my daughter are charged with a violation of whether it's the law or whether it's a violation of your ethical rules, that they have some help. I mean, for the most part, they are young. For the most part, they are vulnerable in more ways than one. Both the criminals and the attorneys that are defending the criminals have a lot more leeway with the courts. The courts are very strict with prosecutors. All the prosecutors, I don't know them countywide, I don't know all 10 counties, but I would expect that they're all meeting very serious standards beyond those imposed by the bar, by their offices, and they're seeking to enforce the law, and there is no one has their back when they themselves are attacked while they're in the process of defending the citizens of New Hampshire and the victims of crime. And so I would ask that this, I don't think it was intentional on the part of the legislature originally, but to overlook the county attorneys who are not as well paid. I don't even think they have water in their offices at the present, but they are working hard to protect the citizens of New Hampshire, including the members of this commission. And I'd ask that you consider them worthy of being indemnified the same way that assistant attorney generals are in New Hampshire. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Thank you.
Thank you
Is
for
there
the
anyone else
opportunity.
who wishes to be heard on House Bill 1608? Seeing none? Seeing none, I'm going to close the hearing on House Bill 1608. So I'm going to open an executive session on House Bill 1608, and the chair recognizes Representative Kutab for a motion.
I move interim study.
Is there a second?
I second it.
Whoop. All right.
Oh.
All right. Moved by Representative Kutab, seconded by Representative Scully. Representative Kutab, you may speak to this if you'd like, or I would be happy to.
Briefly, I'll just say I do think that the first part of the bill really does have some merit. Unfortunately, we're not in a budget year. I think regarding the second portion, there is already an indemnification law in the books. I do realize that it does say may indemnify, not shall. I think that there's another bill that fixes that, HB 1064. Thank you.
Anyone else wish to be heard? So I would say I actually think that that I agree with Representative Olson, and I think on both scores. First of all, I think if we were to establish on the issue of making recording proceedings of the grand jury, if we were to establish that as the law of this state, which is the law in the federal courts, that's everything in the federal courts is there's always a court reporter in the grand jury. But if we were to start that, I think it would be very expensive, and this is not a budget year. And in addition to that, would turn New Hampshire, which largely now, not completely, but largely is not a grand jury practice kind of state where there's all kinds of motions and this and that, because there's no record. If you turned it into one where there was a record, you would start to have that kind of thing. I'm not sure that that would be a good idea. On the second part, it seems to me, again, I completely support the idea that we ought to have indemnification for the reasons that a number of witnesses have said, but this is not a budget year, and that, again, it seems to me would be very costly. And so for those reasons, I support the interim study. I hope that people would bring this back next year in a budget year. I think the outcome might be much different, at least on the second part. So with that, anybody else wish to be heard? All right, so the motion is interim study, and I would ask the clerk to call the roll, please.
Vice Chair Mannion.
Yes.
Rep Tripp.
Yes.
Clerk votes yes. Rep Perez.
Yes.
Rep Scully.
Yes.
Rep Ball.
Yes.
Rep Birch.
Yes.
Rep Smith. Rep Oregon.
Yes.
Rep Page. Rep Manos.
Yes.
Rep Turer.
Yes.
Rep Rombo.
Yes.
Rep Bergeron.
Yes.
Chairman Lynn.
Yes.
Motion passes 15-0.
All right. Any objection to it being on consent? All right, it can be on consent. And Representative Kutab, could I ask you to file the report?
Sure.
All right.
We do still have another bill we have to do if we're not meeting tomorrow.
No, we can do that on Monday, right? We can do that on Monday.
Yeah.
We can do that on Monday. Yeah. Wow. I'm
You
sorry.
guys want to
Oh.
do 1064?
No, well, you know what? We could, I mean, 16:30. Okay. So
It's an ugly amendment.
You guys
We
want to
need
do
to talk about it.
1064?
no, let's think about that. Let's think about that. I mean, I'm still a supporter. Don't get me wrong, but I think So. All right, so. I think we are done, and I want to thank, first of all, the members of the public for hanging in there, but more importantly, the members of this committee for hanging in there. It's been a full day, and I appreciate everybody. Yes, Representative.
Yeah, let's do it.
Well, now, so we've already, since the notice has already gone out, I mean, no, yeah, I don't think,
Yeah,
but-
we can, people can come in early if they want to talk.
yeah, no, so you know what, I mean, you know what I would suggest, I think, we can't start the hearings early, but what I would suggest is on Monday, and I hope maybe both sides of this, come in early so that we can caucus on the things that we're gonna deal with on Monday. All right, so again.
What
yeah.
time served on Monday?
Well, the hearings start at 10, but I would ask if everybody could, at least on the Republican side, if you could get here by 9, that would be great if you could do that. So we can talk for a little bit. So we got through, so we had 6 early bills that we had to exec. We did 1, 2, 3, 4, 5, right? 1608 we did, yes. So we did 5. I think that's pretty good. We have 1639, that's the grand jury thing. So anyway, so we got 5 done. I think that's pretty good. All right. Again, thank you, everyone. And so just remember, for next week is a 3-day week. We have hearings on Monday and Wednesday, and we're going to have an exec session on Friday for, for a whole bunch of bills. So it'll be a full day on Friday too.
And house session on Thursday.
And we have house session on Thursday.
And
So next, pack your bag, bring your toothbrush.
And next Friday is Friday the 13th.
We're gonna I just gave it to Sarah, that's why I had to leave a couple minutes, I gave it to Sarah, so it's a whole bunch of bills.
If we're gonna be here Friday, must be here Friday.
Yeah, I mean, I hate this rule, I tried to get Paul to, I basically said to, why?
And then a work session for something else, and then you can exec anything you want.
Are you still writing that
That's why
minority
other
report so that we can't put that on consent and get it out of the way? We're not, you want to debate.
All right,
Okay.
are we
Oh,
done?
this is your report, okay.
Say no.
Do you want to turn off, are we done? Do you wanna
Oh,
turn
yeah.
off?
We're done.